This case, we have all parties and counsel present, and the jury has indicated they're all here and ready to go. And so is there any reason we can't resume with the plaintiff's evidence on behalf of the plaintiff?
Oh, sir, we're ready.
Anything to take up on behalf of the defendants?
No, sir.
All right, then Deputy Scott, if we could bring in the jury. And Mr. Collins, if you could go ahead and if you have your next witness available, go ahead and have him step on up.
The defense was going to continue with their client.
I thought we were stopping with that. We'd kind of decided there was
I
no.
was going to just discuss the immediate points from Mr. Collins.
Okay.
Where did
I think the question was, when is defendant going to take the stand for their case in chief?
Right. I think we defaulted back to the default, which is they'll have their opportunity to present evidence and call him separately. As I recall, you'd finished your cross. There was no redirect, and then he stepped down. So it'd be time for the plaintiff's next witness.
Right. Again, my understanding
Okay.
was I was just there to cover.
Right.
the
So
purposes of
we're going
trial.
back to the traditional
Yeah.
format just because of
Okay.
the timing of how it worked. So you've got your next witness to call.
Yes, sir. We're going to call Dinesh Ray to the witness
So
stand.
Mr. Ray, go ahead and step on up here, and we'll have you formally call him in again when the jury gets in.
Go to the witness stand, yeah. I believe the notebook's still up there. You got the exhibits ready?
This is.
Played it off of.
Oh, yeah.
Yeah.
You can have a seat. Come in. Well, maybe not so much. We're good.
Awesome. Mr. Very shit.
Yep.
Because he's going to rise that.
All this was.
Duke.
Precision. Precision.
President, time for you.
Thank you, Deputy Scott. Please be seated, everyone. Welcome back, members of the jury. Thank you for being back here. As I understand it, today's obstacle was not traffic, but elevators. But thank you for braving that and being back here ready to go. And so we're now at this time ready for the plaintiff to begin resuming their case in chief. Mr. Collins, you may call your next witness.
Thank you, Judge. Plaintiff calls Dinesh Ray.
Go ahead. You swear according to the testimony about the case, you please say nothing but the truth to help you.
Yes.
Take a seat. Speaking clearly to the mic, would you state your name, just swear your name to the record?
My name is Dinesh M. Thulungarai.
Mr. Ray, please tell us where you reside. Where do you reside?
I did not get you. Do you mind to?
Where do you reside? Where do you live?
Oh, I live in North Druid Hills Road, Atlanta, Georgia.
Okay. How long have you lived there?
Since 11 years running.
Okay. Are you currently married?
I'm single.
Where are you originally from?
I'm originally born and raised in Nepal. It's called South Asian country.
Okay. When did you move to America?
In 2014, April 22.
Did you come to Atlanta at that time?
Yes, sir.
So you've lived in Atlanta the whole time you've been here?
Yes, sir.
Okay. What did you do when you first came to Atlanta?
I work in gas store, C-store, and joined community college.
Okay. And what is your current occupation?
Right now, to be honest, I'm working in convenience store and I'm part-time Uber driver too.
Okay. And so let's talk about your experience in convenience stores. When did you first start working in a convenience store?
In 2014, like May or June, something like that.
Okay. Where was this convenience store?
In Stone Mountain,
And what kind of a convenience store was it?
that's the gas stations.
So it's a gas station and convenience store?
Yes, sir.
Okay. And how long did you work there?
Almost 7 months.
Okay. And what jobs did you have at that convenience store?
Like storekeeper.
Okay. And did you work shifts?
Yes.
What did you do after, what was your next convenience store job?
After I moved to one warehouse that's called Southeast Wholesale. It's in 85 Highway in North.
Okay. And then what did you do after that?
After that, I work in liquor shop. I worked there almost 3 years.
Okay. And so what was your role at the liquor store?
I was operating as like a store manager or everything because everything was on me that time.
What'd you do next?
Next, after that, to be honest, he fired me because of there was Indian owner and who like play a lot of with me with my emotion. And when he hand over that business, it was like 40,000 around sales. But after 3 years, he gave me word. When I make like more than 100, he will give me like 5% and increase my salary. But after 3 years, when I hit my target, he said no. Then I
Okay.
said thank you.
So you dramatically increased the sales of that store, didn't you?
Yes, sir.
Okay. So tell us about the next job that you had.
Then after I went to 720, is BP gas stations in Midtown right here, 720 Danulia. And I worked there almost like around 2 to 3 years.
2 to 3 years?
Yes, sir.
What'd you do at that store?
A storekeeper, like a gas stations, store. Yeah.
Did you work shifts?
Yes, sir.
Were you the manager?
No, I was just employee.
Okay. So what were your duties at that store?
Just like managing and selling, doing like a customer, like salesperson as like.
Okay. What'd you do after that job?
After that, over there, I meet one of my friends who is from the back Nepal, and he offered me, let's go join together, do the business. And he offered me. Then I talked to my owner and I moved. But he was like that time, that 720 Danuli owner was offering like good salary or percentage, but I did not accept because I already get something like bad experience in my life.
So you stayed at 720? Is that what you're saying? Or did you take the?
No, I just leave the 720 and I start to Bell's Food Mart.
Okay. So it's the Bell's, the partnership that you were just talking about. Was that for Bell's?
Yeah,
But
it
tell
was.
the jury what Bell's Food Mart was.
Bell's Food Mart has it's a one like convenience store. There was no gas, and me and my brother, like same country from Nepal, we like in partnership we start to operate that gas stations. And whatever my brother, I'm not like experienced, but I follow him, and I was a legally ownership of that store business, and I was operating.
So you were operating the Bell store?
Yes, sir.
Tell the jury where the Bell store was located in relation to the Chevron.
Okay, it's right across the street of Chevron right now.
Okay. And tell the jury who your partner was, if anyone, in Bell's.
My partner was S. Rai, it's called Sabin Rai, and like Bisal Rai, and one was Akash Rai.
Okay. So you had two partners?
Yeah, 3 partner.
3 partners.
Yes.
Okay. 3 partners total, right?
Yeah.
So what were the roles of your partners?
We work together, like we divide shift and we work together. There's no any boss or something like that.
So each one of those partners had a role in operating the business?
Yes.
And what was your role in operating that business?
Just like as an employee, I just go whatever I make order and check everything, store pricing. That's all.
Did you get a share of the profits?
From over there, I did not, to be honest.
Okay. And why is that?
What happened, to be honest, that store was under the Circle K contract. And that store had been already owed like 6-month rent with the previous partner, like contractor, owner. And that owner would take over that business. And my team promised at the first, he will pay up whatever like owed in installment, and we would run that business. But unfortunately, we did not complete our promise, like fulfill our promises.
Why is that?
Because I depend on my brothers and their friends, and whenever they like took their share and walk away from the business, that time it was too late. And I tried to convince Circle K manager, I tried to keep in touch, I had the lawyer, I request multiple times, but they say no time.
So is this problem related to just the money that was owed prior to you taking over the business?
Yes, sir.
And so there were substantial debts to Circle K.
Yes, sir.
And tell us about your conversations with Circle K after, when you took over.
Okay, we had that promises, whatever, we are gonna to pay in
Objection,
installment.
Judge, hearsay, Circle K conversations.
Right. I'm also, you can approach if you need to. You need to hear how this ties into the contracted issue.
It's cheap. It's like $80 a year.
So, Mr. Ray,
Yes, sir.
you were talking to Circle K, and it was your understanding that there was debts involved that they would not restructure for you, right?
Yes, sir.
So tell us when you met Mr. Khan.
Okay. When I was operating this store, Your Honor, one day I did not do. He's the real owner of Nick Cross Street. He walked in my store, and he checked everything, and he checked the product price, and he that day, and we like discussed a little bit. I was behind the counter, and asked him. He told me, "My name is Khan. I'm manager of Chevron," and we exchanged our numbers. And that time he offered me, "You are running business. Let's run both business." And he offered me that Chevron at that time, but I did not say anything because still my my what's called the contract and like running issue I had, but that time I did not say anything. Just we keep in touch after that incident, after that date.
So Mr. Khan walked into your store?
Yes, sir.
And did he know you beforehand?
I didn't. We didn't. He didn't.
And you did not know him,
I
right?
didn't.
And so when we talk about the man who walked into your store, is that person in the courtroom today?
Yes, sir.
Would you please identify that person?
Mr. Khan.
Right, who is sitting here at the council table? Just identify. You don't have to get up.
Oh, sorry, right there.
Okay, thank you, sir. At the time you talked to Mr. Khan, when he came into your store, did you know what Circle K's position was on the past due balance?
Me?
Yes.
Yeah, I know. I like almost like 16 months we owe Circle K because it was already 6 months when we take over that business, and Circle K put some conditions. Some like boards and some like there was some messed up, and we already got the ticket from DeKalb County. And Circle K told us that first of all fix that, then he will give like transport lease contract on Bell's name.
Okay, so the transfer of the lease contract was the most important issue.
Yes, sir.
Did you tell Mr. Khan about that problem with the lease contract?
I did not.
Okay, so tell us how the conversation with Mr. Khan progressed. What happened next after that? first
Okay,
meeting?
when he offered me first time, we meet inside that my store, Bell's Food Mart, and after that, like sometime with pricing, like markets, what's going on, sales why up and below, like these types, and we are exchanging our experience, and we from where he got like a grocery, like delivery, who like deliver the like grocery stops, some like that in time to time.
Did he want to sell you the Chevron store?
Yeah, at that time he offered me.
Okay, or did he want to buy the Bell store?
No, he offered me that to buy the like Chevron Food Mart and now.
So his proposal to you was to buy the Chevron. And did you at any point in time talk to him about before the Bells closed? Did you at any time talk to him about the problems Bells was having with Circle K?
No, I did not. I did not tell to Mr. Khan because that was my problem.
Right.
He offered me from next door, cross the street, to buy the business. And I was clear there, if this contract is not going to continue, if Circle K will not continue my contract, lease contract, let's think. Then I did not say anything.
So did Mr. Khan at any point in time say he wanted to buy the Bell store?
No. He offered me to buy Chevron to Belly store.
And so did you at any point tell him that you thought you were not going to be able to continue operating the Bell store?
I did not.
Okay, so tell us about the end of the Bell store.
Okay, and after that, like Circle K offered me just return the key and walk outside, go outside, and he did not like charges, no day, anything. He wipe out whatever balance there was, high standard balance, and I told it's okay. If you want that way, let's go to court, make a legal paper. You do not have a right to come back later on me, whatever. So we came court together, and in a court we make legal paper, both sides, and Circle K say okay within, and court offer me how many months do you need to like go away from the like that place store. I told okay, I asked 1 month. After 1 month, I return the key and I close the store.
So at that point, you closed the Bell store.
Yes, sir.
Was Mr. Khan involved at any point in this whole process?
No, he did not.
Okay, so tell us what happened after the Bell store closed.
After that, he offered me again. I talked to him. Okay, my store is closed in Cross Street. I'm okay. If you want to sell it, I'm gonna to buy. And I talked to my community brothers. They still live over here. They are doing same like business. And I told to them, I convinced them, okay, my store is closed over here. Here is a business potential I have seen over here, little bit risky and, like a rough type, like daytime shooting, little bit rough, but we have a good customer too. And I convinced them, and we try to buy that's N Nahar, like 100% share.
Okay, so tell us, who did you talk to about buying from their side? Who did you talk to about buying in Nahar? Was it just Mr. Khan?
Just Mr. Khan, sir.
Did you talk to anyone else over there?
No, sir.
Okay. Did your brother talk to Mr. Khan? Did your brother talk to Mr.
Yeah,
Khan?
he talked.
Okay, so this is all about buying 100%.
Yes, you're
Tell us what the proposal was from Mr. Khan.
okay. That time we went to almost our price, everything we were almost like close. And I talked to my brothers and we went to attorney office also. And whenever my brother heard like condition, liabilities, we had an interest to buy that's N Nahar without liabilities. Bills, I offer. Bills is gonna to take over this business, but whatever liabilities you had in previous years or days, that goes to N Nahar. That should not come into bills. But at that time, Mr. Khan, he said, no, I just grab my cash and I go, whatever I left, everything goes to, will be responsible, Bell's Food Mart, which was like trying to take over the business. So my brother said, this is a yellow flag. Let's step back. And he denies. Then
What happened? So at that point.
after that, what happened? Mr. Khan called me separately and he called me in one place. Still, I know that place in that parking lot. And he offered me come over here and I went because till that day we had a good relation like a businessman, one another, each other. And I went over there and he offered me, okay, look, you reject my 100% and liabilities, nothing is over there. He said to me, and just take 50% by yourself, me, okay? He offered me take 50% right now. After 1 year, everything will be sorted out, then take over 100%. He did not have any problem. He offered me like that. And at that time, to be honest, I did not have enough money also in my account. And that's why I called the brother to like, let's run the business. When he offered me, and I think twice, okay, if he is himself here, if something happened of M. Nahar, he would be responsible. So I accept that offer.
So how long after the first offer did you have the second conversation?
Second conversation, exactly, I don't know the like time frame, but like we happened like after like 2 weeks or something like 10 days.
So you had kept in touch with Mr. Khan, even though
Absolutely.
you weren't willing to buy 100%, you liked the idea of buying 50%.
Yes, sir.
Okay. So tell us what happened next.
Next, then after that, everything is done. Okay, he accept and everything we ready and he offered me, okay, whatever he said. And whenever we went to, like we did store closing, at that time he told me, okay, now I take 51%, not 49, because contract and lease on my name.
So he said he wanted to change the deal from
Deal
50
to 51% now.
to
And
49.
he offered me 49%.
Okay. So during this process, prior to the actual signing of the contracts, tell the jury what you did in terms of due diligence about the store.
I do not get you, Your Honor.
Tell us what documents you looked at.
Okay, to be honest, I just looked the COAM contract. That's
What
all.
contract?
COAM contract is a GAM machine contract
Okay.
and gas contract and just like lease contract. That's all.
Okay. So you looked at the lease contract, the coin operated amusement machine contract or
Yes, sir.
COAM.
Yes.
And you said the gas contract
Yes, sir.
and the lease contract.
Yes, sir.
Okay. Did you discuss those documents with Mr. Khan?
Yeah, I discussed a little bit.
Okay. Did you have questions for Mr. Khan?
Oh, I did not have that lease contract I saw that type of lease contract is everywhere, even like almost like,
So
yeah,
given your experience, you've seen contracts like that before.
yeah, yes, sir.
In fact, had you operated a convenience store that had gas pumps?
Yes, sir.
Even though Bell's didn't, you had operated that before.
Yeah, yes, sir.
And had you operated a convenience store that had coin machines?
Oh, did not, to be honest, sir.
So that was new for you?
That was new for me. Oh, sorry, Your Honor. My bad. That's like Bell's used to had a COAM machine. To be
Oh,
honest.
okay. Did you discuss the financial performance of the business with Mr. Khan?
I did not get you,
Did
Your
you
Honor.
discuss the revenue generated by the store prior to you purchasing 49%?
We just talk like that. That's it. We did not go in detail, you know,
Did you see any tax returns for the business?
no, sir.
Did you see any profit and loss statements?
No, sir.
Did you see the bank account for the business?
No, sir.
Did you ask to see any of this financial information?
I try, but he say, okay, no worry, everything is on me because he was already over there. He owned 51%, and whatever happened, he will be first man, and I will be second man. That way, I like accept whatever he said.
So in fact, because of that 51.49%, how did you view the decision-making process between you and Mr. Khan?
Okay, to be honest, that's I would like to say disclose about that. This is like right or no. Game machine was operating that time, doing good, and sales was good. And I figured out myself if I work hard, give the like goods was customer service, definitely sale will be up. That's why I decide to take over, like accept his.
And to your knowledge, what is the impact of the COAM machines on the performance of any convenience store?
That's huge difference, Your Honor.
What do you mean?
That's the huge difference, Your Honor.
Okay, how so?
Okay, I do not say everyone like a game machine, but most of the game machine, they do the like, pay the cash, to be honest. I don't know how do they adjust and settle. Even I did not know that before. They do the cash. And that's way they will settle and they like cover their loss and profit. I'm clear.
Did the presence of having the COAM machines impact the other sales of the convenience store?
Absolutely, 10 to 15%. Sir.
And how did that happen?
Okay, when game machines customer comes to play, they buy, they stock over just 5 to 6 hours. They need food, drinks, you know. If they big win, they buy like a grocery randomly, whatever, unnecessary things, whatever they like.
Did you talk to Mr. Khan about the performance of the game machine part of the business prior to contracting?
We saw the contract and we discussed about that. I'm clear.
Okay. So, but you understood how the COAM machine business worked. So did you need to ask him questions?
No, sir.
Okay. Tell us about the lease that you saw. Was there any red flags?
Oh, we did not see any red flag on lease contract.
And you didn't see any red flags for the COAM contract?
No, sir.
Okay. And did Mr. Khan give you any other documents other than those leases?
No, no, sir.
Okay. So let's talk about the purchase price. If you would go to Exhibit 9. Oops. So Exhibit 9, if you would, you could look at it in the notebook or look at it on the computer screen. Exhibit 9 has already been tendered and entered into evidence. Exhibit 9 is on page 46. There it is. Can you? A little bit hard to see. There we go. So, Mr. Khan testified that that he had created this document.
Yes.
Have you ever seen this before?
No, just like that day I saw it.
So, but this shows inventory and other items that were part of the purchase, right?
Yes, Your Honor.
At least that's what he testified to. Tell us about
I'm sorry, what was that last comment about what he testified to?
what Mr. Khan testified. Mr. Khan testified to these numbers, correct?
Yes, Your Honor.
In general, that he testified as to these numbers?
That's what I think he's confirmed.
Okay.
That we've
All
talked
right.
about these numbers before. All right, we can continue, Council.
And so this is what he says that you paid. Is that right?
Yes, Your Honor.
Objection, to be clear, the testimony yesterday
All right, well,
was.
I'll just say this. You shouldn't be commenting on other witnesses' testimony, so the jury will recall the evidence that Mr. Khan testified to, and so we'll go to the next question.
Thank you. how was the purchase price determined between you and Mr. Khan?
Okay, he told me my business market value is 400K. Okay, goodwill. And that's why he told me, I told, okay, if like 400K, it's okay. I accept that. He randomly gave me, but I took it.
Did he explain to you how he came up with that $400,000?
Never, sir, Your Honor.
Okay, but you accepted it.
Yes, Your Honor.
So if the total was 400,000, how much were you going to pay?
Like 49% of 400,000, Your Honor.
There we go. And did Mr. Khan explain the numbers to you as far as the other purchase price numbers?
Yes, Your Honor.
Okay. Did you talk about the inventory?
Yes, Your Honor.
So at the time you signed the contract, did you do, like February 11, 2022, did you do an inventory?
That day we did, Your Honor.
Okay. On that February 11th,
Yes, Your Honor.
who was hired to do the inventory?
Inventory guy, Your Honor.
And you did the hiring?
Yeah, we did I called the inventory guy. He told me that he did not know any inventory guy. That store was never did inventory before. But in my experience where I used to work, that previous owner had 265 store in only Atlanta. And he had a personal inventory guy. And I had his contact number. And I know him before a couple of times. And I called him.
Okay. Let's go to exhibit there. So the inventory there on February 11th, 2022 was something everyone agreed to, right?
Yes, Your Honor.
Okay. And so there's no dispute or debate from your
No, Your
side
Honor.
about that initial inventory,
No, Your Honor.
okay? So let's talk about the contracts. We talked about the negotiation of the purchase price. Tell the jury about any other terms that you and Mr. Khan talked about.
No, Your Honor.
Okay. Now, Mr. Khan testified that you went to see the lawyer together
Same
to discuss the terms. Tell the jury,
Well,
is that true?
No, Your Honor.
Ruled.
That's wrong.
So you went to this lawyer how many times?
No, that I meet him first time in his office.
So this is not the same lawyer you went to when you were talking about buying 100% of Chevron?
No, Your Honor.
So had you ever met or worked with this lawyer before?
No, Your Honor.
Okay. Did Mr. Khan tell you he was going to go see a lawyer?
That time, Your Honor, he did not told me that, but he gave me address and he told me come over there. And when I went over there, he was already over there, Your
So
Honor.
did you get a chance to see the lawyer that first time?
To be honest, yeah,
On the first day?
first day, yeah.
Okay. What happened at that meeting?
Okay, I went his office in sitting room and he came with the contract and he gave me in front of, okay, just look at and ready guys, both, you brief him what was the condition, everything. Yes, and we signed it.
So that was the only time that you met that
Yeah,
lawyer?
yes, Your Honor.
Prior to that meeting, had you ever seen the contracts?
No, Your Honor.
Had you discussed the terms of those contracts with Mr. Khan?
I did not get a chance to, Your Honor.
Okay. So take the jury through this process again. You walked in the door at the lawyer's office.
Yes, Your Honor.
What happened next?
Okay, I went to door and I got 10 to 12 minutes time and paper was over there. I read not thoroughly, surfacely, and I sign it. And right there, after that, that's contract paper. He took it from both sides. Lawyer gave us 2 cup paper, contract paper, but he took it. Why he took it, I don't want to verify here. I want to tell you, share cause also. One check was 2 days delay. I missed 165. In my account, I did not have 10,000 less. And I told him to check it, take your date time and one check will be delay. You got to wait 2 or 3 days because I'm managing the money. That's why he told, okay, he took both contract and I said, okay, If you want to take both contract, I did not have objection. And that's why he took the both contract paper.
Did you, did you ever get a copy of the contracts that you
Not
signed?
yet, Your Honor,
Pardon me?
not yet.
And you only got the contracts that we're looking at here through discovery?
Yes, Your Honor.
So you sat down in the lawyer's office, got the contracts for the first time, and I believe you testified. How long did it take before they came and said, it's time to sign? How long before you signed?
I did not get you, Your Honor.
How long were you in the lawyer's office before you were signing?
Like 10 minutes.
Okay. Who told you that you needed to sign?
A lawyer, Your Honor.
Okay. And at any point, did they say you should get a lawyer?
Yes, Your Honor.
Did he say that?
No, no, he did not say it, Your
Okay.
Honor.
In fact, did anyone tell you should get a lawyer? Did anyone tell you to get a lawyer?
I understand, Your Honor. No, nobody told me that to get.
Did Mr. Khan put pressure on you to sign these contracts?
He did not, Your Honor.
Did the attorney put pressure on you to sign these contracts?
He did not, Your Honor.
Okay, so why did you sign so quickly?
Okay, I signed it quickly because I trust him. He was 49%. He told me like before that, he told me, okay, we are going to like contract, sign, you have to pay, sign the paper, just like that. And he showed me that previous contract also. And just like that. And I told her, it's okay. Because my intention was I'm gonna to buy like a whole 100% later. Like he just like right now, just no, that's why I signed it.
So you had seen the previous contract. You said the 100% purchase contract?
Oh, I did not see, but that's a lease contract I have seen in my like Bell's Food also.
Okay.
Yeah.
Why did you not hire an attorney to go through these contracts?
Okay, if I bought the whole like a company, that time I will definitely hire it. But I'm gonna to get the like 49% share of his company. He already operating the like company and his store. Then I did not like in my mind. And he also told me that convinced like he convinced me. And I told it's okay. If you are right, you are here, something happened, you are here. That's way I thought, I decide I have to sign whatever he said.
When did you start work at the Chevron?
Okay, I take over like February, like 10, 11, and next day I start to work over there.
So you started work right after signing the contracts?
Yes, Your Honor.
Okay. So let's look at Exhibit 1. That is the purchase agreement. You make that a little bit. So this shows the total purchase price of $263,107. Is that correct, what you agreed to?
Yes, Your Honor.
Okay, it shows the earnest money of $50,000. Did you pay the $50,000 earnest money?
I a little bit got confused over here, Your Honor. That's earnest money he never talked before. That's 50,000. When I went to sign in lawyer room, attorney room, I saw this 50,000. And I crossed the questions him. I'm buying 49% of your business. I did not understand how come like 50,000 like earnest money. I did not understand in that topics. And I questioned same time in front of that's lawyer, you know. He told me that this is one process. It's like a protocol. Just no worry, just sign it. I never seen this kind of like a contract, earnest money before in previous my contract too. And he said, whatever he said, I say so. He says so.
Who said, don't worry, just sign?
Mr. Khan.
Okay. And so when did you pay that $50,000 earnest money?
Like I paid before, like almost like 2 months ago.
2 months prior to signing?
Mhm.
Okay. And how many checks did you send to cover that $50,000?
I think 3 check, 4 check I sent him. 3 check, yeah, 50.
That's for then for the $150,000, it says cash at closing. Tell the jury what that money was for.
With the cash at closing, I did not get you on.
The cash at closing, it shows on Exhibit 1 on that settlement statement. Did you pay the $150,000?
Oh, yeah. Yes, Honor, Your Honor.
Okay, and how many checks did you
I
write?
write him 3 check.
Okay. In fact, all your payments to Mr. Khan were via check, weren't they?
Yes, Your Honor.
Did you ever pay Mr. Khan via cash
No,
or wire
Yes, no.
transfer or anything else?
no, you-
So all payments were checks. And so this right here shows $200,000 total.
yes, Your Honor.
Did you pay $200,000 total to Mr. Khan?
In my mind, that time, I did not, because of 63,000 was inventory.
Right?
And according to our contract, I have to pay like in monthly base, you know. That's why I did not pay 263, Your Honor.
Right. So the 63,000 showing here as a promissory note, you did not pay that at closing.
Not,
Okay. And is that in fact your signature there on page 1?
yes, Your Honor.
Okay, if you go to page 2, this is the purchase and sell agreement. If you look there on the third paragraph, the third whereas paragraph, it talks about AMA Investment, Inc. Did Mr. Khan explain to you who AMA Investment, Inc. was?
No, Your Honor.
And then the next paragraph, it talks about AGM Ventures, Inc. as the COAM operator. Did you discuss them with Mr. Khan?
He discussed to me, Your Honor.
Okay, so you had a full understanding of the COAM system.
Yes, Your Honor.
And then if you go to page 4, this right here has that same outline we were talking about earlier about the price, how the price was determined.
Okay, Your Honor, in my mind, that's 30,000. That's the deposit money for gas company, any gas store. Some company landlord do. Some store like company like running C store, convenience store do. In my mind, that's the like gas deposit.
Okay, so you had no problems with that $30,000?
No, Your Honor.
Okay, and then the 104,911.76, tell the jury again, that's the inventory. Who did?
That's inventory I did.
Okay.
And
And
I
then-
don't
so
have any.
that's, so there's no dispute about that either, right?
no, Your
And then
Honor.
the $400,000 goodwill.
No, Your Honor.
All right, so that's what we discussed as well. So you were agreed to pay, you were buying 49% of those numbers.
Yes, Your Honor.
So you were not paying the whole 534,000. You're paying half of that.
Yes, Your Honor.
Okay. Now, the next paragraph that has a star and is underlined talks about acceptance of checks, that you were paying by check. And so it says that the seller has the right to withhold all closing documents because you're paying by check.
Yes, sir.
Did you understand that that meant they were not going to give you a copy of the documents?
I did not understand, Your Honor.
Okay. Did anyone explain to you that what this meant?
Objection, that's not what it says.
All right.
It
Uh,
says that if
Okay,
the
we
check's
don't need a speaking
bounced-
objection. Don't need a speaking objection. Allow you to follow up on cross. The jury will make any decisions on what the contract does or does not say.
Thank you,
All
Judge.
right, you can continue.
So did anyone explain what this meant to you?
No, Mr.
Did
Your
Mr.
Honor.
Khan explain it to you?
No, Your
Did
Honor.
did the attorney explain it to you?
No, Your Honor.
Did anyone explain to you why you were not getting a copy of the closing documents?
No, Your Honor.
Okay. So let's go to page 8. There we go. It says here in F subsection I, commencing from the date hereof and through January 30th, 2024, the management period, buyer shall serve as the operator of the business. What did this section mean to you?
It means in my mind, in my knowledge, it means like operator, as the operator of business, means
Who is going to run the business?
me.
Okay. Were you going to be hiring employees for the store?
To be honest, Your Honor, I did not.
Okay. Who did the hiring of employees?
Mr. Khan's, Your Honor.
Okay. Did you order supplies for the store?
Yes, Your Honor.
Did you manage the gas sales for the store?
Yes, Your Honor.
Okay. And this says a management period basically for 2 years, right?
Yes, Your Honor.
At this time, when you started work, were you going to be working a shift?
Yes, Your Honor.
What shift were you going to work? to
I
start?
was like morning shift. I was working morning shift.
And is that typical for the store manager and operator to work morning shift?
Yes, Your Honor.
Why is that?
Because of like morning time, there is a couple of like cash flow, bank deposit, and like pull out the order, and sometimes vendor deals.
Okay.
That's what.
And if you look at the next section, it says during the management period, as same may be extended by mutual agreement, buyer shall pay to seller $5,000 monthly as guaranteed profits of the company. Did anyone explain that paragraph to you?
Yes, Your Honor.
Who explained it to you?
Mr. Khan, Your Honor.
And this was prior to signature or after signature?
Prior to signature, Your Honor.
What was your understanding about your job under this paragraph?
Okay, in my understanding, I run the store solely, means everything, hiring, like ordering, and every month I have to pay 5,000 as a profit. That's all, Your Honor.
Did you expect the business to generate $5,000 as a profit?
Not that time, but I had a hope because my store was already closed, and definitely business will be up.
Based on your experience running the Bell store, did you believe that this store, the Chevron, could generate that $5,000 a month?
If COAM machine is operating that condition, it works.
Okay.
It makes 5,000 profit.
And then it says here also, the parties shall then share the profits and losses arising thereafter based on each party's percentage ownership of the company. What was your understanding about sharing of profits and losses?
Okay, to be honest, even I did not see this like point. Might be Mr. Khan also haven't seen because of his like testimony when I saw his testimony. And it's my condition, whatever profit and loss comes from the like business, it goes like both party.
So so when you say goes to both parties, how would it be divided?
Like 49% on me, 51% to Mr. Khan.
Okay. Now, Mr. Khan testified that you were supposed to keep all the profit. Was that your understanding?
Yes, Your Honor.
Okay. And then you understood that this also gave Mr. Khan the right to shorten the management contract if there was a default, right?
Yes,
So did
Your
you
Honor.
understand that?
Yes, Your Honor.
Okay. Were you there when Mr. Khan signed this contract?
Which contract, Your Honor?
This exhibit 1. Were you
Yeah.
both in the same room?
Yes, Your Honor.
Okay. So he was present for all the signing of all the contracts.
Yes, Your Honor.
And you were present to see him sign all of these contracts,
Yes,
right?
Your Honor.
Okay. So let's go to exhibit 3, that's on page 12. So this is the promissory note. And this was also signed on February 11th, 2022, right?
Yes, Your Honor.
Okay. Can you tell the jury what the dollar amount of this promissory note is?
63,107.
And that is the last part of the payment for the 49%, right?
Yes, Your Honor.
Okay. If you look at that first paragraph, how many months was this payment supposed to take?
5 months, Your Honor.
No, the first paragraph says the note shall be repaid.
Not shall be repaid in 12 conservative monthly.
12 months, right?
12 months, yes, Your Honor.
Right. And does it show the dollar amount in that same paragraph that you were going to pay?
Yes, Your Honor.
What is that dollar amount?
Of $5,344.77.
So this meant that you had required payments of $10,344.77 per month, right?
Yes, Your Honor.
Did you believe the store could generate that enough revenue to cover those $10,000 payments to Mr. Khan?
Not like a whole amount, definitely 6 to 7,000. I hoped I would manage that. And
Okay.
rest, I have to borrow the money from family and friends. That's,
But this is all predicated on
yes, Your
the
Honor.
COAM machines, right?
Yes, Your Honor.
The COAM machines being in operation?
Yes, Your Honor.
Let's go to page 19. This is part of Exhibit 5. This section 4 says distributions, et cetera. The first sentence says, unless and until an event of default occurs hereunder, pledgeors shall be entitled to receive and retain any cash distributions declared and paid on the collateral. Did you receive any cash distributions? Did you get any cash payments, like profit payments for the company?
No, Your Honor.
Were any cash distributions declared?
No, Your Honor.
Did you have the power and authority to declare a cash distribution?
No, Your Honor.
Why is that?
Because I was like a work as a store, like a keeper. I did not have a, like access to like bank account, even like check, the checkbook I did not get in a time. I have to text to him multiply time to bring the check. Vendor is waiting. If I call him over, he did not receive my call in time. If I call him like over and over, in return I used to get like disrespect, and he used to scold. I do not want that kind of. He can disrespect me, but not my family. That kind of like attitude and response, I don't like. I
Who
didn't like.
had the authority to decide whether or not to issue a cash dividend or disbursement?
Turn it
I don't know, sir. That's
all the way up.
Who had the right to make decisions about the company?
okay. 49% me, and according to paper, he already said I go whatever like paper said, but according to him, like paper, 49 my side and 51 him. That's clear here.
So your understanding was what when it came to making major decisions?
No, I
You
didn't.
could you do that?
No, I did not do that.
And so Mr. Khan had the right to make major decisions.
Yes, Your Honor.
Okay. So let's look at the next page, page 20. Section 7, it says remedies upon event of default. If an event of default shall have occurred and pledgeor fails to cure same within the time provided in the note, if any pledge may, upon giving 10 days prior notice to the pledgeor, apply any cash distributions received by it to, set forth in section 8 below, and if following such application, there shall remain any portion of the note still remaining, sell the remaining collateral. So was there ever were you ever notified of an event of default?
He did not, Your Honor.
Did you ever receive any written notice from Mr. Khan saying that there was an event of default?
He never, Your Honor.
Okay. And to your knowledge, there was never any notice that you would be terminated for the management contract?
No, Your Honor.
So let's go to Exhibit 6, which is the operating agreement. Did Mr. Khan explain to you what the operating agreement was?
He did not, Your Honor.
Did the attorney explain to you what the operating agreement?
He did not, but he gave a copy, Your Honor.
Do you know what an operating agreement is?
Yes, Your Honor.
Tell the jury what your understanding of this document was.
Which one, Your Honor? Section 1.1? What?
Operating agreement.
Okay.
This document here.
This operation agreement of Nahar Investment LLC of Georgia, limited liability company, effective as of this 11th day of February 2022 by, between and among the undersigned,
Okay.
confirms our,
I don't really need you to read it. We just need to understand that the
My
owners
bad.
of the company are who?
me, Your Honor,
And,
Mr. Khan.
okay. So this is the operating agreement between the two of you.
Yes, Your Honor.
Let's go to page 29. Article 7, distribution of cash. So this paragraph says the company shall distribute to the members from time to time all cash, regardless of the source thereof, of the company which is not required for the operation and reasonable working capital requirements of the company. Did you ever get a distribution of cash from the company?
No, Your Honor.
Did Mr. Khan ever authorize a distribution of cash from the company?
Not, Your Honor.
Okay. The next section says the net profits and net losses of the company and each item of income, gain, loss, deduction, or credit entering into the computation thereof shall be allocated to the members in the same proportion that they share in distributions of the cash flow pursuant to section 7.1. Were you ever allocated any net profits or losses of the company?
Never, Your Honor.
Did you ever get any kind of tax documents that would show that you had shared in a profit or loss? Of the
Never, Your Honor.
Okay. Did you discuss with Mr. Khan getting cash distributions?
Never, Your Honor.
Did you ask him for money?
Oh, like I did not, to be honest, Your Honor.
And did you know what the cash flow was of the company? Did you get to see bank statements that showed what the cash?
Never, Your Honor.
Did you see any profit and loss statements of the company?
Never, Your Honor.
Tell the jury what happened when you would ask Mr. Khan about the bank account.
Okay, whenever I have to purchases and I have to tax him, drop the check, and he used to bring check. At the beginning, he bring couple of slip, 3 slips comes one, like 3 to 4 check comes one page. He used to bring couple of pages. After that, he used to give me like a screenshot of bank statement. You have this much money and you spend that one. That's it. And I used to write. Later, he stopped that too. After a couple of months, he bring the check and with his sign and fixed amount, like you have a right to purchase 5,000. And in that check already written, who is going to purchase, like Star Wholesale, Hackney Company, or Coca-Cola, and 5,000. And I just passed that check, whatever. That's way I work.
So Mr. Khan did not set you up to sign checks to vendors.
At the beginning, he did, to be honest. But after like a couple of months, he did not.
And so he wrote every check to the vendors?
Yes, Your Honor.
Okay. Did he ever take you to the bank to get your signature added to the account?
Okay, here is one interesting incident, Your Honor. When I took over, when I started to run the business, I already had my Bell's Food Mart account in Metro City Bank. And he asked me, where do you want to open the bank account? And I told him, I already had in Metro City. I have a good relation with Metro City Bank also. And I prefer my way. And next day, he went to bank. He was already inside the bank manager room, and he texted me, come over here that time. I went over there. And he did not say anything, just I signed it. I thought afterwards, my name was included in account and I'm like ownership of that. But after couple of like 2 weeks later, I got the call from my like Metro City employee who still I have a good relation. She said to me, I did not have like rights because I was just like co-signer or what's called in bank language. I don't know. Even he did not add my name. And that time I sucked. Why he did that? I don't know.
Were you given the right to online access for the? Metro
Never,
City
ever.
account?
Never, Your Honor.
Okay. Were you given the right to sign checks on the Metro City bank account?
Yeah, gave me, and he bring like a 6 or 7 page he brought in the store. I signed over in that check, to be honest, Your Honor.
Did you have did you have a debit card?
Me?
Yes.
Yeah, I have, Your Honor.
And what'd you use that debit card for?
Debit card for cash or like,
No, for the Metro City bank account.
oh, no, I did not have debit card of Metro City,
Okay.
Your Honor.
So all that you got out of that Metro City bank account is the right to sign checks?
Yes, Your Honor.
Okay.
I would like to add one incident, Your Honor, if I'm allowed.
Yes, please, go ahead.
What happened, one day he went to bank and he like kick out from the bank that is co-signer also. And that day I got the call from Metro City staff. She called me and told, okay, you are just co-signer, Mr. Khan, kick you out from here. You do not have a rights now. Then I shocked.
What did you see? You
Sorry.
saw that,
No, she told me that on phone.
okay,
And she called me, you do not have any rights?
Hearsay,
Hold on.
Judge.
yes.
All right.
We'll
Are you
withdraw.
moving on? All right.
Yes,
Chair will
let's move on.
disregard that last statement.
So let's go to page 42 of this page 42 of Exhibit 6. This is a Schedule C to the operating agreement. And this provides the membership interest required to call a meeting. What is that percentage?
50%.
And so therefore, did you have the right to call a meeting?
According to paper, I have, but I never did, Your Honor.
But did you have 50%?
No, Your Honor.
Okay. And let's look at page 41, the page right before that. It says the following decisions of the company may require the following consent of the membership. What is the percentage required for all decisions?
50%, Your Honor.
Could you make any decisions?
I did not, Your Honor.
And did you have 50%?
I had 49%, Your Honor.
Right. So all decisions required 50%. So only one person could make all decisions.
First time I saw, Your Honor.
Okay. So let's go to Exhibit 7. This is the amortization sheet. Page 43. Did you see this document when you were with the closing attorney?
Yes, Your Honor.
So you understood that for the promissory note, you were going to pay this dollar amount?
Yes, Your Honor.
Okay. And did the closing attorney explain what this document was?
Yes, Your Honor.
And did he explain the calculations?
Oh, yeah, he did, Your
How
Honor.
about Mr. Khan? Did Mr. Khan review this information?
He did, Your Honor.
So coming out of closing, you understood that there was that $10,300 due every month to Mr. Khan?
Yes, Your Honor.
Okay. Let's go to Exhibit 8. This document's also has been entered into evidence as it was provided by Mr. Khan. These are the 3 checks. Let's start with the first check. 1376 is at the top. What is the dollar amount of this check?
45,000, Your Honor.
And whose signature is that?
It's my signature, Your Honor.
Right? And tell us what account the check was written on?
Okay, Mohammed Khan.
To Mr. Khan, right?
Yeah, 45,000, buying 49 share of Nahar Investment LLC.
So this is part of that cash due at closing?
Yes, Your Honor.
Okay, tell us about the second check.
Paid to Mohammed Khan,
Okay,
02/18/2022, 50,000. Buying 49 share of Nahar Investment LLC.
okay. And then the third one is check number 1374.
Pay to Mohammed Khan, 02 to 11/2022, 55,000, buying 49 share of Nahar Investment LLC.
Okay. And the total of these three checks is 150,000, is that right?
Yes, Your Honor.
Okay. And so those checks cover the $150,000 that was required for cash at closing.
Yes, Your Honor.
Okay. I know it's already admitted into evidence, but are these three checks true and accurate copies of the checks that you gave to Mr. Khan?
Yes, Your Honor.
Okay. So the time that you sat down and did the closing, did you sign all the contract documents that Mr. Khan asked you to sign?
Yes, Your Honor.
Did you sign all the contract documents that the closing attorney asked you to sign?
Yes, Your Honor.
Did you refuse to sign any documents?
No, Your Honor.
So is there any reason at all why Mr. Khan would not give you your 49%?
I do not see any reason, Your Honor.
Okay. Did Mr. Khan ever tell you who TSTT was?
Oh, he did not, Your Honor. When I was like about to write the check, at that time told me that write down in that company name. Even I did not ask.
He told you. to
Just
write-
write, he told me just the name.
Okay. In fact, did you give Mr. Khan every check,
Yes, Your Honor.
regardless of who you wrote the check to?
Yes, Your Honor.
Okay. Let's go to exhibit 14. Hold on just a second. If you would find that in your notebook. Your Honor, may I approach? Go to tab 14.
Mm,
Can you identify this document, please?
I'm not sure. This is my handwritten like a number. Whatever Mr. Khan told me that he gave me number just randomly, and I say okay, but I haven't verified this like number. How did like where did it bring? I don't know. But to be honest,
Is this a true and accurate copy of a document that you created, that you wrote?
yeah, yes, Your Honor.
Your Honor would like to tender exhibit 14 into evidence.
No objection.
14 is admitted.
Okay, please pull up number 14 onto the screen. So this says gas money from July 26, 2022. Do you know what this means?
I know this means what do you mean?
Okay, tell the jury what this means.
That means gas, whatever I sell, like I sell in my like operating time. That's gas amount, like money, according to gas like invoice.
Do you have any idea where these numbers came from?
Oh, he gave me all the like invoices, how many like month I run the store. He collect all invoices and gave me like provide me. That's all.
Who paid the gas invoices?
Himself.
Okay. Did you have any responsibility for paying the gas invoices?
No, Your Honor.
So did you get the gas invoices or did they go to Mr. Khan?
No, he gave me like a copy and that's amount, that's gas come, that amount. That's it.
Okay. Did these gas bills come to the store location?
Yes. Oh, no, Your Honor. That goes to his email ID.
Okay. And so prior to this July date, looking at these numbers, had you seen the gas bills?
Which one, Your Honor? I
No,
didn't.
like it talks about the total amount paid for gas. Had you seen those invoices prior to this date?
Yes, I did, Your Honor.
Okay. How often would you get the gas invoice?
Like every 2 weeks, Your Honor.
Okay. So he would show them to you at that point?
Yes, Your Honor.
How would you get a copy?
Through the like screenshot, Your Honor.
Okay. So would he send that via text or email?
Tax.
Okay. So like the bank account, he would send you a text of this as well.
Yes, Your Honor.
What did you understand this to mean in terms of your store operations?
I did not get you, Your Honor.
So when you look at this, what was the goal of creating this piece of paper?
That means he was trying to like make me lost somewhere else, to be honest.
What do you mean?
That means if I could not like do all the whole through, I cannot catch all the process. So if he give the big number, he can like, can do levy like up and down. That's the clear message, Your Honor.
Let's go to Exhibit 21. Don't pull it up on the screen yet. Would you please go to tab 21 of the notebook?
Yes, Your Honor.
If you would, take a look at the documents that compose this tab 21, Exhibit 21. Are these true and accurate copies of checks from your bank account?
Yes, Your Honor.
Your Honor would like to tender Exhibit 21 into evidence?
No objection.
Admitted.
Okay, if you would please pull that up on the screen. So on page 66, there we go. Can you zoom in a little bit? That's sort of hard to see. There we go. So you see this check here to the right. Says it's highlighted. Who did the highlighting on this check?
I did, Your Honor.
Okay. And this says check 1372, right?
Yes, Your Honor.
Can you tell the jury what this check dollar amount is, who it was payable to?
Mohammed Khan, 25,000, buying Chevron, 1131 North Harrison Road, 04/01/2022.
Is this is this one of the earnest money checks?
Yes, Your Honor.
Okay, let's scroll down and look at the next check. Keep scrolling. There we go. Check number 1371. Can you tell the jury about 1371?
Mohammed Khan, to 25,000, buying Chevron, 1131 North Harrison Road.
So this is also a check
Yes, Your
for
Honor.
the earnest money.
Yes, Your Honor.
And who did the highlighting on this check?
Myself, Your Honor.
Okay, so these two checks that we've looked at so far are the earnest money checks.
Yes, Your Honor.
Okay. And what did you do with those checks?
I did not get you, Your Honor.
Who did you give these checks to?
Me or
Who did you give them to?
I gave to Mr. Khan, Your Honor.
Okay. So let's go to page 68. That's 2 pages later. Tell us about check 1373.
Okay. TST Development Company, 85,000. Buying share of N Nahar, 1131 North Harrison Road, Stone Mountain.
Okay. And who told you to make this check payable to TSTT?
Mr. Khan, Your Honor.
What did you do with that check after you wrote it?
I
Give
didn't.
it to.
I give to in front of Mr. Khan. I wrote it and I hand over to him.
And you handed it to him.
Yeah.
All right. And all these checks we're looking at here, did you do the highlighting?
Yes, Your Honor.
So let's go check 1374. If you would tell the jury what that check is for.
1374.
The next check.
I'm not clear what about this take, but I wrote this 55,000.
Okay.
To
And who is it
Mr.
payable to?
Yeah, I'm buying 49% share of N Nahar investment.
And who'd you write the check to?
I wrote and I
To
gave
whom?
you. Mr. Khan.
Okay. And then check 1377. Tell the jury what that check was for.
15,000. To be honest, that's money. I gave him like, 55,000. That's also a share percentage I gave him. Like, sorry, what's called that's 49%, whatever I owe, I gave to him.
Okay. And then this check for $15,000, check number 1377, what was that for?
15,000?
Right. What was the memo?
Okay, buying Chevron share, 11 feet, 11, I'm not clear the address. I'm buying like his share, like
His share,
Yeah,
okay? And then
It-
check 13, I'm sorry, were you
You-
gonna say something else?
nothing, not at all.
Okay. Check 1379, if you would tell the jury what that check was for,
6,000 only. I gave him like gas money. I deposit.
okay? That's a check that you wrote from your account to who?
Mr. Khan, NR, Nahar company.
So you wrote that check to N Nahar.
Yes, Your Honor.
What'd you do with that check? Who'd you give it to?
I gave to, no, I deposit myself, I think so. I deposit in bank. Oh, no, I gave to Mr. Khan.
So you handed that check to Mr. Khan.
Yes, Your Honor.
And that's what you did with all these checks, right?
Yes, Your Honor.
Okay? Let's go to Exhibit 23. Don't pull that up yet. If you would go to tab 23. Are these documents a true and accurate copy of checks that you have written?
Yes, Your Honor.
Your Honor would like to tender Exhibit 23 into evidence.
No objection.
Admitted.
Okay, now, if you would please pull that up. This first check is check number 204 to General Wholesale. Did you write this check?
Yes, Your Honor.
Okay, and what is that payment for?
That's the beers vendors.
Beer vendors?
Yeah.
Okay, so this is a vendor for the Chevron store, right?
Yes, Your Honor.
Okay, let's look at the next check. What is the dollar amount of this check?
$1,024.35, Your Honor.
And who is this payable to?
Pepsi beverage.
And is this also a vendor check?
Yes, Your Honor.
And this came from your personal bank account?
Yes, Your Honor.
Okay, let's go to the next check. It's on page 72. This is to Star. Who is Star?
Star Wholesale, Your Honor.
Okay, and what's the dollar amount?
$1,165.71, Your Honor.
Okay, and was this also written on your personal account?
Yes, Your Honor.
Okay, let's go to the next check. Who is this payable to?
Star Wholesale, Your Honor.
What's the dollar amount?
$666.52, Your Honor.
Okay, what does the memo line say?
I did not get you, Your Honor.
What is it? It says for
For like grocery, Star Wholesale.
groceries, okay. The next check,
United Distributors, that's the beer vendors, Your Honor.
okay,
$1,627.71, Your Honor.
right? And you wrote this from your personal
Yes, Your
account as
Honor.
well. Okay, next check, please. Tell us about this.
Pepsi beverage, $1,024.35. I wrote and I gave to Pepsi vendors, Your Honor.
Okay. The next check. What is this?
General Wholesale Beer Company, $2,595.22.
And what is this for?
I wrote for a beer delivery, Your Honor.
Okay. The next check.
N Nahar Investment, LLC,
Okay.
4,750, 43 cent. I gave him gas EFT, Your Honor.
What does that mean?
Yeah, that means gas money, Your Honor.
When you say gas money, what does that mean?
That means whatever gas was, and gas was almost out. So that's money like I had to pay him. So I write down that check.
When you say him, who are you talking about?
Mr. Nahar, Mr. Khan and Nahar.
Even though the check's payable to the company, you had to write,
Yeah, my personal check, Your Honor.
you had to write personal check. Okay. Let's go to the next checks, 204. Tell us about this one.
A General Wholesale, $1,444.99. This is the General Wholesale's. This is the wholesale, Your Honor.
Okay.
That's beer company.
Let's look at the next check. Tell us what this document is.
And Nahar Investments LLC, gas EFT, Your Honor, is $6,000.
Okay. And That's also to N-Nahar Investment.
Yes, Your Honor.
Okay, let's go to next page, page 80. Can you zoom in on that one? Thank you. So tell us about the check on the left.
United Distribution, that's the beer company, Your Honor.
Okay, and the next one,
Star Wholesale, Your Honor. That's the grocery company, Your Honor.
please go ahead and put into the record the dollar amount of each check.
Okay, United Distributions Company, $1,627.71. And Star Wholesale, only Star is over here, $1,095.45, Your Honor.
Okay, if you would, let's go to the next page. Page 81. There we go. All right, tell us about the check top left.
Okay, that's N Nahar Investment LLC, 4,000, Your Honor. And I'm not sure, I paid for that gas EFT or like rent purposes, I did. Into, I'm not sure one. Next one is Dina Jume. This is the Mexican chips, Your Honor. $297.54. And next is Star Wholesale, $666.52, Your Honor.
These are all still out of your personal account, right?
Yes, Your Honor.
Okay, let's go to page 82. Tell us about this check.
Okay, this check N Nahar Investment, I pay to N Nahar, $6,000. I'm not sure this is gas money or rent, Your Honor.
Okay, let's go to the next page, page 83.
This is the DeKalb County. I think that's some like ticket or some, I don't know. It's not in my clear, it's not clear in my mind. I pay to DeKalb County, $40.28, Your Honor.
Was that for the business?
Yes, Your Honor.
Okay.
Next one is CTE. That's also business. $14,050, Your Honor. Next,
What that's for?
CTC means that's a tank. Every years we have to like test the tank according to our gas contract, brand contract. Otherwise, they will not supply. That's the amount.
So when you say the brand contract, is that the Chevron contract?
Yes, Your Honor.
Okay. All right. So that was for tank testing?
Yes, Your Honor.
Did you pass?
Yes, Your Honor.
Good. All right, let's go to the next check. Check 203.
Star Wholesale, Your Honor. $1,165.71, Your Honor.
Okay.
Next,
and-
next is General Wholesale. That's the beer company. $1,444.99, Your Honor.
Okay, let's go to page 84. What is this document?
Pepsi Beverage Company, $1,462.40, Your Honor.
And then the next page?
N Nahar Investment LLC, $5,000. It's already written, rent, Your Honor.
Okay. And so all these checks are coming out of your personal account, right?
Yes, Your Honor.
Look at this check here, though. That's not out of your personal account. Who is this account out of?
Okay, Kumar, this one is from my brother-in-law, what's called sister-in-law. I borrow money from him.
Okay. So these checks are checks that you wrote either to the defendants or to vendors, right?
Yes, Your Honor.
Okay. The total of these checks to vendors, is that $15,982.83?
Yes, Your Honor.
Let's go to Exhibit 20. Hold on just a second. Exhibit 20, is that a true and accurate copy of a summary of the checks that were sent?
Yes, Your Honor.
Your Honor would like to tender Exhibit 20 as a summary of these checks?
No objection.
Okay.
Thank you, Your
A minute.
Honor. So now let's go to, hold on just a second. Let's talk about income. So if you would turn to tab 24.
Yes, Your Honor.
Okay. Would you look at these documents?
Yes, Your Honor.
Are these true and accurate copy of tax documents from Indahar Investment to you?
Yes, Your Honor. Your
Your Honor would
Honor.
like to tender Exhibit 24 into evidence.
I'm sorry, what was this again?
These are tax documents from Indahar to Mr. Lynn.
No objection.
Admitted.
Okay. So let's start with the first page. This is page 86. What is the year for this tax form? Do you see that? About the middle of the page?
2023, Your Honor.
Okay, what kind of tax form is this?
This is my payroll, Your Honor, W-2.
It's your W-2.
Yes, Your Honor.
So were you paid wages by the company? This is for wages paid, right?
Yes, Your Honor.
What is this payment for?
For
To the jury.
employee, Your Honor.
And this is for you working shifts?
Yes, Your Honor.
Does this have anything to do with the profits of the business?
No, Your Honor.
Okay. So looking at 2023, what were your wages for that tax year?
$18,630, Your Honor.
$18,630. How many hours a week would you work?
It's randomly, Your Honor. Sometime like 8 hours, sometime 12 hours. It's depend on like
Per day?
situation. Yeah,
Every day?
every day.
7 days a week?
Yes, Your Honor.
For $18,000.
Yes, Your Honor.
Okay. Let's look at the next page. This is page 87. What is the tax year for this?
$14,720, Your Honor.
And then what is the tax year?
2022, Your Honor.
Okay, and is this also a W-2?
Yes, Your Honor.
So for this tax year, you were paid $14,720?
Yes, Your Honor.
Did this payment have anything to do with the profits of the business?
No, Your Honor.
What was this payment for?
For employee, my working hour payment, Your Honor.
Okay, so let's look at page 88. What is this document?
This one is 10, wait a minute, just a minute. Yeah, 1099, Your Honor.
Okay, and what is the tax year for this document?
Okay, I used to take the cash from the store, whatever, for my rent. So that's the amount like pays whatever I took cash from the store. That's the taking cash, and it's called it's like wages, like company doesn't pay the tax. Employee has to pay for this one.
So does this this doesn't have anything to do with
No,
profits of the store, right?
no, Your Honor.
These were non-employee compensation.
Yes, Your Honor.
In fact, that's what it says in the top right-hand corner, right?
Yes, Your Honor. Oh, yes, Your Honor.
Did this have anything to do with the profits of the business?
No, Your Honor.
Did you receive any other tax documents from the company?
Never, Your Honor.
This is it.
That's it, Your Honor.
Let's talk about the business after you started running it. Tell us what happened. How did the business operate?
Your Honor, when I start to run that business, and there was 4 employee, and sometime I used to work randomly, and that's why we used to run that business. And like we have a 4 employee, different payroll that depend on like experience and performance. And some are used to get the payroll, some are used to get the cash. That's what we used to run, Your Honor.
And what did you discover about the revenue of the store? How was the revenue of the store once you started running it?
It was not bad, Your Honor. It was like almost doing that month, I did 45,000. Exact, not like in my mind, like more than 45,000, less than like 50, I did at the first month.
Did that provide enough revenue for you to pay the $14,000 due,
Not, Your Honor.
or 10,000, I'm sorry, $10,000
Not
due to
your own.
Mr. Khan?
Not Your Honor.
How much of that revenue do you think the COAM machines contributed?
I did not get you, Your
How
Honor.
much was the COAM machines a part of that revenue? Any idea?
No idea. Exact number, I don't know, Your Honor.
Okay. Were they a substantial part of it?
Yes, Your Honor.
Okay. When did problems first start occurring?
Problem start from the first day, Your Honor.
Okay, tell the jury what happened.
Okay. Your Honor, when I went to sign the paper, he took it. I did not mind it. Second time, he took the bank, and I thought I was like 49%, and we had a combined bank account. But he did not say anything, and he just like made me sign and walk away with the paper. And he gave me a couple of the check slip paper page. And later, when I get the call from Metro Bank, I was like co-signer. I did not have any responsibility to even like sign the check. That's why we're running. And from that day, we never like talk in two ways, either on phone or like face to face. And like that's why we are running. I was running a store, and that store was messed up totally before. All weeds, drugs, they used to sell inside in that neighborhood. Every day, I call the 911. Like each and every day, more than 6 times, I call the 911 to clean up that store. Shooting, looting, even like customer, whenever used to go buy something, they were not safe. Either they will survive or lose something. That type of condition was over there. Every night shooting, looting. Like some day I work like 18 hours. That's why I run that business. And that's why I did not say anything, because I hoped I can do something over here, and I would like take over, hold the percentage. In that hope, I run the business. And it's clear in my mind, whenever we went to sign that contract paper inside the attorney office, 3 questions attorney did. Request. I did one first, attorney did first question. You do not take over back your business? He laughed twice. I never. Why did I sell? I don't know what's happened. That's his story. And attorney requests us, you have to, him, not me, you have to open the combine, like joint account, business account, first things. Second things, you have to add his name in your company within 6 months, maximum. I know. Still, if you call to that attorney, definitely he will say something. Still, I did not mind. And after a couple of months, that store used to pay cash in game machine. That's the cause. And I continue that way. But when I was running, undercover cops, they caught it and they raid. Still, I know. I got some video clips and some email. It's happened, I think 7 or 8. Can I pull over my
No.
phone? I have in record.
We'll come to the COAM
Okay,
machine
okay.
deal in a second.
And what, sorry, yeah, yes, Your
So
Honor.
continue with the issues that you discovered soon after signing the contracts.
Yeah, and that happened, running contract and check issue, running issue, and he used to appoint the employee. He's taxed me. Okay, that's name, employee is coming. Make his shift like morning, evening, night, whenever he like talk. They have like out of business talk, and his relatives, like community friends. And
But
he
you
used,
say he, you're talking about Mr. Khan.
yeah, and he used to send me, okay, pay him $18 per month, like hour, put in this shift. Yes, sir. Whatever, yes, sir. That's way. And banking, that's issue. Running, that's issue. In time, he never responds my call. If I call, like, definitely in his store 24 hour, definitely something I have to ask, but he never responds my call. And if I call 12 time, 13 time, he used to call back and say, hey, how much, who are you calling? I have a toss. I already hand over the store. That's your response. Boom, finished. One day, even went my family. That day, I really upset. But later he came in the store and excused to me, but I never excused because he came to my family. That day I realized I took the wrong decision. I did not supposed to invest with him, but I did not have options. Either walk away. And after that, when GAM machine bust up and DeKalb County,
Well, we'll come to the COAM machines in just a second.
okay,
So to your knowledge, did Mr. Khan ever do the things he was told he was supposed to do by the closing attorney?
ever never, Your Honor.
Pardon me?
Ever never he did not do.
He did not ever do that.
Ever never, Your Honor.
All right, so now let's go to the COAM machines. So what you explained that the COAM machines license was suspended, I believe. Tell the
Sure.
jury what that means.
That means if any GAM machines is paying cash to like player, that's against the law. And that's happened because that store used to do before also. In my mind, still that store is doing, this store is doing, I'm clear. And undercover cops caught that one employee and he got the ticket. And the 18th, maybe, I'm not exact, that day he raid in our store, that store. When he raid, he sees everything. He suspend our license, he take my employee in jail, okay? Then they suspend 12 months our license. Then that day, another phase came, like problem came. And I talked to Mr. Khan. I did not get any bank account. You did not add my name, your company. Let me go. I don't want to do anymore. I can't. Even when I was employee and manager, I did not feel that types of pressure and, and he offered me, okay, no worry. Let's bring back the COAM license. Then we'll operate. Everything will be up to date. Until that, take the pay your rent. This your W2, I make W2, pay your rent and run the business. After that, we will start new contract.
So
He said
when
to me.
you say restart a new contract, was this specifically talking about the guaranteed profit payment?
I think so. I'm not sure.
And you think so?
Yes, Your Honor.
So what was your understanding that Mr. Khan meant when he said, we're going to just pay the rent?
Okay, that means I just ran the store because I'm also 49% and he also 59%, whatever lost. And when GAM machine come back, everything will cover it. I hope. And that intention, that hope, I run the business.
So how long was the COAM license suspended?
12 months, Your Honor.
12 months. So during this 12-month period, what was your understanding and agreement regarding the $5,000 per month monthly profit?
Okay, we are going to share whatever loss or profit that month. I'm not responsible for that. And we talked inside the store. He agreed with me, but he did not do the paperwork. That's my mistake. That's why. And I accept his word and I trust his word. And because that time the store was making 37,000 sale. In 37,000 sale, how could I make 5,000? Because that's a store in my knowledge, 27 to 28% profit from 30 out of 37,000. So he agreed, whatever, let's run the store. Whenever machine come back, we are both in same boat. We'll cover it. That's why I run the store, Your Honor.
What about the promissory note payments?
He told me he did not ask any permission. When machine will come back, it will cover, then we'll talk about that.
That $10,000 a month,
No, no pay.
Okay.
According to him.
that would start again when the suspension ended, right?
Yes, Your Honor.
Approximately when was the license suspended?
8 of 21, like July 27th or something like
July 21st or 27th?
27, yeah. I have that video still in my phone.
And this is in 2023, right?
Yeah.
Okay. Tell us what happened after that July date. I mean, July, is that what you said?
Yes, sir.
Tell the jury what happened after that July date.
I start to run the business and I was like a storekeeper. As a storekeeper, I did not have any rights, whatever he say, I did. And whatever short money, I borrowed money from my family, friends. And I run the business, whatever I hold it, whatever, like everything's, he used to pay check. There was no checkbook, no check in any store. And see that's amount and I paid my personal because there was no check. And I had to pay in like vendors, company in a time. If I could not make, he used to like yell at me, jump at me. And that's why I run. And 37 too, like after 10 months, I make 68,000 per month, start to sell it, like make the business. That's
What was the impact of the COAM suspension, license suspension on the operations of the store?
like 10 to 15% will be is
Okay.
differences.
And did that also have a ramification for the other sales, the other product sales?
Yes, Your Honor.
And so what do you think was the total impact, decline in sales?
Total, you are talking about I didn't get you word.
Okay. So you said 10 to 15%
Yes,
was the
Your Honor.
COAM by itself.
Yes,
But
Your
if
Honor.
you add in the other things, the Pepsis, the Cokes, all that kind of stuff, what do you think was the total decline in sales because of COAM machines being down?
Like same like 10 to 12%.
Okay. So tell us what happened next. You're operating the business,
Yes, Your Honor.
no COAM machines. Tell us what happens next.
Okay, whatever, I borrow the money, I have friends and family, whatever I run, and he hold the check, bank account, like till 15 days, he did not receive my call. And if I said, okay, I have to buy some grocery, he told, okay, I have to pay the rent. Then I never like enforce him. And he used to pay. Like that, I run. And incidentally, before like lottery game machine time, like it was almost like 45 days remaining. And that time, one day, he texts me, okay, stay in the store, I'm coming Monday. 3 people came, they went to like get inside the store. They bring the inventory computer, one is drink section, another is grocery, one is like a cigarette. Within 10 minutes, they put down the inventory and they left. And he said, okay, no more, you are my employee. Might be there is no record. If you see the video, still it will be clear. My word is not like clear. How did he disrespect with my coworker? Even he did not allow to me grab my stuff from that store that day.
So you were fired.
I was totally fired and disrespectfully I was fired.
And you were shown the door.
Yeah, exit. And I did not say that before when like game machine like bus stop, I tried to quit and take back my share, whatever, but he didn't deny. He told, whatever happened, we are both in same boat. Let's like cross together. But that day when I make like 68,000 grocery only without COAM machine and everything was updated and I put all the like stuffs, small things also in a scanning, so there is no price gouging for customer. It's used to happen before. Everything was going smoothly before like commission came back like 45 days to 50. He came and boom, boom, boom. And that day I could not sleep. In my pocket that time only I have $200. And 1 week I sleep, and from next week I start Uber. That's it.
So why do you think Mr. Khan fired you?
He told me I did not run the store properly. I messed up his.
Judge, on mental impression, there's no way he can be in his head.
As he's answering his statements by party opponents, so overruled.
Thank you. Please go ahead. Why did Mr. Khan fire you?
He told me I did not run business properly. I did not pay time, everything in time, like payment in time, make a pay. And first thing that day, he came inside the office and told me, okay, give me this money. Your problem, according to your like 53, I owe you. And he brought that same number and like paper. This is my number, you got to pay. Otherwise, you fire from my store. Get out from it. Get out from my store. I know that's still that word in my quote. I have been already quoted.
That's what he said to you.
Yeah, get out from my store. If you need share, bring this number. It is verified or not, how came, how did he like brought. There is no any like, and there is no authorized person's signature. Get out from the store.
Did Mr. Khan get the COAM license back?
He got it.
And
That's
so-
why it's happening, it's everything's. That's the cause.
And do you know if the revenues for that store went up after the COAM machines were back in operation?
I cannot tell you right now, but it should be around, I do not know. But if I get that's in that place, I can make like around 65 to 60 to 65 in like average in annual, I can make 55,000. That's all. That's my working experience.
Now, after you were fired, did you ever hear anything else from Mr. Khan about the business?
Sir, how did he fired me in front of an employee when I was working shift. Even I did not dare to go back in toss. That's why I knock your door, Your Honor.
Did Mr. Khan ever pay you any profit sharing from the COAM machines?
Not yet.
Did you
No,
ever
Your Honor.
get any kind of check from the company after you were fired?
No, Your Honor. I got W-2, that's all.
Which we've already looked at.
Mm-hmm.
Well, can I just approach?
Sure. What you got?
Yeah, but you can always do it. And the W two is not also want to go. I'm introduced. We're like. Yeah. That's right. Well, that's. Yeah, I mean, he's gonna have to ask him. Did you get it? That's literally what I was. I didn't know. That's what
Yeah, Chris Yoder.
Why don't you ask the question first?
Have you seen the tax returns for in-the-hard investment for 2022, 2023, or 2024?
No, Your Honor.
May I approach your honor?
Again,
I just wanted to look at it, see if.
he's saying he's never,
Just said no.
he's saying he's never seen it. And so if you have some other relevant question about it, or you want to do something else with his documents, we'll take that up. But at this point, I don't see a need for him to look at something he's never seen before.
Okay. To your knowledge, was a K-1 issued for you for 2022?
No, Your Honor. I
Your
don't have
knowledge
that.
was a K-1 issued to you for 2023?
No, Your Honor. I don't have.
Okay. And have you ever seen a K-1 from the company issued
No,
to you?
Your Honor. Never.
Did Mr. Khan ever tell you about the profit and loss for 2020?
Never, Your Honor.
How about for 2021?
He did not, Your Honor.
Mr. Khan testified yesterday that the store was profitable when he ran it.
Objection. He's restating testimony from Mr.
I haven't finished my question yet.
All right, overruled.
Do you recall, did you know whether or not the company was profitable?
What's the year, Your Honor?
2021, right before you took over.
I do not think so, Your Honor,
And why is that?
because of that in that location there was 4 stores: one CBS, one Sitco, one Bells, and one Chevron and Nahar. And first store like best store CBS, then mine, then Sitco, and then after and Nahar used to come. I used to make like a 1,700 only grocery that day. Means I don't think so. Like he used to make 50 to like 45 to 50,000 maximum in a brace. If I, in my mind, according to my experience, if he did different, I don't know.
Did Mr. Khan ever say anything that indicated he believed that the store could generate $60,000 a year to pay that required guaranteed profit?
Yes, Your Honor.
How? What did he say?
Now, what he, according to my experience also, he did not say anything. My experience also, if any store makes like a more than 40,000, it's a little bit close to like expense, my experience. And 70, if any business makes 70,000, that's the excellent store in my mind. So 65 is a good number. And when my store closed, that means my side customer also, my hope, I will brought them in that store, connect with that store. So I could live it like profitable. That's Your Honor.
Did you discuss with Mr. Khan whether or not the store could generate that $10,000 a month for the guaranteed profit and the
Did
promissory
not,
note?
Your Honor.
Okay. Let's go to Exhibit 17. This is already entered into the evidence. This is on page 6. You see, this is the letter that my firm sent on your behalf to Mr. Khan, Nahar, and TSTT. Do you recall this letter?
Yes, Your Honor.
Okay. What's the date of this letter?
Uh, Okay, May 17, 2024,
And then you see the total amount due. What is that dollar amount?
$263,750.43.
$236,750.43.
Yes, Your Honor.
Okay. And let's turn the page. Let's go to page 61. See those 3 bullet points? You explain to the jury how that total demand was determined?
Okay. 120,000 I paid to Mr. Khan. 85,000 to Mr. Khan's TST. That also goes to Mr. Khan. And $31,750.43 I paid the vendors, different vendors and different wholesale.
So this is what your initial demand was to Mr. Khan and his companies.
Yes, Your Honor.
In effect, you were asking to refund the money you paid.
Yes, Your Honor.
And this 236 is a lot less than what you're asking for today. Right?
Yes, Your Honor.
So if they had agreed to pay that, they would have saved a whole lot of money.
Yes, Your Honor.
They would have saved you a whole lot of work too and money.
Yes, Your Honor.
Now, do you believe that the defendants have been stubbornly litigious in forcing you to bring this lawsuit?
I do not think so.
So your claim for attorney's fees is based on stubborn litigiousness?
Yes, Your Honor.
Are you testifying to this jury that you believe the defendants have been stubbornly litigious?
Yes, Your Honor.
Do you believe the defendants have also acted in bad faith?
Absolutely, Your Honor.
Do you believe that the defendants have put you to unnecessary trouble and expense in having to bring this lawsuit?
I have a bad experience. Absolutely, yes, sir, Your Honor.
In this letter demanding a refund of the money you paid, this was sent before the lawsuit was filed.
Yes, Your Honor.
Did at any point after that May date, did Mr. Khan offer to refund your money?
Even he did not respond to your email, Your Honor. How did he respond to my call?
So we talked about the income that you made working at the store. That was about $40,000 for 2 years, right?
Yes, Your Honor.
Did that have anything to do with the profits of the business?
No, completely. That's a different, Your Honor.
Did you get anything profit-wise from the business?
0 penny, Your Honor.
Is there anything that belonged to the business that you had that you should have returned?
No, Your Honor.
Did you have any company property in your possession?
Nothing, Your Honor.
And you took no money from the business other than what was shown in those tax documents?
No, not even penny, Your Honor.
To the end, the day that you fired, had you ever been given online access to the bank accounts?
Before, when I was working, that time also, he did not give me. How did he give? No, never, Your Honor.
And did you ever make any distributions from the bank account to yourself?
Never, Your Honor.
Okay. Now, these checks we've already talked about, these checks were each one handed to Mr. Khan personally, right?
Yes, Your Honor. But that vendors, I gave to vendors, not less vendors one.
But you never mailed any checks to Mr. Khan?
No, Your Honor.
You hand delivered each one.
It's and everyone. Yes, Your Honor.
And for each check, Mr. Khan told you how to write it out, make it out.
Yes, Your Honor.
Some were to him personally, right?
Yes, Your Honor.
Some went to Indahar,
Yes, Your Honor.
and then one went to TSTT.
Yes, yes, Your Honor.
So at this time, Are you asking this jury to award you total damages of $384,904.79?
Yes, Your Honor.
And what does that represent?
That represented everything's expenses, vendors, whatever I paid from my personal account and my Bell's Food Mart account, and plus my attorney fee.
Plus your attorney's fees. I have nothing further, Your Honor.
All right, defense counsel, do you have any kind of a rough ballpark of how long you would need for cross-examination?
$2 hours.
Okay. All right, members of the jury, why don't we probably take a little 5-minute break? We'll get started with cross, and then we'll get a lunch break at a good stopping point.
Oh, you said the
2 hours too. I was glad that's okay.
I wondered. What you mean, same.
You can sit down.
Those 2 numbers. What's their old slide? Yeah,
I don't understand.
we gotta look at this thing.
You really did pay out.
Thank you, Deputy Scott. All right, before we break for 5, just trying to game out the afternoon. For just a 45-minute lunch break, that still gives us about 5.5 hours in the day. Subtract 2 for cross, that's 3 remaining. Do you anticipate when and if the defense would present its evidence, how long direct of your client would be?
An hour and a half.
Yeah, I mean, that just doesn't give us a lot of time for a charge conference and instructions and that sort of thing. So anyhow,
Maybe an hour.
yeah, we'll see. We'll just have to stay on course here. So anyhow, we'll be back when the jury lets us know they're available. So please don't go far. Stay here if you can.
All right.
Okay, let's step outside for a second.
A different, well, I'm afraid, don't worry about it. Just don't worry. I feel like it's good. Yeah. In essence, these are the 2 best cases. These are great. Explains it really well. This is really, we can go back in that room, but just look at this the highlighted portions. Oh.
Man, and I have to piss. So let me piss.
I do. Right.
Oh, they scattered. Oh, well. Yeah. Hmm? I know. Do you mind if I leave around 3? You're talking to me or the attorney? Sounds good. Sounds good. I am highly skeptical you're gonna get to see a verdict today on this.
Okay. No.
But then, and his measure of damages are, okay.
We're not there.
Okay. No.
Yes, ma'am. I mean, maybe just like,
How do you say that?
Right.
It's not, doesn't look very good. If he says no, what I'm saying is, we had it, so the thing is, I was saying yesterday. Then do I say, well, doesn't that mean that you own the company, but you just want the money?
Yeah.
Wants all of them. See what you can get the money back.
Do you remember what it said? Then you show it to brush through. You didn't.
That's
Tell
true.
someone, go.
All right. God, I know I'm saying, I'm asking this like 10 times. Maybe I'm asking.
Don't ask it then.
Well, I don't understand it. I don't understand. I just want to make sure I still want it. I want to make sure. Because now, I just had an epiphany about what he just asked for all the money back there. It sounds like this is- I still,
Oh,
okay,
y'all are back.
propose, okay.
Bringing anything new?
But that can, to me, spells it
Well,
out. And
but
it's
this
just
is
a
what we
Supreme
knew.
Court
And this
case.
is what we knew.
But just if she's asking. for
Yeah,
it.
yeah. And I think that, and I, you said we had
That's
those
what
three
we
jury
need to.
charges.
Yeah, you're right, you're right. This is just a whole thing about rescission prior to filing suit.
That's good.
I guess literally that letter is sort of saying it. It doesn't really say it. I think
This is the kind of thing.
Yeah.
Probably will be many years before she's in custody. Yeah.
After the jury.
Mr. Ray, you can go ahead and come on back.
Have these notebooks.
Thank you, Deputy Scott. Please be seated, everyone. All right, defense counsel may proceed with cross-examination. Once we get closer to the 12:30 mark, just let us know a good stopping point. And Mr. Ray, I remind you, you're under oath. Counsel.
You're fine. You're fine. Good morning, almost afternoon, Mr. Ray. I'm Justin Alioto, as I introduced myself earlier. I represent the defendants, counterclaim plaintiffs in this action. Going to be going over a number of items that you've already testified to, and then some additional topics that I'm going to have questions for you. Understood?
Please. Your Honor.
Okay. If at any point you don't understand something that I'm asking you, or if there's a particular word that you don't understand, please feel free to let me know that. But if you answer, I'm going to assume that you understood my question. Is that fair?
Yes, Your Honor.
Okay. Now, I noticed that during your initial examination, you would often preface your answers with, "to be honest." I mean, to be clear, you were honest on all of your answers, right? Not just the ones that you were saying to be honest, right?
Yes, Your Honor.
Okay. Well, the first thing that I want to be clear on is this. Before we look at any pieces of paper, get into any he said issues, I want to make sure the jury, and the court fully understands what it is that you're asking the jury to do in this case. Is that fair?
Yes, Your Honor.
Okay. Now, just as we concluded these proceedings, you testified that you wanted all of the money that you paid into the business returned to you, correct?
Yes, Your Honor.
Okay. So again, we got plenty of materials to look at, but before we get there, I want to just make sure I understand this point. You are wanting to undo the deal and put yourself back where you were before the contracts were ever entered into, correct?
Yes, Your Honor.
Okay. And lastly, to be clear, whether the last dollar figure that was announced between yourself and your attorney, this $287,000, that's your understanding of what it would take to be made whole again, to put you back as if you had never entered into any agreement with the defendants, correct?
Could you?
Sure. So that $387,000 figure, knowing that part of that is your legal expenses and court costs and things of that nature, that plus the balance represents everything that it would take for you to be made whole again, as if you had never done a contract with the defendants, correct?
Yes, Your Honor.
Okay. Now, earlier you testified that in the entire time that you've resided in the United States, you've been a part of the gas station and convenience store industry, correct?
Yes, Your Honor.
So we're talking about more than a decade, correct?
Yes, Your Honor.
Okay. And you testified earlier that in some of your experiences in that industry, based on your efforts, these companies had increased financial success, correct?
Yes, Your Honor.
Okay. Have you ever produced any documents, or is there anybody else here today to testify as to that success?
No, Your Honor.
Okay. Now, earlier, I was having a little difficulty understanding when you were talking about the Bells Ferry location. You said that was in the same neighborhood as
Cross
the
the street.
Chevron.
Yeah,
across the street,
Your Honor.
right? Okay. Did you say that at some point the Bells Ferry location, did you say the words straw man? That it had a straw man owner? Did I hear that? Did you ever use that expression, straw man?
The straw man, I never use, or did I?
Oh,
I do not, that's
okay,
not in my mind.
I had marked down that it sounded like you said that there was some straw man in the Bells Ferry location, and if that's not accurate, that's fine. But
No,
do you have any
that's not
recollection of that?
No, Your
Okay.
Honor.
Now, I want to clearly, for a moment, talk about the company TSTT Development. Okay?
Okay.
That's
Your-
one of the defendants in this case, right?
Okay.
Okay. Now, to be clear, nobody acting on behalf of TSTT development was part of your negotiations on buying 49% of the Chevron, correct?
No, nobody. Your Honor.
Okay. And the purchase agreement is not with TSTT, correct?
No, Your Honor.
And the operating agreement is not with TSTT, correct?
Your Honor.
Okay. So the only connection that TSTT has in this case, according to you, is that some of the money that you paid towards your relationship with the Chevron went to TSTT, correct? That's the only connection that TSTT has with this case, correct?
Okay, let me clear. Might be,
Mhm.
I'm not clarify you in previous. Oh, TSTC, I never heard that name. I supposed to give the check to Mr. Khan. He told me that write down this check in this name. Who belongs to this company? Whose company is that? I never know. But it's clear in my knowledge that's the reason for that check. I was buying 11, like North Harrison Road. That's it.
Right.
I don't know any.
Right. So we're saying the same thing.
Okay, yeah.
So again, the only involvement that TST has at all in this case is that it was the recipient of a piece of the money that you paid to buy the Chevron. That's it.
Yeah, I paid to Mr. Khan.
Right.
That's all. I don't know. Like TST, he told me that in front of me, write down the that's on my name of TST. I did.
Yeah.
That's all.
We're saying the same thing.
Yeah.
So there's no contracts with TSTT, right?
I never heard that name
Right.
again.
And there's nobody negotiating on behalf of TSTT for the Chevron, right?
Never ever, Your
Okay,
Honor.
thank you. Okay, now. Well, hold on one moment. When you decided to consider buying 49% interest in Nahar, did I hear you correctly say that you didn't get into any deep discussions with Mr. Khan about the profit expectations? You based that on your experience in the industry, correct?
Yes, Your Honor. That 49, but 49% came finally when we are going to sign. Before that, we had a 50-50%.
Okay.
Okay?
All I'm asking about is any idea of how profitable the business was going to be. You did testify earlier that you projected that based on your experience, correct?
Yes, Your Honor.
Okay. And because of that experience, if I'm understanding correctly, you didn't get into any specific profit and loss statements or bank records or anything of that nature. Do I have that correct?
I did not, Your Honor.
Right, you did
Yes,
not.
you are. Yes,
Okay,
Your Honor.
got it. Okay, so it sounds like it's fair to say that your decision to purchase a piece of the Chevron, it wasn't based on any individual or any company guaranteeing you any sort of amount of profit expectation. Is that fair to say?
Absolutely, yes, Your Honor.
Okay, thank you. And am I remembering correctly that you had a family member or a friend that said that he thought there was some yellow flags if you were to do this deal? Is that correct? That there was
Wait
a
a
yellow
minute.
flag?
Let me little bit explain over here.
Well, you can explain, but first, just yes or no. Did you say that a friend or relative?
Not in that 49-50 conditions. That's 100% conditions.
Right,
It's clear.
but he thought there could be a red flag in there, correct?
Definitely, yes, sir.
Okay. But obviously, despite that, you opted to move forward with the deal anyway, correct?
Yes, sir. Can you like explain why?
Is it different than the explanation you gave to your
No,
own
no, let
attorney?
me, because you come in like jumping, like quick question, yes or no. If I get the explanation like
sure.
time, I,
It's up to the,
Okay.
I mean, fine with me. It's up to the judge.
yes, Your
All
Honor.
right, go ahead.
What was your question, Your Honor?
That despite the fact that a friend or a relative thought that there could be a yellow flag
Okay,
with the
yeah,
chevron,
let me come back.
ultimately you obviously
I got it,
decided to do the deal anyway.
Okay. That's yellow flag because of liabilities. And Nahar, I supposed to like give whatever liabilities comes up to that day to an Nahar, and bills will run. That's business in new, like management, everything new. But Mr. Khan and Nahar owners, he denies. He just grabbed the money, hand over the key, and walk away from the business. After that, what the liabilities? That is not his own responsible after that. That's why it was a yellow flag. But after that, 49 to 51, because he was himself involved. So yeah, absolutely, I say yes.
Right. So even though this friend or family member had concern about how much liability you would be undertaking in this deal, nevertheless, you did the deal anyway, correct?
Oh, yes.
Okay. Now, earlier you also testified that you're very acclimated with the gaming slash coin operated amusement machine slash COAM business, correct?
Not like nothing, really. I told you, nothing. Like that's my second, like, yeah, second game, like store.
Right. So you had gaming at Bell's Ferry.
Bell's Ferry, but we did not do like that. That's the different way. I told you, mostly like almost most of the machine, they have different policy, but handful like a com machine, they have different policy. So which one game machine, like owner and company belongs to that, and what their policy depend on their policy, Your Honor.
Okay, but Bell's Ferry had COAM, correct?
Yeah, we had,
And Chevron had COAM.
but that's a different company, and they have they had a different names and brand and policy too.
I understand. I understand that Bell's Ferry is different than North Harrison.
Yes, Your Honor.
All I'm asking is both of those stores had gaming.
Gaming, but
Okay.
yes, Your Honor.
All right. And you said that even when you started your deal with the Chevron, you knew that some businesses were acting outside of the law and would pay customers cash instead of merchandise, correct?
Yeah, that's the store used to do. Yes, Your Honor.
Okay. And even though you knew that some businesses operated their games in that way, you still decided to go into this deal for the Chevron.
Yes, Your Honor.
Okay. And not only do I understand that based on your extensive experience with the gas station and convenience store industry, that you felt comfortable with this opportunity to be an owner of the Chevron, you still are aware of the fact that if you wanted to, you had every right to hire as many attorneys as you wanted to assist you with this deal, correct?
Absolutely, yes, sir.
Okay. Now, did I hear you correctly say that when you were looking at the purchase agreement and the operating agreement, you read some of it, you just didn't read it thoroughly? That's the word I have. Is that
Yes,
correct?
Your Your
Okay.
Honor.
Now, not to be dramatic, but just to be clear, Nobody forced you to sign anything, correct? Nobody threatened you in any way to sign anything.
Absolutely not.
Okay.
Your Honor.
And of course, you can decide not to sign that document if you changed your mind, right?
Yes, absolutely, Your Honor.
And to be clear, we've already established that there was an inventory taken right before you became the manager of the Chevron, correct?
Yes, Your Honor.
All right. And that number is different than the promissory note figure, correct? Promissory note is a little over $63,000. The inventory amount was a little over $100,000, correct?
Wait a minute, I did not get you. Would you mind to repeat it?
Sure. Your promissory note
Mhm.
is for a sum a little over $67,000, correct?
Mhm.
But the inventory amount was over $100,000, correct?
Yes. Your
Okay.
Honor.
And so the inventory amount has nothing to do with what you owe under the promissory note, correct?
Okay, let me clear you. Might be I'm wrong or I did not catch your questions. That's promissory notes. How came? How, like promissory note, how came, first of all? That's inventory, whatever we made it, from that 49% grocery goes to on me. All right? You hear me? And 63,000, that's from the, I have to pay like monthly basis of that grocery amount. And you are talking about which one, 63,
67,
67.
promissory note, right? So it's two different numbers. The
Mhm.
promissory note and the inventory are two different numbers, right?
Oh, yeah,
Okay.
absolutely.
And in the agreement that you went over with your attorney, it actually says that if you're not the manager anymore, if there's a shortfall between the amount of inventory from when you started being a manager and the amount of inventory at the end of your management period, you would be liable for that gap, correct?
Absolutely, yes, sir.
Okay. Now, there were a few instances when you were speaking with your attorney where he was asking you, what did you think this passage in the contract meant? Do you recall that? And you would explain what you thought it meant.
Okay.
Oh,
That's
hold on. Yes, sir. Do you
my
recall
bad.
that?
Yes, yes,
Okay.
Your Honor.
All right. My question is this. Do you know if the passages that you were referencing today, were those the ones that you did read when you signed? Or were those ones that you skipped through? In other words, are you just looking at it for the first time for this lawsuit? Or were those actually passages that you read when you signed?
I did not get you, Your Honor.
Do,
My bad.
do you actually know which passages you read before you signed and which ones you only read after the lawsuit?
Oh, I didn't. I read whatever. Which one? I'm not clear. But up, like I read it. We have a like promissory note and running, but in detail, no, in my mind.
Okay.
Like,
If you don't remember which passages you read when you signed, how do you know what it was that you thought it meant when you signed it?
okay, it's clear. That time I signed. I'm owner of this business 49%. We run the business, and according to him, after 1 year, when there was zero liabilities, he's gonna to hand over the business. That's all.
Right. But for instance, you
Yeah.
were asked earlier what you thought the passage of the operating agreement meant when it said you had to pay Mr. Khan $5,000 a month?
Absolutely.
Do you remember being asked?
Yeah.
Okay. And you gave an opinion, you gave testimony as to what you thought that meant, right?
Yes, absolutely.
Okay. What I'm saying is, if you don't remember which passages you read when you signed it, how do you know what you thought it meant at the time that you signed it? If you didn't read it when you signed it, how do you know what you thought it meant at the time you signed it?
Okay, thank you for question. We had a lively conversations out of attorney in a store couple of times, and we have a discuss in main point. Let me clear you. 5,300, like whatever that grocery I owe him, and like 5,000 every month profit. I signed it. We had that's all discussions.
Okay, so I guess just to close the loop on this line of inquiry, at the end of the day, out of the pages of the purchase agreement and the pages of the operating agreement, you don't know what you did or didn't read at the time of the signing. Is that fair?
Gentlemen, I did. I read it.
You did read it.
That's why I sit with Mr. Khan when game machine bus stop. I sit inside the store and we discuss in that issue. And I request to him that time also, what we'll do of the paper. But he say, no worry, I'm here. It's my word. I never tell lie. Go ahead, run it. I don't need any lie because of at that time I was about to exit from that business. I was trying. That time he told me that.
Okay. Well, now I'm confused because I thought we just covered moments ago that you did say to your attorney, you looked at the pieces of paper, but you did not read it thoroughly.
Definitely, I did not read thoroughly paper.
Okay.
Absolutely.
Okay.
But that was our agreement between
Right.
me and him.
Right. So I comprehend the fact that you're saying before you signed the document, there were some principal points that you had discussed with Mr. Khan, correct? There were some major items that you discussed.
Yes,
understand that.
I did, Your Honor.
But when it comes to actually looking at the purchase agreement and reading it and looking at the operating agreement and reading it, you only skimmed through it and did not read it thoroughly, correct?
Yeah, definitely. I did not read it thoroughly. It's
And
true.
as you sit here today, you don't know which are the parts that you did read and which are the parts that you didn't read on the day of the signing, correct?
Absolutely, yes.
Okay. All right. Now, you should have another notebook up there, another
Yeah.
binder,
Yes, Your Honor.
that at the top says defendants exhibits.
What the page?
One moment. Go to exhibit 7.
Mm-hmm. Yes, sir.
Do you recognize exhibit 7?
Yes, sir.
All right. What is this?
They say $5,344.77.
Exhibit 7 to the defendant's exhibit, not the plaintiff's exhibit.
Okay, my bad.
Okay.
Okay, yeah, I get it.
Okay. What is exhibit 7?
The membership interest required to call a meeting of members shall be over 50%.
You are not looking at the right.
All right.
He's in the wrong notebook.
You're still in the wrong notebook. Can I?
Right.
Oh, my bad.
Defendants. 7. There you go. You recognize that?
Yes, Your Honor.
Okay. What is it?
Complaint for damages, Your Honor.
Okay. So is this is your lawsuit, correct?
Yes, Your Honor.
All right. Now, if you wouldn't mind, turn to paragraph 16. You see enumerated paragraph 16?
Let's see,
They're all numbered
oh,
numerically.
er,
Matt approach.
this,
1, 2, 3.
Thank you.
Go to 16.
okay. Yep,
Now, in your lawsuit, you say that you paid a total amount of $236,750.43, correct?
Yes,
And
Your Honor.
43 cents, correct?
yes, Your Honor.
Okay. Flip to the next page, number 22. You see it's the exact same number, right? $236,750.43, correct?
Yes, Your Honor.
Okay. Flip to number 35. It's the exact same number, right? $236,750.43.
Yes, Your Honor.
And then flip to 38 and 39. You'll see that's the exact same number again, correct?
Yes, Your Honor.
Okay, so the only number for damages that is in this lawsuit is the principal amount of $236,750.43, correct?
Yes, Your Honor.
Okay. Now, going back to the plaintiff's exhibit notebook, to the demand letter, exhibit 17. Now, this is the exhibit that you just discussed with your attorney about, right? This is his demand letter
Yes, Your
to
Honor.
my client.
Yes, Your Honor.
The total amount due on page 1, it's the same number, right?
Yes, Your Honor.
$236,750.43, right?
Yes, Your Honor.
Okay. Go back to the defendant's notebook, please, and turn to exhibit. Okay. Do you recognize defendant's exhibit 9?
Defendant exhibit, yes, Your Honor.
Okay. And are these,
Can we adjust his microphone? He's not speaking.
And Mayor, can we get your jury number?
Hello?
Get your jury number.
5.
Thank you, ma'am.
but I'm sorry, I moved to tender exhibit 7, which was his complaint. I'm sorry.
All right, any objection?
No objection, Your Honor.
All right, D7 is admitted.
Just for the record, though, this is not going back to the jury room, right?
We'll discuss that as charge conference.
Thank you, Judge.
And, okay, so going back to defendant's exhibit 9. So do you recall getting a series of questions from my office called interrogatories that you've already responded to?
I did not get you one more time.
Well, this document is titled Plaintiff's Answers and Objections to Defendant's First Continuing Interrogatories. You see
Yes.
that?
Yeah, I saw
Okay.
it.
Do you recall answering the interrogatories, the questions that my office sent to you, which were questions in written form?
I'm not sure, Your Honor.
Okay, that's fine. Let me unpack that for a second. Do you ever, I don't want you to tell me anything that you discussed with your lawyer,
Yes, sir.
okay? All I want to know is, do you ever recall providing answers to interrogatories that my office gave?
Never, Your Honor.
Okay. So, do you know who gave these answers then?
Yeah,
Who?
me and like our lawyer, we discuss about everything. And we made it, we prepared this one. I mean, no, whatever I provide to my lawyer, he made it.
Right. Well, I tell you what, just for instance, go to page 4, where it says answers to interrogatories.
His, I mean,
Yep. Oh, it's right on the screen. Yeah. Answers to interrogatories. Let me help. Can I help?
I'm here.
I don't know.
Oh, my bad, my bad. I
It's
apologize.
okay.
Let me tell you this one. Thank you.
You had it right, you just had it wrong. So first of all, this is what we're looking at.
Okay,
Okay, so let me just, to be clear,
yes.
do you recall answering the interrogatories that my office sent to your attorney? Do you
I
kn-
never, I did not.
Okay, so now go to page 4 where it starts by saying.
Same book?
Literally the same document. Just go
Yeah.
to the 4th page where it says answers to interrogatories. You're going the wrong way, man. Page 4. Answers to interrogatories.
Okay. Mm-hmm.
So you'll see that there's some form of a question and then something called response, right?
Mm-hmm.
Okay. So for instance, you'll see the first interrogatory asked to identify any person whom you believe has any knowledge of the subject matter of the lawsuit. You see that?
Yeah, I saw it.
And then there's a response. Okay. Now, just for illustrative purposes, go to the next page. Then there's another interrogatory. Identify all persons who have been contacted. Then there's another one. Have you obtained any statements or reports? You see all that? And then there's responses. To be clear, did you provide these responses to these interrogatories?
This answer I did not provide, but we had a discussions with my lawyer couple of times, and we sit and we discuss about the whole things. I tell whatever story.
Okay. Got it. So I understand that obviously you've had communications with your legal counsel.
Yes, sir.
Understood. But until now, if I'm understanding correctly, you've actually never seen these exact questions. Do I have that correct?
Yes, Your Honor.
Okay. Well, I mean, I'll move to introduce Exhibit 9 into evidence.
All right, any objection to D9?
No objection, Judge.
D9's admitted.
They're all numbered. Like I said, you just got to go to number
Oh,
4.
my bad. Fourth, yep.
You see how at the top, you're asked to describe about your claim for fraud. State with particularity the basis for your fraud count. Right?
I did not get you. Wait a minute. 4. With a partially basis of code 2. Okay. Yeah.
You see how the only grand total on here is that same number of $236,750.43.
Yes, Your Honor.
And that's the same number. It's the only number that's in your lawsuit, right? That's the only total that you're asking for in your lawsuit, in your complaint that we already looked at, right? the $236,750. We've already established that that's the only number that we saw or identified in your complaint, correct?
Okay. Yes, Your Honor. Can I clear it a little bit? Can I tell
You
you
need to,
detail?
are you saying you need to explain
Yeah,
that
can
the
I-
answer is yes, that it's the same number that's in your lawsuit?
Okay, can I like clear it? How did it came to 63 and when it came?
No. You,
Objection, Your Honor. The
I-
witness should be allowed to explain his answer.
no, hold on.
Well, but as we did with before, he first should answer the question if there's a clear yes or no answer, and then he can explain. So
Correct.
do you recall the question?
Yeah, I am not asking
You
you,
ready to recall the question?
Uh,
The question asked again.
yeah,
Okay, let's ask it again.
is that number the same exact total that was in the lawsuit? And is that the same exact total number that was in your lawyer's demand letter?
yes, Your Honor.
Okay,
But let me clear. Can I clear, Your Honor?
sure.
Here, my personal accounts, whatever I paid to vendors and company has not been added over here. It's without that my personal check, that amount has not been added plus lawsuit, attorney fee. Before that lawsuit, we talked and my lawyer, he emailed to him, Mr. Khan and his lawyer, let's settle out. And this give number, if you make us like go to court, you have to take care. Attorney fee plus personal account, whatever like personal, whatever amount like paid from this personal account, you have to take care. That's way we we discussed before. Absolutely, you are right. That's the before lawsuit.
But even in the lawsuit, that's the only number.
No, that's the before lawsuit. This number came when we are trying to settle it down,
Well,
settle down our agreement. Like,
let's go back to the lawsuit. If you don't believe me, we just covered it. Same notebook. Go to Exhibit 7, and that's in that notebook. Got it? You see where it says complaint for damages?
Exhibit 7.
Same notebook,
Same
Exhibit
notebook.
7. Look at the tab that says 7.
Okay, I'm here.
The only number that you're saying that you paid in this lawsuit is $236,750.43, correct?
Objection, Your Honor. Asked and answered. We've already been over this.
I agree.
Well, he just gave a different answer.
Well, I think he gave his explanation for the variance, and the jury will have to accept that. So let's move on.
Okay, so,
Or the jury will take what weight, if any, to assign to it.
okay. So the number that you're asking for now isn't the same number that's in the lawsuit, correct?
Before the lawsuit, that was number. After lawsuit, this is a different number, Your Honor.
Well, that is your lawsuit, right? Exhibit 7 is your lawsuit, right? That's your lawsuit.
Still, I don't know where you want to take to me and what you want to answer, but I clearly tell you that that's the settlement, primary our settlement, that's offer,
Yes.
okay? It like, you know that. And after that, when definitely, I did not answer each and every question, but whatever happened in 11 or North Harrison, I told every story to my lawyer, okay? And according to his knowledge and how we discuss, that amount will be, let's try to settle down these cases and nothing else. But after that, when we file the lawsuit, that is our primary demand for settlements.
I understand. Is the $387,000 number in your lawsuit?
Yeah,
It is
When
in
we
there?
start.
Show me where it says that.
it's not here, but
Thank
this-
you. That's all I need to know.
Thank you.
Okay. Now, knowing that, then the first time you've ever asked for a number above and beyond $236,000 was at the start of this trial, correct? There's nothing that's ever been filed with this court that ever says any number other than that 236,000, correct?
Yes, Your Honor.
Okay. Now, sticking with this fraud count, before I move on to the next topic. None of the defendants, whether it was Mr. Khan individually, N Nahar Investment LLC, or TSTT, none of those defendants made any promises or guarantees or represented how much the business was going to make before you signed the contracts, correct?
Yes.
Okay. Now, you've looked at multiple times the purchase agreement, correct?
Yes, Your Honor.
All right. And we've talked about how the grand total for the purchase agreement would be $263,107, correct?
Yes, Your
All right. Okay. Now, going back to your exhibit notebook, like this exhibit notebook. Got it? Exhibit 20.
20. Yes, Your Honor.
Okay. You've got on the right-hand side, all of the payments towards buying 49% of the Chevron. You see that?
Yes, Your Honor.
And that totals $236,750.43, correct?
Okay, Your Honor.
So no, is that what it says?
Would you mind to go back and let me clear this right-hand
Art.
side?
May we approach?
Sure.
What page is 9.1J? I'm just there so I don't get fired, man. You're doing it. We should at least have had one.
Okay. I was given a different exhibit 20. I have the one that ended up getting supplemented. Can I make sure he's looking at the same one? Now, the purchase price from the purchase agreement that you signed
Mhm.
is a grand total of $263,107. That's what it said on the purchase contract, correct?
Yes, Your Honor.
And we've already gone over many, many times
Mhm.
that out of that $263,107, your demand letter, your lawsuit, your interrogatory response, it all says that you paid $236,000 and change of that, correct?
I did not get you. Would you mind to like clear?
The lawsuit, the complaint,
Mhm.
that says 236 and change.
Mhm.
The answers from your interrogatory responses also says 236 and change, right?
Mhm.
And the demand letter said 236 and change, right?
We're talking about before the lawsuit or after lawsuit?
I'm just saying what those documents say. They all say 236, $750.43. We've already gone over that. They all say that number, right? That's what you paid.
Yeah, I already told that answer too.
Okay,
Your Honor.
good. Thank you. Knowing that, and knowing that that's a portion of the total purchase price of $263,107, why would you pay $331,750.43 to own 49%?
Okay.
Why are you paying more to buy 49% than what the purchase agreement says it costs?
Thank you for your question, Honor. I'm awaiting this question. Let me clarify. In previous record also, would you mind? You can check it. I already told you. There is my personal check goes to and Nahar names for some gas, for some rent. Okay. I'm asking that money too. That's why this number is different. Your Honor.
I agree. I see
I
that.
already told you, and we already saw you picture too. I think we have a copy also. I do not want to lie, whatever is straight. That's way it's going. And right now, I'm asking whatever, like I pay on Nahar name, I discuss with my lawyer, and I need all the money. Before to lawsuit, we discuss, we try to like settlement in like peaceful way.
I understand. But
That's
this,
my answer, and that's the reason, Your Honor.
but this entire right-hand column says it's all for just the purchase of the 49%. The left-hand column of $15,982.83, that's the other checks that you're saying you paid personally.
Yes, Your Honor. Let me check the.
Okay, so
Mhm.
what I'm saying is, if this column on the right represents you buying 49% of the business, which according to this totals $331,750.43. Why would you pay more than the required $263,177 for the same 49%?
Your Honor, that's buying 49. Once couple of checks should be like messed up or like I have to not idea, but I don't know why you are coming in same question. I don't know. In my mind, whatever I pay the check, I give to my lawyer, and lawyer also have a special team. They verify everything. All right, and I gave him whatever he said, and I told you couple of Nahar might be it's wrong. It's gas money, EFT already paid over there. And maybe one check or two checks should be like up and down, would be messed up. But like 15 to 10,000, not then more. But I'm still not clear. Your Honor?
I understand. All of these checks
Mm-hmm.
are not under the column that you denote is for the 49% purchase of Nahar. I understand that these are all a summary of all the checks that your lawyer went through you for things like Pepsi, DeKalb County, Star Wholesale. I understand that. And that's also added into this grand total. But this column on the right says this is all of the money that you paid to buy 49% of Nahar. Do you have any idea why this total, not for Pepsi, not for General Foods, why would this total for 49% ownership interest be higher than what you were even required to pay according to the purchase contract, which is $263,107?
Okay.
Objection, Your Honor, asked and answered. We've been over this.
Yeah, I mean, at this point, I think
All right,
it's cumulative. I'll ask you to move on to the next
Okay.
topic.
next question. If this is what you paid, and I'm disregarding for the purposes of this conversation, the other checks, all those checks that you went through with your attorney for Pepsi and things like that. If this is what you paid for 49% of Nahar, Why in the lawsuit don't you have this number? $331,750.43.
Okay, let me clear it. It's click in my mind. I remind you, 25,000 I put in and Nahar personal check, Mr. Khan. Might be could be one time $15,000, another time $10,000. And I put deposit in Muhammad personal account. And that time I wrote it 25,000. That's the profit of store. Might be that number could be like messed up over here, messed up. Otherwise,
Well, I guess let me just end it by asking you this. Is it your position that not only have you paid the entire purchase price, but that you've actually paid extra for the 49%? Is that your position?
no, sir.
Alright, going back to the interrogatory responses, so please go to the defendant's notebook. Exhibit 9. And then we're going to response number 9. Are you there?
Yes.
All right. Do you see at the very bottom, you state that for the closing, you paid $196,000.
Yes, Your Honor.
And in your lawsuit, you say you paid $236,000, right?
Yes, Your Honor.
Okay. And on exhibit 20, this new exhibit 20, you're saying that you paid over $300,000 for the same 49%, right?
Yes, Your Honor.
Okay, thank you. Okay, going to response number 10. Do you dispute that you did not make any payments towards the promissory note? Do you see that?
What's you say, which paragraph?
10.
10?
Do you dispute that you did not make any payments towards the promissory note? Do you see that?
Uh-huh, yes, sir.
Okay. Go to the next page at the top. Now this says plaintiff states that plaintiff did pay one or more payments towards the promissory note. Did you see that?
Yes, I saw it.
But you didn't.
Yeah.
You didn't make any payments towards the promissory note, did you?
I did, Your Honor.
You did.
Yeah.
Well, we looked at the amortization schedule, right? And it was about $5,400 something a month, right?
Yes, Your Honor.
Okay. And you spent a significant amount of time with your attorney going through all these checks that you gave, right?
Yes, Your Honor.
Are any of those checks for that amount? The scheduled payment amount?
Uh-huh. Yes.
There are?
I did not get you. Would you mind?
Well, were any of those checks promissory note payments?
Mm-hmm. Yes, Your Honor.
They-
No.
They weren't.
Yeah. Yes. I did not get you still.
Okay. For all these checks that you produced that you're saying you paid,
Yes, Your Honor.
were any of those checks promissory note payments?
Yes, Your Honor.
There were.
Yeah.
That's your
Yes, sir.
testimony.
Yes, Your
Okay.
Honor.
Go back to your notebook, the plaintiff's notebook. And go to exhibit 8. You see those 3 Bell's Ferry checks?
Yes, Your Honor.
Now, those aren't promissory note payments, right?
Yes, no,
Okay.
Your Honor.
Now, go to exhibit. Twenty 21. You see those checks?
Yes, Your Honor.
Those aren't promissory note payments,
These
are
are
they?
promissory note.
Which one of these checks is a promissory note payment?
I think here 50,000, 25, 25.
What checks?
That's both.
You on plaintiff's exhibit page 66?
Yes, 66. I'm here.
Okay. What are the promissory note payments?
25,000. Check number 1372. Another 1371.
Okay. Now, earlier you testified that those $25,000 checks, which add up to 50,000, that was your earnest money payment, right?
Yes, Your Honor.
Okay. So that's not your promissory note payment. That was the 50,000 earnest money, correct?
Honest money, Your Honor.
So it's
Yes, sir.
not promissory note
No
payments.
promissory.
Flip over 2 pages. There's page 68. There's no promissory note checks on this either, are there?
68.
Mm-hmm.
Okay, let me see. This one 15,000, 1377.
Yeah.
But it's written buying Chevron because of I was paying this profit of the store to Mr. Mohammed Khan's account. So I did not know what should I write over here, a profit or loss. So I wrote down, wrote it. This one promissory check.
Okay. So even though your promissory note payments are a little over 5,000 a month, you're saying that this even $15,000 check is a promissory note payment?
Absolutely, you are right, sir. Not 15,000. I paid him in his personal account 25,000, not in monthly base, like 2 times. One time 15,000, another time 10,000.
Okay.
Still, I have that receipt in my phone. If you would
Okay.
you like to see it, I'll pull up.
Well, if you didn't give it to us before, I'm not terribly interested in it now. What are you claiming out of that $63,107 that you paid under the promissory note? How much of that $63,107 are you claiming that you paid?
Whatever I pay from my Bale's food and my personal account.
I
I'm
understand.
asking those amount. That's it.
How much money did you pay towards the promissory note?
Okay. Promissory note, I paid 25,000.
That's your position.
Yes, Your Honor.
And you're saying that that 25,000 comes from that 15,000 check plus what other 10,000?
10,000 check should be somewhere else. I have to take a look at it, but I have that receipt.
So your monthly payments were $5,344.77.
Yes, Your Honor.
Okay, that's obviously not a round number, right?
Yes, Your Honor.
How did you end up paying 15,000 and 10,000 checks instead of 12 checks for 5344.77?
It's easy. Don't take it. It's complicatedly. I did not pay him like 3 months or 4 months. After 4 months, I paid him once, 2 payment,
Okay,
Your Honor.
got it. So even under your testimony, the payments that you did make were late, correct?
Yes, Your Honor.
And even under your own testimony, you still haven't paid the full promissory note, correct?
I did not get you.
Well, you said you paid $25,000 towards the promissory note, right?
Yes, Your Honor.
And the promissory note is a little over $63,000, right?
Yes, Your Honor.
Okay, so you still owe the gap between the 25,000 and the 63,000, right?
Oh, yes, Your Honor.
Okay. Okay, go to interrogatory response number 14. So again, that's exhibit 9 from the defendant's exhibits.
14.
All right, counsel, I believe we should stop the point. All right, how much time do you think you have remaining or topics?
I don't want to go too low and then.
I'm not saying I'm turning the clock. I'm just trying to get a ballpark figure here. Two like topics or
Topics.
we've got an hour.
Right for today, you asked me how long total.
Here's how much you have remaining. We've got an hour. You said initially you had 2 hours. Do you think you still have about an hour left? Okay. All right. So members of the jury at this point, unless there's a concern with any one of you, let's shorten our lunch break to about 45 minutes. It being about 12:40 now. We'll come back about 1:25. Okay. Please don't discuss the case with anyone, including amongst yourselves, or do any research about the case. We'll see you back at 1:25. Thank you, Deputy Scott. Anything to take up before we recess on the part of the plaintiff,
No, sir.
on the part of the defendants?
No, sir.
All right, we'll be back ready to go. 1:25, sir. You can step down.
Thank you.
We're in recess.
Yeah. Yeah. Charge it. Bring it. Oh, bring it, dude. I don't think so.
Just sent you an email
Okay.
with another one.
Okay, perfect.
I want to use that case. I like that. Huh?
Did the rest of the document look okay?
Yes.
Okay.
Yep. Just want to add that to it.
No.
Yeah.
Thank you, Deputy Scott. Please be seated, everyone. Defense may resume their cross-examination.
Thank you. Mr. Ray, whatever amount that you paid towards this 49% ownership interest for the company, is it fair to say the money wasn't set in some sort of special account? It was just given to the defendants, correct?
Yes, Your Honor.
And they just, as best as you can tell, they just cashed the checks. Is that fair to say?
Yes, Your Honor.
Okay, so it wasn't as though this money was ever going to get claimed back for any reason. It's just money that you gave for the purchase price and nothing else, correct?
Purchase prices plus, that's, I already told you that 25,000 I gave him, Your Honor.
Okay. Okay. If you would, yes, in the plaintiff's exhibit notebook, go ahead and go to it.
Yes, Your Honor, I'm here.
Looking at the purchase agreement, correct?
Yes, Your Honor.
All right, if you would, go to page 6 of that agreement.
I'm here, Your Honor.
You see section 11 is titled Time is of the Essence,
Section.
enumerated section 11,
Wait a minute.
page 6 of the purchase agreement.
This one.
Go ahead and go to page 6. No. Exhibit 1.
Exhibit 1.
Okay. Page 6. Section 11.
Yes,
Okay. You see that's called Time is of the Essence.
I say.
Okay. And
Yeah.
it says Time is of the Essence as to all provisions in this agreement, correct?
Yes, Your Honor.
Okay. And the next section is titled Construction and Survival, correct?
Yes, Your Honor.
All right. Let me know if I misread any of this. This agreement, this purchase agreement of the purchase and sale is the complete agreement between the parties. And any contracts previously executed between the parties, along with such other written or verbal representations or warranties as may have been made by either party, their brokers, their agents, or assigns, are merged in this agreement and are extinguished except as set forth herein. You see that?
Yes, Your Honor.
And the provisions and warranties contained in this agreement shall survive the closing and those instruments and documents attached thereto, correct?
Yes, Your Honor.
Now, I understand that earlier you testified that none of the defendants made any representations or warranties before you signed it, but, correct?
Yes.
Okay, but this is just, to your knowledge, this is just making clear that the only the terms and conditions that are in this document are what are going to control between the parties, correct?
Yes, Your Honor.
Okay. And in that vein, on the same page, section 14 is called Reliance. You see that?
Yeah, I saw it.
And it says, the parties do agree and affirm that no representations, warranties, or inducements are relied upon by either party except as set forth in this agreement. See that?
Yeah, I saw it.
Okay, turning to the next page. And again, we're in the purchase agreement. Section 18, special stipulations.
Mm-hmm.
Okay. Now, Subsection A says indemnification and release of seller. See that?
Yes, Your Honor.
Okay. And the opening passage says that you are gonna assume all claims, liabilities, and obligations of the seller and the lease guarantor under the lease, the gas supply agreement, and the COAM contract that arise from after the closing. See that?
Yes, Your Honor.
So you would agree that starting February 11th, 2022, you are indemnifying the seller from any claims relating to either the lease with the landlord, the gas supply contract, and the COAM contract, correct?
Yes, Your Honor.
And in that regard, the following sentence says, upon this consummation of this transaction, the seller and the lease guarantor shall be released and not liable for any and all claims, liabilities, or obligations arising from or in connection with the lease, the gas supply agreement, the COAM contract, the business as business is defined in the purchase agreement, the company as company is defined in the purchase agreement, or any other contractual and non-contractual claims, liabilities, or obligations arising from or in connection with any other contracts or agreements entered into by the seller, guarantor, and or the company directly as a party or indirectly as a guarantee for or for any matter arising out of the operation of the business and or company incurred after the close. So you would agree, after February 11th, you are the guarantor of those liabilities.
Yes,
correct?
Your Honor.
All right. Now, turning to the next page. Fill in the special stipulations subsection F. Now, this is saying in the beginning that the parties are going to agree to the terms and conditions stated under this subsection, 18F through 18FI through 18F6. Within 10 days after closing, the parties shall enter into an operating agreement of Nahar Investment LLC, informing content satisfactory to seller, hereafter called the operating agreement. The operating agreement shall include, among other terms and conditions, the following material terms. Okay, so before we go any further, even in the purchase agreement, you and the seller had agreed that there's going to be an operating agreement. Correct?
Yes, Your Honor.
And that in that operating agreement, these material terms would be present, correct?
Yes, Your Honor.
All right, so number one, commencing from the date hereof and through January 31st, 2024, defined as the management period. The buyer shall serve as the operator of the business, defined as operator, be solely responsible for all claims and liabilities arising from the operation of the business, including but not limited to claims and liabilities under the lease, the COAM contract, and gas supply agreement. I read that correctly?
Yes, Your Honor.
Okay, so including but not limited to liabilities arising under the lease, the COAM contract, and the gas supply agreement. Okay. 2, during the management period, as same may be extended by mutual agreement of buyer and seller, buyer shall pay to seller $5,000 monthly as guaranteed profits of the company, and buyer, after satisfaction of all liabilities for the operation of business, shall be entitled to the net profits of the business, defined as the guaranteed profits, correct?
Yeah, yes, Your Honor.
Okay, so I just want to be clear. During your management period, as long as you take care of the overhead, and as long as you make your $5,000 payments to Mr. Khan as the seller, any money that's left over as net profit belongs to you, correct?
Yes, Your Honor.
Okay. Now, 3, in the event the buyer fails to satisfy any of the liabilities for operation of the business, including but not limited to default under the lease, the COAM contract, and or the gas supply contract, or failure to pay any and all bills to third parties, to a third party or parties, including but not limited to utilities, phone, internet, insurance, trash removal, inventory, taxes, etc., or fails to pay the guaranteed profits to the seller, or otherwise fails to comply with the terms and conditions of the operating agreement or other obligation arising from operation of the business, then the seller shall have the right to shorten the management period and to remove the buyer from management of the business.
Yes, Your Honor.
Okay, so it's right there, crystallized. If you don't pay the bills on time, if you don't pay the 5,000 monthly payments on time to Mr. COAM, if there's any claims regarding the lease with the landlord, the COAM contract or the gas supply contract, all of those would be independent grounds to remove you as the manager, correct?
Yes, Your Honor.
All right. Upon receipt of notice from the seller, the buyer shall immediately surrender the business, including all assets and business premises, to the seller. The parties shall then share the profits and losses arising thereafter based on each party's percentage ownership in the company. So let's unpack that. When you're no longer a manager, whether you're not a manager because your management period was shortened, or whether you're no longer a manager because the management period ended, i.e. January 31st, 2024. At that point, the arrangement of you getting all the net profits after all the bills are paid and the $5,000 monthly bills or $5,000 monthly payments are paid, and you getting the net profit, that ends. At that point, you are just a 49% owner, correct?
Yes, Your Honor.
And if there was a net profit, Mr. COAM would be entitled to 51% of that net profit, and you would be entitled to 49% of that profit.
Yes,
correct?
Your Honor.
Okay. But while you're the manager, the only money that you're entitled to get are the net profits after the overhead is paid and the $5,000 monthly bills are paid, correct? While you're a manager.
Yes, Your
Okay.
Honor.
Number 4, the buyer shall pay all monthly rental payments due under the lease at least 1 day prior to its due date, right?
Yes,
That's
Your
the
Honor.
rent to the landlord, right? Okay. 5, the seller has absolute right to sell the business and decide on terms and conditions of the sale of the business.
Yes, Your Honor.
Okay. 6, the buyer shall provide to seller on a monthly basis report of sales and use tax returns. Let's stop there so they understand. ST3 reports to the DOR are monthly tax reports that you have to give to the DOR every month, correct?
Yes, Your Honor.
Okay, and that's one thing that you're supposed to provide to the seller every month, correct?
Okay, I'm not clear over here. Would you mind to like repeat it once?
Sure. So the first document or item that you're required to give to the seller on a monthly basis is a report of the sales and use tax return. You see that?
Yeah, I saw it.
And I'm assuming, given your expertise in the C-store gas station industry,
Mm-hmm.
that's referring to the monthly sales tax reports that you give to the Georgia DOR every month, correct?
Yes, Your Honor. Okay, what is your question over here? Do you have a question or just a yes or no?
That's the first item that you're required to give to the seller.
Okay, and what's your question? I got that the question, but what you like, yes or no, or like, let me clarify here, clarify.
The question was for you to acknowledge that language,
Yeah,
report of sales and use tax return, is just one way of saying the monthly sales tax that you have to report to the DOR every month. That you agree that that's what that represents?
yeah, yes. Okay,
Okay. Bank statements, bills and invoices for utilities, etc. Those are all things that you're required to give to the seller on a monthly basis as part of this material term, correct?
okay, you are going to like, according to like a point by point, I got you where you want to take to me, but it's clear, I did not have a bank access. Everything is Mr. Khan on hand. Monthly, whatever sale comes a report that register, I provide him, it still might be in my record, Your Honor.
All I'm asking is that these are the things that you're obligated to do under the contract, correct?
Yeah, it's under the contract.
Okay.
I'm agree.
Now, do you remember how before we had our break, you were saying that you made payments towards the promissory note?
Yes, Your Honor.
And you said that it was $10,000 check and a $15,000 check for a grand total of an even $25,000.
Yes, Your Honor.
Okay. And we established that the amortization schedule shows that it wouldn't be a round number. The payments would be about $5,477, let's say, right?
Yes, Your Honor.
Okay. Now, earlier, we just went over the fact that one of the material terms of this purchase agreement is that you have to pay the seller $5,000 a month.
Yes, Your Honor.
Are you sure that the $25,000 that you're talking about was actually representing 5 of the $5,000 monthly payments that you had to make to the seller, not $25,000 towards the promissory note?
I'm sure. After like 4 or 5 months, I pay him like I did not have a money. That's why I'm sure I paid like a 15,000 and 10,000. I deposit that amount in his account. That's the promissory amount, money.
Money towards the promissory note, not money towards the $5,000.
No, his profit, his side profit.
Okay, thank you. All right, so just so we can move on from that topic, there's no money that was paid on the promissory note. There was money that was paid to the seller for the $5,000 monthly payments, correct?
I lost, my bad.
All right, you've got the promissory note,
Yes, Your Honor.
12 installments,
Mm-hmm.
5,400 and change, let's say.
Yes, Your Honor.
Then you've got $5,000 a month that you have to pay to the seller every month, right?
Yes, Your Honor.
Remember your attorney was talking about, that gets you at a little over 10,000 a month, right?
Yes, Your Honor.
Okay. What I'm saying is, when you testified that you've given $25,000 to the seller, that $25,000 wasn't payment towards the promissory note. It was representative of 5 of the $5,000 monthly payments that you owed as profit to Mr. Khan.
Yes, Your Honor.
Okay, good. Okay, same notebook, your notebook, plaintiff's notebook, number 6, the operating agreement. If you would, turn to page 10 of the operating agreement.
Same book.
Sure. On the top. I got you. Exhibit 6. I got you, page 10. Okay. Section 13.2. I know that we just went over language like this in purchase agreement, but to be clear, we've got a mergers clause, a entireties clause in this contract as well, section 13.2. This agreement contains a complete statement of all of the arrangements among the parties with respect to the company. See that?
Yes, yes, sir.
And then it says, and it cannot be changed or terminated orally or in any manner other than by a written agreement executed by all the members. You see that?
Yeah, I see.
And then again, going back to the merger clause, there are no representations, agreements, arrangements, or understandings, oral or written, between or among the parties relating to the subject matter of this agreement, which are not fully expressed in this agreement, right?
Yes, Your Honor.
Okay. Now, you would agree that there are no amendments to either the purchase agreement or the operating agreement, correct?
I did not get you, Ken.
You would agree that the parties never entered into an amendment to either the purchase agreement or the operating agreement, correct? You never sat down and signed a something to change any of the two documents?
Never.
Okay. Okay, now, turn to the next page, please. Special stipulations. See that?
Yes, I
To the
see.
extent that any of the following special stipulations is in conflict with any other terms or conditions of this operating agreement, the following special stipulations shall control, right?
Yes, Your Honor.
Okay, so for the special stipulations, if there's anything that is contradictory in this contract from these terms control, correct?
Yes, Your Honor.
Now, I won't take up too much of your time on this because we just went through it on the purchase agreement. But section 14.1. You would agree, this is saying that you're gonna be the manager, correct?
Yes, Your Honor.
Okay, and your management period is gonna be from February 11th, 2022 to January 31st, 2024, correct?
Yes, Your Honor.
And you are gonna be solely responsible for day-to-day operations of the business,
Yes, Your Honor.
perform all management duties as defined hereinafter,
Yes, Your Honor.
and you are going to satisfy all claims, obligations, and liabilities arising from operation of the business of the company,
Yes, Your Honor.
including but not limited to claims arising under the lease, the coin-operated music machine contract, and the gas supply contract, correct?
Yes, Your Honor.
Okay. And you signed this bottom passage, so now we're at the top of page 12, saying that you agree to carry out the duties and operation of the business in good faith with your best effort and in full compliance of all laws.
Yes, Your Honor.
And upon the expiration of the management period, Muhammad Khan shall have the right to take over the business and manage its day-to-day operations.
Yes, Your Honor.
Okay. And then A through J defines what your management duties are, correct?
Yes, Your Honor.
Okay. Now, just as with the operating agreement, the next section at the bottom of the page, 14.1, says that you're obligated to pay $5,000 a month to Mr. Khan during your management period. correct?
Yes, Your Honor.
Okay, turn to the next page, please, section 14.4. Again, I know this was part of the purchase agreement as well. In the event Dinesh Ray fails to satisfy any of the liabilities for operation of the business, including but not limited to default under the lease, COAM contract, and or the gas supply agreement, or failure to pay any and all bills to third party or parties, including but not limited to utilities, phone, internet, insurance, trash removal, inventory, taxes. Sorry for that. Great point. Or fails to pay the guaranteed profits to Mr. Khan, or fails to comply with local, state, and federal laws that govern operation of the business, or otherwise fails to comply with terms and conditions of this operating agreement or other obligations arising from operation of the business, then Muhammad Khan shall have the right to shorten the management period by notice specifying the last day of the management period and to take possession of business and all business-related assets located therein and to remove Dinesh Ray from management of the business, correct?
Yes, Your Honor.
Okay, now, skipping to the bottom in bold. Now, this also establishes what the initial inventory was which was on the purchase agreement as well, right? $104,911.76, correct?
Yes, Your Honor.
Okay, and it says here that if you have a inventory shortfall when your management time ends, you're responsible for the delta, the gap, right?
Absolutely, yes.
But
Your
if
Honor.
there was a overage, you would be reimbursed if it was more than $104,000 of inventory.
Yes, Your Honor.
Okay. But when you left on November 11th, 2023, there was a shortfall, correct? There was less than $104,000.
I do not accept that number, Your Honor.
Well, I'm not even mentioning a number.
No. You whatever saying, that means that's how did you say short or like over?
Okay.
My question is that, so how did I accept that?
Short.
Like, you gave Jack exact like answer short. How did I accept that? That was short or like over? So,
I say shortfall. Oh,
so I request you, was not short. I did not agree with that number.
Well, the only number I've said again is the 104,000.
Yeah, I accept that one. I already told you, I accept that one. But what number, like when he fired me, he did like his people within 10 minutes. I never signed over here. I did not accept that one. So please take back that word and like use different word. I do not accept the short one.
I'm not asking you whether or not. I've even shown you the number that we're claiming was representative of the inventory on November 11th, 2023. I'm not asking you to accept that number. I haven't even shown you that. I am just asking.
No, I take that, but you told me like,
Do the question asked and answer that question.
I am just asking if on November 11th, 2023, when your management period was cut short, that if you agree that the inventory was whatever degree, that it was less than $104,911.76.
yes, according to that, that's that day inventory, but I did not accept that.
Well, now you're confusing me. Are you agreeing with my statement that it was less?
Yeah, it was.
Okay. Turning to the next page, section 14.8. This is with the purchase agreement. This is a recap of what you're supposed to provide to Mr. Khan every month, correct?
Yes, Your Honor.
Okay. And then lastly, on page 16. In bold. It says the members plural.
Excuse me, which word is it?
In
What's,
bold.
okay, yeah, I got it. Thank you.
Members.
Thank you. Your
The members hereby agree
So
that.
just pause just for a second. Okay, did you just do that in place? Will you just hold for a second? Okay, we just hold in place for
Yeah.
a second. All right, you can proceed.
In the middle of this paragraph in bold, it says the members hereby agree that the net value of the company is currently $400,000 plus value of inventory at cost and amount of deposits with the landlord, the jobber, the vendor, and utility company equals the total capital contribution of the members. You see that?
Yes, Your Honor.
So you and Mr. Khan are the only members, correct?
Yes, Your Honor.
All right. Now, earlier when you were being asked questions by your attorney, and he emphasized the fact that even after the bills that had to be paid every month, you would be required to pay a little over 10,000 on top of that between the $5,000 to Mr. Khan and the promissory note payment.
Yes, Your Honor.
And you said that you hope you could manage that, right?
Yes, Your Honor.
Okay. And you would agree that sometimes people enter into businesses thinking that they're going to be successful, but sometimes they fail, right?
Yes, Your Honor.
Okay. Now, you were the manager of the Chevron for 21 months, correct?
Almost, Your Honor.
February 11th,
Yes, Your Honor.
2022. I'm sorry, February, yeah, to November 13th, 2023. I think it was what it was, but February of 2022 to November of 2023, correct?
Yes, Your Honor.
All right. So earlier you testified that you had written checks to pay for things like Star Wholesale and Pepsi and beer, correct?
Yes, Your Honor.
But the contract says that's what you're obligated to pay, correct?
Yes, Your Honor.
And you testified that sometimes you would even have to get Mr. Khan to get a check from him because vendors were waiting, right?
Yes, Your Honor.
So sometimes Mr. Khan would actually pay for vending bills that were your responsibility, correct?
No, Your Honor.
But you're responsible for all bills, right?
Yeah, yes, Your
So
Your
why
Honor.
would you ever need to ask him for a check to pay for bills?
Your Honor, I already told you that I did not have a check. He did not like provide me check. I already told you that. He used to provide like a 1 page, like 3 page. And I have limit vendors. I have to pay limit, like that's all purchases. So I'm not asking he has to pay from his pocket or somebody else. I'm asking him provide this company check so I can pay to the company, like vendors. That's all, Your Honor.
But at the end of the day, that's your that's your liability. You're responsible for making sure that those bills are paid, correct?
Absolutely my responsibility. But whatever like had account in business account, I had to pay through by that. But I was not allowed. Yes, sir.
Now earlier, you testified that you're only a 49% owner, correct?
Yes, Your Honor.
And that the decisions for the business still rest with the majority owner, correct? 51%.
Oh, yes, Your Honor.
Okay. But that's just one of the terms that you agreed to in the contract, correct?
Yes, Your Honor.
Okay, so you agreed to allow Mr. Khan to make decisions about certain aspects of the business, correct?
Yes, Your Honor.
Okay, well, wouldn't you agree that the banking information is a pretty big decision for the company?
Yes, Your Honor.
Okay, thank you. And even though the majority ownership has the right to make these big decisions, we've already established that you're operating the store on a day-to-day basis.
Yes, Your Honor.
Correct? Okay. So you're making those day-to-day decisions in his absence, correct?
No, Your Honor. He's made to decision whatever I used to sell and whatever I make to order, and I sent him. Okay.
Let's put it like this.
Yeah.
If he's not there,
Definitely, yes,
who's
Your
the
Honor.
manager?
I was.
Okay, so you're making the decisions.
Yes, Your Honor.
Okay. And I think you testified earlier that there were conversations that Mr. Khan had with you about problems that were happening at the store, correct?
Yes, Your Honor.
Some of those problems being you not paying for the things that you were supposed to pay for, correct?
There was, what kind of, I did not get you, Your Honor.
Sure. Wouldn't you agree, or isn't it fair to say that part of these conversations that Mr. Khan had with you were at least in part talking about bills getting paid, his $5,000 a month getting paid? Is that fair to say?
Yes, Your Honor.
Okay. And we've already established that if those bills don't get paid, or if there's a breach of the COAM contract, or if there's a violation of the law, he has the right to insert himself and become the manager, correct?
Okay, Your Honor, can I like,
Well, right
Accept-
now, all I want to know. is
okay,
do
yes,
do
you
what
are
the
right.
says?
Okay.
Okay, so it does say that. If you want to explain something about that, you can. Or we can go to the next. one.
No, you have a question, like same question is coming, okay? But I already told you that why I paid whatever like 15, 25,000, I paid it, that's like profit and your, what's called promissory. And after that, you are saying I have to pay that bill, but I did not have the like account access and even like check. So whatever I had, I did.
I got it, but you would agree that the nature of these conversations, at least in part, has to do with the fact that not all the bills are getting paid on time or they're delinquent, things like that, correct?
Yeah, according to that point, yeah, you are right.
And you would agree that just because you own some sort of interest in a company, it doesn't give you automatically the right to make all the decisions on behalf of that company, correct?
Sorry,
Well, do you own stock in any companies?
no.
Okay, but you know what stock is, correct?
Yes, Your Honor.
Okay, so if you decide tomorrow that you're gonna buy 1,000 shares of Apple, you don't get to decide how Apple is run, right? You-
Yes, Your Honor.
Okay. And just to crystallize this point, all of the back and forth that you had with your attorney earlier today about these checks that you paid to Pepsi, to Star Wholesale, to General Foods, you were required to pay those under the contract that you signed, correct?
Yes, Your Honor.
Okay. So you would agree, whether it was money towards buying 49% of the company, or whether it was money that you paid for vendors or for rent, all of the money that you paid was because the contract said you were supposed to pay those monies. correct?
Objection, Your Honor, that's not what his testimony was.
I won't sustain that objection. I'll say that we've covered this a topic, I think, at length, and so it's time to move on to the next one.
Understood. Thank you, Judge. Now, at no time did we ever see in the operating agreement or the purchase agreement anything about you getting extra money for just general employee wages, did we?
Yes, I did.
No. There was nothing in the operating agreement or the purchase agreement saying that you were entitled to those, correct?
Still, I'm not clear, Your Honor.
Well, I think we covered that the only money that you were supposed to get as the manager was if there was a net profit after paying the bills and paying the $5,000 to Mr. Khan, you would get the net profit. right?
Yes, Your Honor.
It didn't say anything about wages on top of that, correct?
No, Your Honor.
Okay, but nevertheless, you received wages for the time that you worked there, correct?
Yes, Your Honor.
Earlier, we established at the outset of my conversation with you that you want to rescind the deal and unwind everything, right?
Yes, Your Honor.
Are you gonna give that money back?
Okay, let me,
Are you gonna give the money back
to whom, Your Honor?
to Nahar Investment LLC?
Why, Your Honor?
Well, you said you wanted to undo the deal, right? You want to go back to where.
No, I do not want to go any deal, okay? And Nahar, you are right, whatever I signed. Let me like clear why I get the payroll. When machine bus stop, Then after, he offered me payroll and take the check and cash levy. That's my like employee. Before that, we did not. And right here, another thing is your last question was like, I do not want to go any deal with an Nahar.
You what?
I do not want to go any deal with Nahar.
I agree.
Okay, he has not like uh, he has not completed his promise according to like company and company policy, Your Honor.
I understand.
So you are asking like 120, I did not get over here, that's amount. How did it come and how did you ask me?
All I'm saying is that you acknowledge that you received compensation in hourly wages, let's say, from Nahar, correct? Even though they didn't have to give you that under the contract, correct?
That's, yeah, under the contract, you are right, absolutely.
Okay, now. I think you said in June or July of 2022, there was a raid by law enforcement, right?
Yes, Your Honor.
In June and July of 2022, you were 4 to 5 months in your management period, correct?
Yes, Your Honor.
So you said that they busted the store for cash payout, correct?
Yes, Your Honor.
Workers at the store were illegally paying customers cash.
Yes, Your Honor.
And as a result, that breached the COAM contract, correct?
Yes, Your Honor.
And it breached the provision in the operating agreement that says you're gonna make sure that the store doesn't break any laws, right?
Yes, Your Honor.
Now, you were also saying that the COAM was a big revenue getter for the store, right?
Yes, Your Honor.
Okay. And you said that you thought that by having those revenues removed, the sales went down 10 to 15%, right?
Yes, Your Honor.
Okay. Well, whatever the revenue was, that's how much money those COAMs were making when they were being used illegally, right?
Yes, Your Honor.
Okay. So you don't know what the COAMs would make if they had been in compliance with the law.
No, Your Honor.
Now, you said earlier, correct me if I'm wrong, that you started noticing problems with the business on day one, right?
Yes, Your Honor.
But you ended up, we already established you were a manager for 21 months, correct?
Yes, Your Honor.
Okay, so even though that there were these problems that you noticed, you decided to stick it out and continue to try to make a go at it, correct? Go of it.
I did not make the decision, but when that machine was stopped, I talked to Mr. Khan, and he came in his store. We discussed informally, and he told me, he offered me, okay, he did not want anything. Let machines comes back, then we'll go as usual our contract. That's why he convinced me.
I guess, let me break it down like this. It's day one, it's February 11th or February 12th. You notice problems.
Yeah.
Right?
I noticed it.
You still decided to be a manager there, just despite the fact that you saw these problems, correct?
Yes, yes, Your Honor.
Now, earlier, you made a point to your attorney to say some of these problems was, well, I found out that there's a lot of crime, there's drugs, there's shootings, right?
Yes, Your Honor.
But you literally came from a gas station that was across the street.
Yes, Your Honor. Yes.
So it's not like your store was in a different neighborhood than the Chevron. The same neighborhood, right?
Same neighborhood, but different scenario.
Okay. But it's across the street.
Yes, Your Honor.
Okay. So even though there's drugs and crime at or about the Chevron, you knew that before you decided to buy a piece of that Chevron.
Yes, Your Honor.
And even though you're claiming that there were some sort of discussions about changing what you might owe as the manager or how you're gonna get compensated as the manager after the COAM bust, you would agree that none of that was reduced to writing, correct?
I did not get you, Your Honor.
Well, I understand that your testimony is that there was some sort of discussion that maybe there was going to be a change in the arrangement of how you would be the manager or how you would get paid, right? You're saying that there was discussions about
Yeah,
that
yes, Your
around the
Honor.
time of the raise.
Yes, Your Honor.
Okay, but you never actually amended or modified the contract, correct?
Yeah, I talked to him, but he said, no worry. It's like, it's not necessary. Trust me. I depend on his word.
But we just established that to amend the contract, both parties got to agree to it in writing,
Okay,
right?
yes, Your Honor.
And that never happened.
Never.
Now, you would agree that when you left as the manager on November 11th, 2023, you had not yet paid all of the promissory note, all of the bills, and all of the $5,000 monthly payments to Mr. Khan. I'm not asking you to decide how much of it you paid, just to be clear. I'm just asking that you would agree there was still money owed based on what you had to pay in the contract.
According to paper, yes, Your Honor.
Thank you. Now, earlier, I believe your attorney asked you after you were removed as the manager, right?
Yes, Your Honor.
If you had any more communication, and you said you didn't, right?
I did not, Your Honor.
Okay. Well, do you recall having a meeting with Mr. Khan on January 3rd, 2024?
No, Your Honor.
Okay. Do you recall getting a taped conversation, video tape from my office to your office documenting that conversation?
When, Mr. Honor, when did you say it?
Have you
After that-
have you ever seen the video that my office gave to your attorney's office showing a meeting that you had with Mr. Khan that was videotaped and
No,
recorded?
not.
Never seen it?
Never seen it.
Okay. Well, let me ask you, now that I've said that, are you sure at the beginning of January 2024 that maybe you had a meeting with him,
To whom?
Mr. Khan?
Might be I meet after that because of there was some like issue of that source, like DeKalb County has been like seized couple of items. All right. And DeKalb County sent the letter and come to pick up. And that time I did. That's
Okay. So even though earlier you said you didn't have any communication after November 11th, 2023, now you're remembering that you did.
yeah, I did, but for that issue.
Okay. Do you remember that as part of that conversation, you saying that you admit you still owe him some money?
No, I did not care because I did not say anything to him because whatever he number gave me, that was not like a clear and exact. That's why I did not.
All right. Now, during this 21-month period that you were the manager, based on your complaint, you're saying that and your testimony from earlier, the business was not profitable, correct?
During my time,
Yeah.
it was not, definitely.
So if the business wasn't profitable and your contract says you only,
I think we did cover this.
all right.
Keep going.
Okay, during the 21 months that you were the manager, Well, do you have any text messages, emails, or documents, anything during the time that you were the manager where you were asking for any financial information from Mr. Khan?
Yeah, I did.
You have text messages, emails, and letters?
No emails, no letters, but whenever I have to purchases, that time when I told him I needed some stuff for his store, at that time he used to like do the screenshot and used to send in my message.
Okay. So all this talk about cash distributions and things like that, you would agree there's no cash to give to you because we're not at a profit, correct?
Yes, Your Honor.
Okay. And okay, even after November 11th, 2023, do you have any documents ever where you're asking him for anything related to taxes?
I got only WT. I was asking only WT, and I did not go any through like other documents because he has the first questions. Whatever number he had, he showed me that number, give my number. Even he did not give me like account access. How did he like provide me?
I
Your
understand.
Honor.
I'm just asking, do you
No,
have any document showing where you've ever asked for any of this information?
I did not, to be honest.
Okay. Now, earlier in this trial, you were here when Mr. Khan testified about the net profit, net loss of the company, correct?
Yes, Your Honor.
And he was able to refresh his memory by looking at the tax returns, correct?
Yes, Your Honor.
And if you recall, in 2022, that figure was negative $17,000 and change, right?
Definitely that will be,
Okay.
it would be in us 2022, Your Honor.
Right. And for part of that 2022, you had gaming, right?
Yeah, it was like just 4 months, 7, 8 months. Yeah, Your Honor.
Okay. So even the games being there, and even with the games being run illegally to make more money, the business was negative 17,000 for that year, right?
Yes, Your Honor.
Okay. So do you have any reason to doubt that after you left, and even if games got put in, that in 2023 and in 2024, that the net profit for the business is anything other than what Mr. Khan said it was from his testimony yesterday?
Okay, Your Honor, let me little bit. I claim in my experience, I do not say every store, convenience store. Most of the convenience store they do not show exact whatever they have in record, sales record. So, in my experience, 2022 it was definitely it was in lost, but 23 I do not guess so. In my experience, I am not like expertise.
It's not your expertise.
Yeah.
But not only that, we've already established you don't have anything where you ever asked him to dispute those numbers, correct?
I did not ask, to be honest, Your Honor.
And so even if in your experience, people fudge a little bit on their tax returns, in 2022, you're acknowledging then that a $17,000 net loss is even after fudging on those numbers, correct?
Maybe, Your Honor.
I mean, extrapolating your logic, right?
Yeah, maybe, Your Honor.
All right. And just to be clear, as you decided to purchase 49% of this business, you never asked for any, if they even existed, P&Ls or bank statements for the store for 2020 or 2021, correct?
Your Honor, I already told you, even we did not do like a two-way conversation on phone. I used to like call like more than 15 times. One day, I already told he came to in my family. Then that day, thank you, I said, Your Honor.
Right. I'm just saying to be clear that before you decided to buy a piece of the Chevron, you never even asked to look at any records relating to its finances, correct?
Yeah, I did not ask
Okay.
to be.
All right. All right, now, please go to the defendant's exhibits. We've already taken a peek at this, but it's your lawsuit. It's exhibit 7. Let me know when you got it pulled up. You have it?
Exhibit, which one?
7. Yeah, you see it, your lawsuit?
Just a moment. Might be I lost over here.
Me to check it out.
This one or that one?
I can take a peek. Thanks. All right, flip to paragraph 8, please.
8?
Yep.
Yes,
Now,
I
in the lawsuit, you said that the defendants made various representations regarding the business that turned out to be false. You see that?
I didn't get you. Like, just a moment. You say 8?
Uh-huh.
Uh-huh.
See that?
Yeah, I saw here.
Okay. But today we've established that none of the defendants ever made any representations about the business, correct?
Yes, Your Honor.
Okay. And you just decided to act based on your experience in the industry.
Yes, Your Honor.
Okay. Number 12, please. Shortly after entering into the agreement, operations of the COAM machines were compromised
Hang on.
due to no involvement with the plaintiff.
I lost here. Yeah.
Number 12, paragraph 12. I think you were on paragraph 7, now we're on 12.
You were 7. What's it?
It's the same document,
Huh?
exhibit 7. We're just now on paragraph 12. That's it, that's 8.
8.
Yeah. Can I help?
Yeah, please. My bad.
See number 12?
Yes, I saw.
All right. So not to get into semantics, but I think we agree that the COAMs were there for several months before the raid happened, correct?
Yes, Your
It
Honor.
was like, I think you said the summertime.
Yes, Your Honor.
Okay. And although you say due to no involvement of plaintiff, we've actually established that in the summer of 2022, you were the manager of the Chevron.
Yes, Your Honor.
Okay, go to number 18, please. You claim that the defendants breached the contract with plaintiff by terminating plaintiff's employment with the business. Do you see that?
Yes, Your Honor.
But we've already established that if any of the terms and conditions of the operating agreement or purchase agreement are not met, then Mr. Khan had the right to shorten your management period time, correct?
Correct, according to paper. Yes, Your Honor.
Okay. So Mr. Khan was simply acting within his rights under the contract to remove you as the manager prematurely, correct?
According to paper. Yes, Your Honor.
Okay. Now, 19 says defendants breached the contract with plaintiff by terminating plaintiff's ownership interest in the business. Do you see that?
Yes, I saw it, Your Honor.
Is it fair to say you have no document ever at any point in time from any of my clients saying we're terminating your 49% interest? You would agree with that, right?
Yeah, I'm agree with this.
Okay. And number 22, you claim that that's the number, that's the principal number that the defendants are indebted to you for, correct?
Yes, Your Honor.
All right. And it's the $236,000 number, right?
Yes, Your Honor.
All right. Okay. Now, in that same trial notebook, please go to exhibit. Six. Now, we already established that in May of last year, your lawyer wrote a demand letter to my client, correct?
Yes, Your Honor.
Okay. Have you ever seen the response letter that my office sent back to Mr. Collins?
Yes, I saw it.
You've seen this before?
Yes, Your Honor.
Okay. Judge, I would ask that Defense Exhibit 6 be admitted into evidence.
Objection to D6.
No objection.
It's admitted.
Okay. Now, I know when you got it up. Go to page 2. All right, please go to page 2.
Page 2.
Now, do you see at the top, we've sort of superimposed a portion of those management obligations that you had in the operating agreement and the purchase agreement, correct?
Yes, Your Honor.
Okay. And we've articulated our counterclaim figure of $338,378.85. Do you see that in the middle of the paragraph?
Yes, I saw it.
Okay. And during my opening, I don't know, do you recall seeing that exact same number on the PowerPoint slide? This is what we're asking the jury for, $338,378.85.
Yes, Your Honor.
Okay. Now, the first item is $5,000 cash due at closing. You see that?
5,000. Yes, I saw it.
Now, granted, I understand that now, today, frankly, for the first time ever, you're saying that you paid in excess of $300,000 for the purchase price of En Nahar.
Yes, Your Honor.
Okay. But earlier, when we were looking at those interrogatory responses, you noted that you had paid $196,000 at closing. Do you remember that? When we looked at that answer?
All right, we covered this.
Well,
We can get to the next question. I think I can see where you're going, but we don't need the build up because we've already covered that.
all right. All right. Item number 2, you owed $5,000 a month in monthly fees to Mr. Khan, right?
Yes, sir.
Okay. And you were a manager for 21 months, right?
Yes, Your Honor.
So in footnote number 1, we gave you credit for the $25,000 that we just readdressed after this lunch break. Do you see that? Buyer was to pay seller $5,000 per month for a total of $105,000 over the 21 months he was in possession of the store.
Mhm.
To date, buyer has paid only $25,000 of these amounts to seller. Do you see that?
Yes, Your
So we
Honor. I
did
saw it.
give you credit for the $25,000, right?
Yes, Your
But
Honor.
that would leave $80,000 left, right?
Yes, Your Honor.
Okay. Then we have $128,292.50 of various fines, fees, taxes, utility bills, insurance, and other out-of-pocket expenses occurred in keeping the store stocked and running both prior and after buyer's departure. Do you see that?
Yes, I saw it.
Okay. And we've already established that fines, fees, taxes, bills, those are your responsibility.
Yes, sir.
Correct? All right. 4. We've established that there are no payments that were made under the promissory note. There were only payments that were made towards the $5,000 monthly payments that you had to give to Mr. Khan, correct?
Yes, Your Honor.
All right, so that would still be owed. And I understand that you might not agree with this, but that the delta, the gap between the inventory amount that was counted when you started on February 11th, 2022, and when you departed on November 11th, 2023, was $61,979.35, right?
I say,
Now, to be clear, if that's right, if there was a $61,000 gap in inventory, according to the contract, you would be responsible for that, if that was the accurate number, right?
yes, absolutely, yes.
Okay. Now, it says here that it appears from your letter that you wish to relinquish your rights in the company, the 49%, okay? Based on the letter that your attorney wrote in May, that you wanted your money back, right?
Yes, Your Honor.
And when we started our conversation today, you made clear you want your money back. You want to go back to where there was no deal with Mr. Khan, right?
Yes, Your Honor.
Okay. And we said that's fine. But then you've got to take off the $338,000. I'm sorry. You've got to, you will still have a delta of $143,375.85. So according to your lawyer's letter, you paid $236,000, right?
Yes, Your Honor.
And according to our letter, you owe $338,000, right?
Yes, Your Honor.
So even if we gave you back your 49%, according to that math, you would still owe over $140,000, correct?
Yes, Your Honor.
All right. And now, 6 is already in, correct?
It is.
I believe we covered this material, Judge, so I'm just skipping through it. Now, you would agree that just because you didn't make as much money as you had hoped to make, that in and of itself doesn't give you the right to get all your money back, right?
No, Your Honor.
Okay. If you would, just go to your interrogatory responses. So that's defendants exhibits 9. Go to number 15, no,
9 and 15.
please.
I try my, let's see. Fifteen right here.
Okay, got it? Number 15 asks, do you dispute that you have never been released or terminated, I'm sorry, as a 49% owner of the company? You see that?
Yeah, I saw it.
And even as of the date you answered these interrogatories, you said that you believe you still own 49% of the company, right?
I have one, I don't know how to say. You, according to you, still I own this company 49%. You're right. That's your question, Your Honor?
I am literally just asking if you agree that the words on that piece of paper from you say that as of the date you wrote these, you believed you owned 49% of the LLC. That's what this says, right?
I believe, but in practice, I did not get anything, so I do not believe now.
Okay. When you say you didn't get anything, you mean you didn't get any money, right?
No, I paid the money,
No,
but
no. When you say you didn't get anything, you mean you didn't get any money, right?
yes, Your Honor.
But if there's no profit, what money would there be to give you?
I'm not asking the profit, Your Honor. I'm asking here, yes, do you, this means 49% you are saying still I owe, like I'm a partner, 49% of this company. Means I do not get any certificate whenever he verify, okay, you are this company of 49%.
Okay. You don't have a stock certificate?
No, I don't have anything.
You have a purchase agreement that says you own
Yeah,
49%.
just say purchase agreement and whatever I pay in my bank account, like check, that's all.
And you have an operating agreement that says you're
Yes, Your
49% owner.
Yes, Your Honor.
And the day that you wrote these answers, you said you still believed you were a 49% owner.
I do
right?
not believe so anymore, Your Honor.
On the day you wrote these, you believed you were.
Yeah,
And
at
she
that
asked
time.
and answered?
Thank you. On the day you
All
wrote,
right, well,
okay.
I think we.
I fully comprehend the notion that you're asking this jury to undo and unwind the deal. I understand that. Okay?
Yes, Your Honor.
We covered this, Judge. I'm just skipping through it. Please go to number 24. Do you dispute that the company lost its coin-operated amusement license during the management period as defined in the operating agreement? See that?
Yeah, I saw it.
At the bottom, you say plaintiff states that the license was suspended for 1 year prior to plaintiff taking over management. Do you see that?
Yes, I saw it, Your Honor.
Well, that's not accurate, is it?
This is accurate, Your Honor.
Well, it wasn't suspended 1 year prior to you taking over as a manager. It was suspended 5 months after you were the manager, right?
Yes, Your Honor.
So this answer is not accurate.
No, this is an accurate answer, Your Honor.
Accurate?
No, let me see. Give me a second, okay? Yes, Your Honor.
Okay. So is it fair to say that that answer, that the license was suspended for a year before you took over, that is inaccurate? That is not correct. Is that fair to say?
Before I took over,
Uh-huh.
uh,
You had COAMs when you became the manager, right?
yes, Your Honor.
And they got suspended 5 months after you were the manager.
Yes, Your Honor.
Okay. Number 25. Remember how we talked about a meeting, or I asked you about maybe a meeting you had on January 3rd, 2024?
With Mr. Khan?
Mm-hmm.
Yeah, I did, but
Okay.
okay. My bad.
Number 25, do you dispute that during the recorded conversation tendered to your attorney, you admit and or acknowledge that you owed money to defendant Khan? Do you see that?
Yeah, I saw it.
Now going down to the bottom, plaintiff states that plaintiff admits that money is owed to defendants under the various agreements. Do you see that?
At the where?
At the bottom, defendant states that plaintiff admits that money is owed to defendants under the various agreements.
I did not get over here.
You see it?
I did not get it.
Okay.
Here or- Yes.
Plaintiff states that plaintiff admits that money is owed to the defendants. You see that?
Yeah, I saw it.
Okay. And then it's, well, first of all, knowing that that was the answer to that question, do you dispute that during the recorded conversation tended to your attorney, you admit and or acknowledge that you owed money to defendant Khan? Are you sure that you haven't watched that video?
I did not.
Okay. If you never watched that video, how could you answer a question about the video?
Which one video, Your Honor?
Well, this question is asking about the recorded conversation that we gave to your attorney, right?
Yes, Your
You're
Honor.
saying you never watched it.
I did not, Your Honor.
If you never watched the video, how can you answer a question about the video?
No idea about this one.
You have
Your
no
Honor.
idea. Okay. Now, it goes on to say, but that money is far outweighed by the money owed to you, owed by the defendants to you for misrepresentations of the business, right?
Yes, Your Honor.
Okay. Now, to be clear, you have not articulated any monies that are owed by the defendants to you other than simply saying, all of the money that I ever spent on the Chevron, I should get back. Is that a fair statement?
Yes, Your Honor.
Okay. Nothing further, Judge.
All right. Let me first ask, plaintiff expect redirect?
Yes, I have some redirects, but probably about 15 minutes or so.
Okay, members of the jury, do you want to time now? Or do we want to go forge ahead with that? Okay. Plaintiff, floor is yours.
Thank you, Judge. So let's go to our notebook, plaintiff's notebook. If you would, please turn to tab number 8. This is on page 45. You have that in front of you? Pardon me?
Yes, I do.
So
Oh, just on a page number. Okay, give me.
48, 45 is at the very bottom of the page.
Yeah, yes, I have.
Okay, so these are the 3 checks that you received through discovery from the defendant, right?
Yes, Your Honor.
And these are all checks that you testified to that you signed and sent to them.
Yes, Your Honor.
Were 2 of these checks not in your records at the time we sent our demand letter?
I'm not sure about that.
Okay, so the difference between the amount of money in the demand letter and the amount of money we're seeking today is in fact the value of 2 of these checks.
Oh,
Would that be correct?
you are right, Your Honor.
So in fact, the difference is $95,000. So that would mean that there's a $45,000 check and a $50,000 check that are not in your calculations when we sent our demand letter, right?
Yes, Your Honor.
Do you see any checks on here that would qualify for that? A $50,000 check and a $45,000 check.
Yes, Your Honor.
What checks are those?
Those it's called. I wrote to Muhammad Khan.
Okay, what's the check number?
Check number 1374.
No, for $45,000?
For 45,000. Okay. Yeah, check number 1376.
Okay, and what's the date of that check?
02/18/2022.
Okay, and is there a check on there for $50,000?
Yeah. Okay.
And what's the check number on that one?
Check number 1375.
Okay, and what's the dollar amount?
50,000.
And who was that written to?
Muhammad Khan.
So if these two checks are added in, is that how you get to the dollar amount that you're asking the jury to award you today?
Yes, Your Honor.
Okay. Let's go to page 41, which is part of, I think it's the operating agreement. So that would be Exhibit 6, page 41. Let me know when you see that.
Yes, Your Honor.
You have that in front of you?
Yes, Your Honor.
Okay. Now, during your testimony on cross-examination, opposing counsel talked to you about Mr. Khan making decisions, right?
Yes, Your Honor.
What does the agreement say about his right to make decisions? Right there in front of you.
It say following the decision of company shall require it the following constants of membership interest.
Then for what kinds of decisions?
I don't know what.
What does it say?
All decisions say.
And what does it say as a vote?
A member interest over 50%.
Okay, so that means for all decisions, only Mr. Khan can make those decisions.
Yes, Your Honor.
Okay. Now, when you made all these agreements, was there any indication that these all decisions included the right to not allow you to have access to the bank account?
No, Your Honor.
In fact, wasn't Mr. Khan instructed at closing that he had to add you to the bank account?
He did not.
I mean,
Yeah.
didn't the closing attorney?
Objection, that was.
Okay,
hearsay.
closing
Hold
after.
up, hold up, hold up. We got a hearsay objection. I'm not familiar with it, or unless you've got an exception that you think would apply.
Your Honor, this is, I would say it doesn't go to the, truth of the matter asserted, it's just to say that he was on notice.
All right, I think it is being offered first truth, so I'd sustain that unless you
Okay.
want to bring it up later after a break.
Okay. Let's talk next about the wages. I believe your testimony was that you started getting paid for the work that you did for the company when you started running a regular shift, right?
Yes, Your Honor.
And when did this occur?
Like after like 8, like one game machine bust up, like.
So after the COAM license was suspended, was that part of your overall agreement with Mr. Khan?
Yes, Your Honor.
Now, refresh the jury's recollection. What all was involved in that agreement with Mr. Khan?
That's agreement according to Mr. Khan and we. Like I take the like whatever money little bit in like WT, like certain amount, not like big profit. And that until like a game machine will back up.
And so you were going to get paid for the work you did
Yes,
on an
Your
hourly
Honor.
basis, right?
Yes, Your Honor.
And then was that also the time that you made the agreement about the profit, the guaranteed profit?
No.
Tell the jury when you made the agreement to suspend the guaranteed profit.
After that, when machine bust up, then we agreed between me and him, agreed that he did not ask any like profit because it was low, so business went down. So at that time, I was trying to get out from the business, but he offered me, okay, he did not ask any profit, just keep running. Whenever game machine will come back, then let's do like continue or we'll start a new policy.
And what about the payments due under the promissory note?
Under the promissory note, I have to do him like 5,000 profit plus like inventory.
So,
agreement.
no, I'm talking about, did you agree to suspend or did he agree to suspend the promissory note payment?
Yes, Your Honor.
And when was that agreement made?
Made after that, like 8 means August or September, something like that.
So it's right
September,
after the
yeah.
COAM license
Yeah.
was suspended. Talking about the COAM cash payments. Was that something that that was a standard practice in that store prior to you coming in?
Before I coming, same thing was happening.
And what would have happened if you had stopped that practice?
Means I did not get you.
Pardon me?
I did not get you. Was you?
If you had ordered all employees to stop paying out in cash, what would have happened in that circumstance?
Okay, people do not come to like play, and business will be down.
Is the payment of cash prizes common in the COAM business?
Yes.
What do you recall about this meeting with Mr. Khan on January 3rd, 2024?
January.
What do you recall about this meeting that they're talking about that you had with Mr. Khan in January?
This last time or?
Yeah, do you recall the meeting?
No, I did not recall. He called me and he told me we supposed to go DeKalb County to pick up the seized items with the money. There is a lot of around 34 to 60, $3,600, and that is seized by the DeKalb County Police. And DeKalb County Police request to us to pick up your stuff, seize money and items. That's it.
Let's take a look at defendant's exhibit number 6. So change notebooks. Let's go to their notebook. So in this exhibit number 6, this is the letter from defendant's counsel to you dated June 12, 2024. They're saying that you owe the defendant $338,000. Do you see that on there? Go to page 2
It's true, my bad.
of exhibit 6.
Just exhibit. Yes, sir. This
You see, so you see that section there?
Exhibit 2?
Pardon me?
Exhibit 2?
Exhibit 6 on there in their notebook. Are you in the defendant's exhibit notebook?
Yeah.
Okay, go to tab 6.
And where?
Either
Six, page 6?
May I approach, Your Honor?
My bad. My bad.
Six.
Yes.
So it shows as part of this, they're saying that you owe $5,000 for the cash due at closing. But
Yes,
if you
Your-
see exhibit 8 on the screen, have you had it on the screen? Have you had a chance to look? You've looked at this exhibit 8, of course. These are the 3 checks that they produced, right?
Yes, Your Honor.
And what is the total of these 3 checks?
36, 145,000. Oh, wait a minute. 150,000.
150,000. And that's what you were required to pay cash at closing, right?
Yes, Your Honor.
So do you agree with the defendant's assertion that you owe $5,000 from the closing?
Sorry, I
Do
didn't.
you owe $5,000 to them from the closing?
I'm not clear about that.
Okay. You were required to pay $150,000.
Yes, Your Honor.
What did these checks total?
150,000.
Okay. You were required to pay $50,000 in earnest money.
Yes, Your Honor.
How much did you pay?
200,000.
50,000.
100.
What's the total of the two? 200.
200,000.
Right on. So there was no short pay of $5,000, was
No.
there? Next, they say that you owe $80,000 in unpaid monthly fees. Do you dispute that number? Do you agree? You don't agree with that, right?
No, Your Honor.
Okay.
Objection leading.
Overruled.
Let's go to the next number, $128,292.50 for fines, fees, utility bills. Do you agree with that number?
No, I do. I do
Okay.
not agree. Your Honor.
And then they say that you owe $61,979.35 for the inventory differential. Do you agree that you owe that money?
I do not agree, Your Honor.
So why are you pursuing your claim against defendant TSTT?
Uh,
So you filed suit against TSTT. Why are you suing them?
I'm suing them because I paid the cash, check to TST,
And how much was that check?
85,000.
And you're suing to get that money back, right?
Yeah, absolutely.
Okay. Let's talk about the contracts. Why did you feel comfortable signing the contracts, even though you did not have the financial information about the business?
Okay, to be honest, that's contract. He told me that he's gonna to like transfer whole his 100%. And after 1 year, I'm gonna to like take over that business. And when my store bells closed, and I saw a little bit potential. It was risky, but there was some potential. That's why I like agreed to run the business.
Tell the jury about your relationship with Mr. Khan at that time.
We did not have any relationship. Just we like know each other. I literally, he was like a store manager. He came to offer me to buy the business. That's all.
Did you trust him?
Business is trust. That's why I had to trust. I have to trust.
And was that part of that part of the reason why you did not insist on having a lawyer?
Yes, you.
Let's go to page 39, please. This is in our notebook, so you can, this is in plaintiff's notebook. You testified earlier that, that the first deal, the 100% deal, was scuttled because you had to take over all of the liabilities for the company.
Yes, sir.
If you look at this, page 39, this text says, Muhammad Khan agrees to be personally and solely responsible for all outstanding liabilities of the company that accrued or arisen prior to the date hereof, including the SBA loan, and agrees to defend, indemnify, and hold harmless Dinesh Ray. So did that help you feel more confident and comfortable in moving forward with the deal?
No.
I mean, what was your take on this paragraph?
He told me like, whatever that's loans, his goes to on him. He's not like I'm not. Doesn't. He did not involve me in his loans. That's the difference part. Even I did not know he had a loans. He never disclosed that loans before to agreement.
Okay. And so was this different from what you had in the first deal, the 100% deal?
Yes.
Okay. Did you ever receive any kind of document from Mr. Khan that that your ownership was terminated?
No.
Okay. It's your desire to have the jury unwind this deal
Yes, Your Honor.
and to give you your money back.
Yes, Your Honor.
Thank you, Your Honor. I have nothing further.
Any recross?
Yes, sir. All right, I'm just gonna take this in the same order that your attorney took it. So now if I'm understanding correctly, you're saying that you were missing checks at the time you did your demand letter, correct?
Yes, Your Honor.
Okay, but that number that's in your demand letter is the same number in your lawsuit, right?
Yes, Your Honor.
So you were still missing the checks when you decided to sue my client?
I'm not sure, Your Honor.
And it's the same number that you put down when you were answering the interrogatory responses, right? It was 236,000. So were you still missing the checks while we were in the middle of this lawsuit?
Yes, Your Honor.
Okay. So you agree that until this trial started, the only number that my clients have been defending against, according to you, is $236,000. Before today, that's the only number you ever gave, correct?
Yes, Your Honor.
Okay. And okay, you agreed in your contract to give Mr. Khan the decision-making power, right?
I did not, Your Honor. I was like on at that point, Your Honor.
Did you not just tell your attorney a moment ago that at the end of the operating agreement, it says that Mr. Khan is the 51% owner and all decisions require 50% or more of an ownership interest.
Yeah, according to paper, yes.
Okay, so whatever decisions he made, whether you liked them or didn't like them, you agreed in a contract to give him that authority.
Yes, Your Honor. according-
Okay. And to be clear, you've already established at no time in the 21 months that you were the manager or the time between your departure as the manager and the beginning of this lawsuit, you have nothing, no letters, no text messages, emails, anything where you ever asked for any additional financial information about the Chevron, correct?
No, I already answered that questions, Your Honor. I asked multiple time, I call him, but what happened in return? Then I stopped that from that day.
You're saying you asked him orally, but after all of this time, you have nothing in writing, correct?
Yeah.
Okay. And although it's your position that at or about the time that the gaming machines were removed, that you had talks about changing what you owed or how you were going to get paid, to be clear, you didn't put anything in writing, correct?
Yes, Your Honor.
And the contract requires that if it's going to be amended, it needs to be in writing and signed by both people, correct?
Yes, Your Honor.
And you just testified to your client that it was your understanding that when you took over as manager, you suspected that the clerks were paying cash on COAM, correct?
Yes, Your Honor.
And you did it anyway, right?
Sorry,
And you let them do it anyway. You
I-
never told them to stop.
to whom?
Whoever works for you. You just said that you were worried that if you told them to stop, you wouldn't make as much money, right?
Yes, sir.
Okay.
Yes, Your Honor.
So you let them do it anyway.
Yeah, they were doing like, they were doing before too, and same things, just I continue. That's all.
Got it. Now, when your attorney asked you about this January 3rd meeting, now you're saying that you remember what you talked about, right? You
Yes.
recall what the nature of that conversation, okay?
Yes, Your Honor.
All right. Well, knowing that you remember that part, do you remember the part where you acknowledged that money was still owed to Mr. Khan?
No, I
You don't remember
sir.
that part? Okay. Go to the, please, the plaintiff's notebook. Exhibit 9. Go to item number. Item 9.
Exhibit 9,
Exhibit 9, item 9.
item number.
This no. Now, your attorney just asked you to confirm that you paid $200,000 at closing, right?
Yes, Your Honor.
How much did you say in your answer that you paid at closing? Look at the bottom.
150. Wait a minute.
The bottom of the response
Response.
says 196,000, right?
Yes, Your Honor.
Okay, so when you answered these interrogatories, you said you paid $196,000 at the closing, not 200, correct? That's what this says, right?
Yes, it's said.
Okay.
Your Honor.
And the letter that I wrote in response to your demand letter, we're claiming that you paid 195. Remember that?
Okay, Your Honor. Let me clear. Can you clear?
And then you can explain.
Yes, Your Honor.
Okay, so
Your Honor, please let the witness explain his answer.
He's about to.
Okay.
You can continue.
okay, so the answer was yes, correct?
Yes,
All
Your
right,
Honor.
go ahead and explain.
Okay, what happened? That's 196. Okay, that's the according to like I have to pay. That's goodwill, but there is some money I already paid him with that account. Like I don't know in my mind clear. Maybe gas or some like EFT. He wants at same time. That's condition I make him like pay more than like 196.
All I'm saying is your attorney showed you
All right, let's move on.
Purchase
We
agreement
went over this
says
in the cross.
200,000.
We went over this
All right.
now. Let's go on.
Now, your attorney ended his examination of you by noting that there is a guarantee by Mr. Khan for all debts and liabilities that arose before you became a 49% owner of the Chevron, right? But you're not claiming that there's any money that you paid that was his responsibility because it was a debt that was incurred before you were the manager, right?
I did not get you, Your Honor.
Well-
My bad.
You've never claimed that there's money that you paid for that Mr. Khan was supposed to pay for because there was a debt that you paid that already existed before you were the manager, right? You've never claimed that.
Yes, Your Honor.
Okay. Thank you, Judge.
All right, Mr. Ray, we can sit down.
Nothing further, Your Honor. Yes, please, come on. Mr. Ray, you're free to step down.
All right,
Leave the
any
notebooks
further
on.
evidence on behalf of the plaintiff?
Yes, Your Honor, would like to recall Mr. Khan to the witness stand. Pursuant to Rule 612, we want to tender these tax returns.
All right, can the parties confirm whether that's actually necessary?
Can I approach?
Sure.
We're going to mark these, Your Honors, and exhibit 26.
All right, any objection to plaintiff's 26?
No.
All right, plaintiff's 26 is amended. While she's marking that, anything further on behalf of the plaintiff?
Yes, Your Honor. I'm sorry, can we approach real quick?
Go back up on the stand. That's fine.
All right, anything further on behalf of the plaintiff?
Nothing further on behalf of the plaintiff rests, Your Honor.
All right, so members of the jury, at this time, I have to excuse you. There's something we have to take up outside your presence. Probably last at least 20 to 30 minutes. Based on where we are right now, I do think, well, I can almost guarantee that we are not going to be able to conclude today. So we will be coming back tomorrow. If anyone has any kind of scheduling conflict, you can bring that to my attention. But I believe we would be on track potentially to begin closings in the morning. So with that, if you could step back to the jury room, we'll be back with you when we can.
The conversion. Nice, right, but that's what I'll say. It's this. No, so. It is.
We do the conference before I
In this case.
Direct to work, no, do conference after we close.
say that if he's gonna give us a directive to the board, he can say, maybe we won't be done today.
All right.
True.
Let's
see.
Yes, Your Honor, I'd like to make a motion to amend the complaint to conform to the evidence pursuant to OCGA 91115B.
9/11/15.
Yes, Your Honor. So I think the evidence has shown that, of course, there's a matter with the checks, the amount that is due. You know, when we started the case, we thought the amount due was $236,000. In discovery, we gained those two extra checks, which was $95,000. So we would need to true up the complaint because it does say throughout the complaint, 236,000 when it should be 331,000. Second of all, I think that there is some additional amendments that we need to make regarding the breach of contract claim and the fraud claim, based on the evidence that has been presented. With the court's approval, I can get that ready and filed within the next 24 hours. So that's what I would ask.
So, I mean, my initial reaction would be, I wasn't planning to give the pleadings to
Okay,
the jury.
so therefore it's not urgent. Pardon me?
Is there any point in amending?
Well, because the defense made such a big deal out of it, I think it perfects the record of the case.
Well, there's, I mean, no matter what the complainer, the interrogatory said, well, the complaint aside, the interrogatories, I mean, they're introduced. Except the evidentiary weight for prior consistent statements, sure, you do it what we will, but the complaint itself, they're not gonna get a copy, you can ask for whatever you want, you got your claims in.
Okay, Your Honor.
I haven't been presented with this before. It says there's some other reason, jury's not gonna see or.
Right.
refer to this complaint again.
Well, I guess I feel like my client got really beaten up on the witness stand regarding what the complaint says. And then, so my position was, well, you know, let's fix the record. And so if the court feels like that's not necessary because it's not going back to the jury, I'm okay with that.
Well, I mean, I guess nothing would stop you from arguing.
Whatever. But we need we need to leave the court to do so, you know?
Yeah, I'm just saying, you can say that a complaint is what kicks things off, and procedurally, it's how you initiate a lawsuit, and you can argue why that shouldn't have evidentiary weight as impeachment, but I imagine there's other. I'd have to look at this, but I don't know if I can even approve this now that the pretrial order's been signed, so let me first get some input from the defendants here.
Well, the first order of business was the pretrial order's already been signed. Number two, as you already said, it's not going back there. And number three, I mean, if they want to ask for $500,000 tomorrow or today, it's fine with me, but I mean, we have every right in our closing to say, well, if these checks were missing when you wrote your demand letter, that means that they were missing during your complaint. They were missing when you did your interrogatory responses. And frankly, Judge, apparently they were missing when they entered the PTO. So, you know, they can ask for whatever they want, but I don't understand the purpose of ever being able to go back now and amending an actual pleading from over a year ago. I mean, I've only been defending the same lawsuit for over a year. I understand that now we're having to keep our head on a swivel and address with the jury this higher amount that's being sought, but I've never been defending a lawsuit for a different number.
And I'm trying to read -11-15 line here, because this says that evidence is objected to a trial on the ground of some of the issues being on the pleadings. Then the court can allow the pleadings to be amended. And, you know, I'm not really seeing that the issue here is that certain evidence isn't coming in because the complaint that raised, everything's coming in and this gets raised.
Right.
So at this point, I'm not seeing the grounds or need or something.
Okay, thank you, Your Honor.
Start from there and then you can continue.
Your Honor, I know that requests to charge were due when trial started, but I want to let you know I forwarded some new non-pattern requests to charge to Ms. Sue. And based on the evidence as it's been coming in, so I'd ask the court to consider that as well. I know we're not at a charge conference yet, but I wanted the court to be aware that I've submitted those because I think it more conforms to the evidence in this case.
We'll take that.
Thank you, Judge.
You want me, do you want me to withhold, just hit the pause button on
I
that?
think all of those relate, as I've looked at them briefly, to fraud claim and conversion claim.
You're correct.
Those are still there, come charge conference, then we can address.
Okay.
All right. What else? On behalf of the plaintiff.
Nothing else on behalf of the plaintiff.
All right, defendants.
All right, Judge, we want to make a directed verdict across the board for all three substantive claims and all three defendants.
Let me just, I'll go ahead and jump right in. I can't help myself. Let me just see if I can narrow the issues at all. Is there anything that the plaintiff from the outset, based on the evidence has been presented, concedes or is withdrawing?
No, sir.
All right, have at it.
Okay, so in no particular order, not in order of importance, okay? Number one, TSTT. So TSTT, it's clear they're not a party to any contract that has been breached. So the breach of contract, count one as to TST should be gone.
I mean, there's a lot to I'm just gonna have to do this to go back and forth and rule as we go. Just so breach of contract, there's no privity. How can you sue TSTT?
You're right. Your Honor, the only reason we brought TSTT in is because they got the money.
Then why not concede the issue? But
I'll
anyway,
concede the issue.
directed verdict is granted on as to that, and that would follow the fraud claim as well. What about conversion?
It's actually in the jury charge that we gave you, but there is no conversion on cash unless the cash is set in a segregated account for some other purpose at a later time. It's considered non-unique intangible property. There's no such thing as conversion on cash. It doesn't meet one of the exceptions.
Well, and so I looked at that case, and then I found this case before they gave me these supplemental charges, but they cite to Decatur Auto Center, I believe, and then there's another one that I'd found, Quincor Construction from 2015, 333 Georgia Appeals 510.
What was that site again?
333 Georgia Appeals 510, which comes out and in defining the element says, under Georgia law, both cash and checks may be the subject of a conversion claim. And they don't really square that with your Taylor case. Maybe you can.
Yeah, no, that's actually the starting point for all conversion, that it can be, but it's got to meet the exception.
Okay.
So, yeah, so,
So Decatur was about a specific check, and his argument is that we're talking about specific checks here.
right. And that's fine. There is a possibility that any of this money could have qualified for conversion, but it's going to have to meet this exception. So tangible personality or specific intangible property may be the subject for an action of conversion, but as fungible intangible personal property, money generally is not subject to civil action for trover with an election for damages for its conversion, internal sites. While money constitutes personal property, money is intangible personality that is fungible because it belongs to a class of property which cannot be differentiated by specific identification unless there has been created a specific fund that has been set aside from other money. Thus, there can be no conversion action for money damages for money because generally money is not subject to a civil action for conversion. There exists an exception for the conversion of money. Such money must comprise a specific, separate, identifiable fund to support an action for conversion. And that's why I specifically asked the plaintiff if that money was ever being set aside for anything in the future, or if it was just money that was eventually deposited by the defendants. And he answered it was the latter.
And to the Decatur case, that appears to be based on like a specific check where a bank held onto that check and did some things with it, and it was in one account by itself identified. The other one I cited to you, the Quincor case, was interesting. It was like a civil forfeiture where they seized a pot of money, and they said they did that without authority under the search warrant. So unless there's some other, maybe plaintiff has found some other cases that are talking more generally, but how would you respond to this separate and identifiable
Fun.
requirement?
But from the case that we cited, it was very clear that checks are considered or can be used in a conversion case. And I don't believe that court said anything having to be a check going to another specific and identifiable fund. I think the case is pretty clear that you can convert and therefore bring a claim for conversion for checks.
Again, I agree with that.
This
You
was
can.
this was Saks Management you're citing, and let me let him finish before I'm going to bounce back and
That's
forth, but
fine.
let's
Yeah.
try not to interrupt each other. So Mr. Collins, if you want to keep running on that while I look at Saks, unless you have anything
Pull that
else.
up. So in this case, I'm reading under subsection D, conversion, it says in its complaint and amended complaint, Sachs alleged the defendants are liable for conversion of payments it made to some general contractor pursuant to the contract. Money may be the subject of a conversion claim as long as the alleged converted money is specific and identifiable.
But this is not a good case for you. It goes the other way. And then you go down, moreover, something I was going to bring up with the paragraph starting with moreover. They say that conversion has to be separate from the contract claim.
But remember, Judge, this is separate because the contract is with Mr. Khan and Nahar. This is not with TSTT. This is all about TSTT, who got the money. So I would say that that would answer your concerns about this case, wouldn't you think?
Maybe.
At
All
the
right.
least, it's a question of fact for the jury. It certainly would not be subject to a directed verdict. Let the jury decide. That's what they're here for, Judge.
Just trying to jump out of your seat over here.
Yeah. It's not a question for the jury because you have a qualifier. And plaintiff had an opportunity, if, assuming he's going to tell the truth, the plaintiff had the opportunity to answer that whether or not it was going to be set in some sort of identifiable account set aside. So that way that money doesn't blend in with all of the other US dollar currency on earth. And so without that exception, there is no conversion. I understand checks could be the subject of conversion. It's just got to meet that exception.
Well, so the other thing I'd point out is, I guess, Mr. Collins, your argument is that, well, TSTT wasn't part of the agreement, so that part about conversion having to be separate from a breach of contract duty means that that aspect of law doesn't apply. So by that, are we almost conceding then that Mr. Khan and our investments are part of the contract? So that's going to kick the conversion claim against them? Because that'd be a very odd outcome here if we only have a conversion claim against TSTT.
No, I'm just saying that that's the grounds for the conversion claim for TSTT.
Right.
But I think Nahar and Mr. Khan are clear conversion claims because he took the checks, he took the money and used it for his own use and did not give any value to Mr. Ray.
Can I?
All right. Well, I mean, the elements of conversion are laid out, and they talk about it requiring an unauthorized assumption or exercise of the right of ownership over personal property to another. And you've got this line of case law highlighted in Sachs talking about it has to be something outside of just a mere breach. You can't turn a breach of contract claim into a tort just by labeling it something else. And I'll take a closer look at Sachs and everything that flows from it tonight. But frankly, my indication, having looked through these today and knowing this issue was coming, is that I think as a matter of law, as Sachs was an issue of summary judgment, that I think all the conversion claims do get kicked based on the evidence presented. So if you want to provide additional informal briefing over email tonight, I'll look at it. But otherwise, I would anticipate that is going to be, that I'll be granting that motion for directed verdict as to all 3 conversion counts. Returning to the defendant's motions.
All right. So just to be clear, it's because of the lack of separate account, conversions out for Nahar and Mr. Khan and TSTT, correct?
That's right.
And then for TSTT, no privity of contract, so that's out. And then the fraud is out.
We're getting to the fraud. I don't think
for
you've made-
TSTT.
Well, fraud didn't. Yeah, there were no
Okay.
misrepresentations alleged to have been made by TSTT. So I think,
Okay.
again, there's a complete lack of evidence. So I think at this point, TSTT is out of the lawsuit entirely.
Now, for fraud, as I said yesterday at our conference, got to make an election. Now, I appreciate the gentleman's candor. I'm glad he was very precise and he made his election. He wants to rescind. He wants to unwind. I apologize. I know you're getting frustrated. I just wanted to make sure that.
Me? I'm not. No, I'm not.
No, I just know that I probably made him go there 10, 12 times just to make sure that it was clear that he elected what he elected.
I mean, look, I think there's a distinction to be made here. His testimony is that as a matter of damages, he would love to get all his money back. I think the question you're making is a matter of law as whether he was required to elect his remedies. And we touched on this yesterday. I've looked at the case law. it does appear to me that if this is a fraud in the inducement claim, that you can't have it both ways. And as the statute says, they have to make a prompt election of remedies. And there's a, I'll just go ahead and include the site for one case that was pretty definitive on this, which was that even at the time of complaint, that can be too late to make that election. That was Liberty versus Storage Trust Properties, 267 Georgia Appeals 905. We don't have that election in the complaint. We actually have a definitive, the opposite. There's an affirmation. We affirm the complaint. And even before that, we have the demand letter saying we're essentially pursuing under I don't see a rejection of the contract in the demand letter either. So I would say that one, I've not seen the election of remedies here at the earliest, not the earliest stage, but promptly, which I think that alone would stick the plaintiff with a breach of contract claim. And then the alternative, I still am quite unsure of what the misrepresentation here is based on Mr. Ray's testimony. I think he was quite affirmative in saying, you know, he received some general assurances of, just trust me, it's going to be fine. But that's not going to rise to the level of an actionable misrepresentation. And so I'll allow the plaintiff to respond here, but I can't put my finger on any specific instance of fraud that rises to a triable issue as a matter of law.
But Your Honor, our position would be that there was a duty to disclose the fact that the company wasn't making any money. And so that would be the fraud in the inducement. But we also said there was fraud after the fact because of you know, the failure to do what Mr. Khan promised to do. And that was to, you know, give 49% of the business, give him a share of the profits, give him a share of the losses, give him cash distributions. And then, of course, he insisted that Mr. Ray agreed to pay $10,000 a month that the company didn't have, that they could not generate.
Where does this duty to disclose arise? It's not in the contract.
Right, it's not in the contract.
And so where does that come from?
I think it's just a good faith and fair dealing, Judge.
All right.
I mean, I think I would put that as a requirement for every kind of contractual relationship.
Any case law you can point me to that would create that?
So I, you know, I think that's really more about contracts, the breach of contract claim. So I would say, Your Honor, that I don't have case law for you, but I would love to be given a chance to brief that overnight.
All right. And defendants want to make their record as well.
Yes. So number one, I'm glad we have a consensus here that clearly he wants rescission. He's announced it clearly for the first time at trial. Number one, that is too late, like you said. And number two, we hammered home a dozen times that there were no representations made from any of the defendants about the company, that he relied on his expertise and experience in the gas station industry. So you can't have, there's literally no lies, there's no fraudulent misdeeds prior to February 11th, 2022. And even if somehow he thinks that there was one before he signed, which he obviously stated 1,000 times that there wasn't, you've got the timely election problem. So frankly, fraud in the inducement is out for everybody. And to be hyper technical, if fraud in the inducement is out, then just to preserve the record, I believe conversion is separately out because there's no tortious act to attach the conversion to. If that makes sense. So if there was no tort, right, then there wouldn't be conversion. There would only be breach of contract.
Well, I mean, I guess conversion could be a separate tort. Would be the.
Okay, so to be clear, it's your understanding. Okay, so.
I think that's just a separate claim and cause of action altogether.
All right, so we're not taking out conversion for that separate independent ground. I understand that.
Unless you can, I mean, if you got something to point me to, then you can preserve it. But otherwise,
That's fine. So that's the last I'll say about fraud in the inducement. Other than given the way count 2 is articulated, as well as the way count 2, I'm sorry, in the complaint, and given the way count 2 is articulated in the PTO, I don't believe that they have established a separate type of fraud, meaning any fraud that happened after February 11th, 2022. In other words, to the extent that there's a fraud claim, as I said yesterday, as I said even in my opening, the only type of fraud that can be deduced from the complaint and from the PTO is fraud in the inducement. It isn't as though they have count 2 fraud in the inducement, count 3 fraud post February 11th, 2022. So for those grounds, I don't think that they can even have a fraud generally. And then we do have good case law on the following point. If the fraud you're talking about is post signing the contract, okay? And that contract has a mergers clause. You can't have fraud post signing of the contract. You can only rely on the terms of the contract itself. So if I was bullet pointing this, I would say we've already established why there's no fraud in the inducement. For them to continue to try to have a fraud claim in general, again, the way I'm compartmentalizing it, post February 11, 2022, they've never articulated that as a claim in their complaint or in the PTO. And even if they did, bullet point 3, the case law is clear. If those contracts have mergers clauses in them, there is no actionable regular run-of-the-mill fraud. So to me, for all of those grounds, there can't be a fraud. And then when you're done with this analysis, I'll discuss the breach of contract.
All right. So to be clear and to divide it up, we've got fraud and inducement, which is everything before the contract. I think you've got what they refer to as inceptive fraud, which is fraud at the time you're making the contract. And then you've got after the contract. And so I think the defendant has preserved all his alternative grounds, but based on the evidence presented, I have not heard any evidence of fraud leading up to the contract. I've not heard it articulated that there was something within the contract at the time it was executed that it was done without the present intent to perform. And after the contract, the things that I'm hearing about, the 49% or how the business was run and all those things, those could be breach. But again, I'm not hearing that coming in the form of a fraudulent statement or misrepresentation. I think also the impact of the merger clause certainly impacts the before and after analysis. And so essentially, as I've indicated, I'm also inclined to strike the fraud claim in its entirety against the remaining 2 defendants. And so plaintiff is asked to follow up on that. I'll allow that opportunity.
Thank you, Judge.
And we move on to breach of contract. To that end, I know you may have issues with well, let me go ahead and you can start.
Sure. So as the court is aware, and it's ironic that Mr. Collins had brought up the duty of good faith and implied duty of good faith and fair dealing. As the court is aware, there can't be a breach of contract for what the contract expressly provides a party is able to do, right? So the only allegations, and I went through them very carefully in his count 1, was that number 1, they breached the contract by unlawfully terminating the employment.
All right.
Okay.
They had the ability to do that if he defaulted, but you had to provide notice. What evidence was there that you provided sufficient notice?
Well, he acknowledged multiple times that they had conversations that he wasn't paying the bills and that finally it came to a halt on
Was-
November 11th.
Was there any evidence that that
2023.
was formal notice? You're on notice. If you don't pay me, you're out of here.
Well, I would just say, I can double check. The notice in that provision is not capital N notice, it's lowercase notice. I'll double check that.
Let's
And
do that.
Forgive me if I'm wrong, but I
Do that,
believe it's
because it said-
lowercase.
I think it said notice for the purposes of this entire agreement. And not only, it's not as explicit whether it can be orally or in writing, but I think if we go down that road, when it's talking about delivered to the following addresses, I think I would interpret that as saying it does have to be in writing because it's very odd and
It is.
to live oral notice in by address, but
So going with the operating agreement first, section 14.4. Notice is in fact not the capital N notice. It's lowercase. Upon receipt of notice from Muhammad T. Khan.
all right. I'm looking at plaintiff's binder.
Oh, I'm sorry, here, Judge.
Just refer to me. I know we've got the.
Yeah.
Well, I'll just start here because I got it highlighted. Look at the purchase agreement
Okay, one moment.
and in paragraph, F of the purchase agreement, that's where we're talking about the right to shorten the management period,
That's
Upon-
one time.
receipt of notice. And paragraph 13 talks about notice and how that's affected. So under the purchase agreement,
Yep, so going in your order,
yeah,
the purchase agreement first. 18F. Upon receipt of notice, notice is not capital N notice. And
why does that matter?
Well, because unless notice is defined somewhere that says it has to be in writing and
Paragraph 13.
right, if it was capital N notice in 18F, then we would know that they're talking about the way notice was defined.
It's
Same-
lowercase in the sentence. Maybe it's capital the title, but then if capital letters are going to make the difference, it says for the purposes of such notice, lowercase.
Well, it also says it will be deemed effectuated when delivered personally. Doesn't have to say delivered personally in writing.
Okay, so now we get to whether it's oral or in writing.
Right, so it just says delivered personally, and he did confirm when I asked him, were some of these conversations about the fact that his $5,000 bills weren't being paid, that other utility bills wasn't being paid, and he answered in the affirmative. And then obviously it eventually came to a halt on November 11, 2023, but this says it's effectuated when delivered personally. It doesn't say in writing, and then the same attachment would go to section 14.4 in the operating agreement.
But Your Honor, there's no evidence of this notice, alleged notice.
He admitted it.
He admitted they had
We're not going to
conversations.
interrupt each other. Let me give Mr.
He
Collins a
admitted they
chance.
had conversations. Nowhere did he admit that he had notice of default or notice of breach or notice that he had done something wrong. They were dealing with a really difficult time for the business.
Judge, I would vehemently disagree. I believe that if we pulled up that portion of the transcript, it is going to, my question was, at least to a degree, was part of these.
All right, I think I've got something here that I think might answer this or cut to the chase here. 18D, repossession of the business or business premises fails to cure within 30 days after delivery of notice.
Or
You may say that there were oral conversations received.
purchase? Is it purchase or operating,
This
Judge?
is the purchase agreement. And let's say that let's assume that oral notice is good. 2, let's assume that these conversations were sufficient to constitute notice. Does not D then impose a 30-day requirement to give him an option to cure?
No. That is if we try to take possession based on non-payment of the purchase price. Are you on plaintiff's exhibit 7? Page
No, just
7?
one. I'm still in the same document, the actual purchase and sale
Yeah, so,
agreement.
right, so.
18D.
Right, so nobody repossessed the business based on failure to pay the loan documents. You see what I'm saying? This is only if we were saying you didn't pay the full purchase price, and because of that, that's the grounds of why we're kicking you out.
Your Honor,
It
we
doesn't
would-
apply for the management portions of either the purchase agreement or the operating agreement.
Yeah,
All right,
I
Mr.
would,
Collins.
I would disagree with that because it says, anything within the loan documents, which would include paying the light bill, you know? I mean, that would include every kind of possible breach has to be provided with notice and a chance to cure. And the loan documents is a defined term that includes all these agreements.
Well, let me put this to you, Mr. Collins.
Sure.
Do you believe that there was a time period that the notice had to be provided to remove him from management? And if so, what's that time period and where do you find that?
Well, I would say the time period is 30 days. That's a 30-day notice. I mean, this is all about repossession of the business. So in that November date, when Mr. Khan fired Mr. Ray unceremoniously in front of employees and the public, he should have said, I'm not going to fire you. I'm giving you official notice. You're in breach. You got 30 days to fix it. That's not what happened.
May I respond?
Sure.
Number one, the purchase agreement says there's going to be material terms in the operating agreement. And it talks about the management portion of that operating agreement, right? And within that, as we went over ad nauseum, there is no time period for removing him as manager. It just says if he fails to fulfill those obligations. Number two, in the operating agreement itself, the management section that I'm talking about is under the special stipulations that say, to the extent that this language contradicts any other language, this provision shall apply. And there is no time limit on removing him as a manager.
Can you show me that?
Sure. So so first, to be thorough, in the purchase agreement, so defendants exhibit 1, we get to section 18 that you had shown me, 18F, right? It says that the operating agreement shall, among other in terms and conditions, include the following, shall include those material terms, right?
This is 18A.
18F, page 8 of the purchase.
Okay.
So they're saying we're gonna have an operating agreement too, and when we do, these are the terms that shall be there. And in subsection 3, one of those terms is, if you don't take care of your contractual obligations, we get to kick you out as manager. Then in the operating agreement, if you go to section 14, special stipulations. So this is page 11 of the operating agreement. To the extent that any of the following special stipulations is in conflict with any other terms or conditions, the following special stipulations shall control. And once again, when you get to section 14.4, you have that copy and paste from the purchase agreement. No time limit. If he does not fulfill, we can shorten the management period. And now we're back to square one on notice. Notice can be oral.
All right. What about the fact that your client said he did not fire him?
Well,
Why don't we believe your
He-
client, or the jury could believe your client?
because we are stipulating that he was removed as a manager. And quite frankly, he thinks fire means he's not a manager and he's not an owner. But
Well, I mean, that's not evidence I think we can consider here, but
the contract speaks for itself. It's the controlling document. It says special stipulations, and he acknowledged if he doesn't, I mean, look, forget about paying bills. He let the COAMs run illegally, and it says right there, one of the things you can't do is break the law. And if you break the law, we can shorten your management period.
all right, Mr. Collins,
Yes, Your Honor.
do you want to respond to any of that? There's a
Okay,
lot he said.
yeah, I mean, I think to say that there's no notice requirement is ridiculous.
There is a notice requirement.
There
The
is a
question
notice
of what
requirement.
comes along
And
with it.
there is absolutely no notice. There's no evidence at all of any notice. I think the court is right. Mr. Khan testified, not that he's 100% believable, at least in our opinion, but he testified he didn't fire Mr. Ray. Mr. Ray testified he never got any notice. Well, if Mr. Ray was never fired and he never got any notice, then clearly there cannot be cannot be a termination, cannot be a notice as required in the agreement.
All right, well, I'm gonna,
It's a jury question.
yeah,
Judge.
I'm gonna leave that as a jury question, whether sufficient notice was received based on the testimony that's been received so far. What other motions?
One moment. Excuse me, Judge, just one moment.
She filed that, didn't she get a poverty affidavit to file this lawsuit?
Okay, Judge, I'm just was having a little trouble trying to articulate this last point. If the contract was breached in the manner that you think potentially the jury could find, then the contract was breached by N-Har LLC, not Mr. Khan in his individual capacity. He wasn't acting as an individual.
Yeah.
He's acting on behalf of the corporation. And so
All
the
right.
breach of contract should only attach to the corporate entity.
So let's go from there. How do you pierce the corporate veil in this case, Mr. Collins?
Well, Your Honor, I mean, I would think that this is signed, it says seller Muhammad Khan. Remember, Judge, Muhammad Khan is selling his ownership shares in the company. And so this is a contract, for 49% interest in N-Har Investments, whereas Muhammad Khan currently owns 100%. So Mr. Khan is the one who is conveying the ownership shares, which is why some payments went to Mr. Khan and some went to N-Har. I think that's an easy question to
Yeah, I
answer,
mean,
Judge.
yeah, he signs the agreement as he's the seller.
Thank you, Judge.
I mean, but you can continue if you have something else.
So, okay, so two things. Going back to the complaint, the first enumerated allegation says, and this is what we just addressed. The defendants breached the contract because they wrongfully terminated me, right? Okay, we just went through that. And I understand why that's how the LLC could have breached a contract. But Mr. Khan individually isn't breaching that contract. And in other words, if I'm Steve Jobs, right? I'm firing my employees on behalf of Apple. I'm not, you don't sue Steve Jobs for wrongful termination, you sue Apple for wrongful termination. So what I'm saying is the breach of contract claim, if it survives, it should only be against the LLC.
We would disagree with that, of
And-
course.
All right.
That's number one. And then number two, the second allegation of, and there's only two in the breach of contract claim, is the other way the defendants breached it is they didn't give me my 49% shares. Now, for starters, in the interrogatory response, he said he owned 49%. At this trial, he obviously thinks he owns 49% because he's asking for the deal to be rescinded because he doesn't want to own 49% anymore. He wants to be put back in the place that he was before. Pre-terminating that inconsistency, once again, it would be the corporation that committed the malfeasance if there was somehow this, I didn't get a stock certificate. Mr. Khan in his individual capacity isn't breaching that contract. So once, and those are the only two principal allegations in count one breach of contract in the complaint. So once again, I mean, unless, like you said, unless there's some sort of piercing the corporate veil, I mean, both of those misdeeds, even if taken as true, are in the hands of the corporate entity.
Your Honor, we would say that there is all kinds of evidence presented to the jury, shows about misdeeds from Mr. Khan and Indahar. And so this is certainly not given the 49% is an important part of it, but there's also the firing of Mr. Khan. I mean, of Mr. Ray, that was clearly done by Mr. Khan, not in his capacity as the, an innocent employee of the company, because he's not an employee of the company. He's a shareholder. He's a shareholder who has 51% ownership interest. I don't think that, I don't think you can separate Mr. Khan from the company. And certainly, we do piercing the corporate veil on a regular basis, and I think the statute is broad. If you want us to pull up what the statute says, I'll be happy to do so. I don't think you have to get to that point, Judge. I think he signed the contract. He's in the contract. I think they're both in the contract, and I think we got a breach of contract claim.
All right, well, I'll just leave it at this. The verdict form will delineate between the two. I'm going to defer ruling on this. And so it'll be very clear the jury's decision of who they think is liable. And as a matter of law, if I need to revisit that, I will.
Okay.
He brings up the point, though, that as a theory of the 49% shares, why do we suggest, or so you still contend that that is a breach, that he does not own 49% of the company?
Yes, Your Honor, we contend that he was never given 49% ownership share of the company.
What did that have to look like?
I think that could look like a number of things. I think it could look like a share certificate. It could look like a filing with the Secretary of State's office. More importantly, though, it could look like him getting a share of the profits and losses. The whole reason why I wanted to get these tax returns into evidence is because each one of those returns has a K1, and that K1 is solely for Mr. Khan. Mr. Ray never got any benefit from being an owner. He never got any money for when it was profitable, and he never got any losses for when it wasn't profitable.
Okay.
Does he want us to amend our complaint and say he owes more money? Because the only evidence on the record is that right now we're at a negative $6,000 between the 3 years. So if he wants a K1, I mean, I don't understand. Look, having something that shows he's a 49% owner is pretty clear. He's got a purchase agreement that says he owns 49%. He's got an operating agreement that says he owns 49%. If he really wants to share in, my client testified he doesn't have a stock certificate for himself. I mean, I own shares in other stocks that I don't have a stock certificate for. I'm in the market. I mean, I don't understand that at all. And of course he owns 49%. His interrogatory response said he owned 49%. And there's no such thing as rescission. There's nothing to unwind unless he's unwinding 49%.
Well, I think we addressed this already. As my understanding, interrogatories can be used for impeachment, shown as a prior and consistent statement, but they're not deemed a stipulation or an admission as a matter of law. So to that end, I think I have to construe all inferences in favor of the non-movement and his current ownership, and whether that purchase agreement actually conveyed the interest remains an issue of fact for the jury to determine.
Thank you, Judge.
All right.
We're good.
Of course.
All right. So unless you reverse course on fraud, then just for the record, then we want to be clear, punitive damages is out.
That's right. That's ancillary.
All right. Again, this making sure I can explain this. If there's no fraud, how could there be bad faith under 13611 to recover legal fees? I mean, what's the lies that we told that we didn't honor to do something in bad
Well,
faith?
don't interrupt him, but we'll give you a moment.
Thank you, Judge.
Okay, so directed verdict on the 13611 claim. and it doesn't require a lie. Someone can just be stubborn, or whether they just. I mean, there's a wide variety of conduct that can be covered by it, and I think the case law does generally allow a lot of leeway in order to make that a jury question. So it's preserved. I'll defer ruling on that.
All right, lastly, Judge, going back to breach of contract just one last time. As we know, the final element of breach of contract is damages. Now, the only damages that this gentleman is asking the jury to award is to just give him back all the money that he spent under the fraud in the inducement paradigm. Put up no evidence of any money that he was supposed to get that he didn't get.
What was
And-
let me ask this. Let's say he was terminated early under the agreement. So he was owed another 3 months of being manager at a minimum. Was there evidence presented to show what benefit you get from being a manager? What damages flow from not being a manager? I mean, I know he worked as an employee. He got paid for that. But was he getting paid separately to be a manager? Why do you want to be a manager? Someone give me
Well,
some
very-
context here.
Very simple, because obviously this gentleman thought he could make so much money off of gaming that it was worth him to say, I'm going to spend X amount of dollars to be a 49% owner of this company. For now, I'm going to pay this gentleman $5,000 a month on top of that, and I'm going to be responsible for all the bills. Because all the money that's in the till after that doesn't belong to Mr. Khan, it's all mine. And that's why he wanted to do it. And that's why, even in the complaint, they made a huge deal out of the fact that, woe is me, I lost my COAM license for paying illegal cash, and now I'm stuck. I'm up creek. So that's why he would want to be a manager, and he screwed up and he made a bad investment. Well, I'd hate to be the last guy that
All
had a
right,
horse and
got
buggy
it.
shop.
Mr. Collins.
Well, can I on the damages?
Okay, you got something else? Sure.
Yep. In fact, not only did he say he has no evidence to dispute the net losses that we presented, and if we're operating at a net loss, there's no 49% distributions to give to him, right? He also established that contractually, he's not even entitled to get any regular wages. That was over and above what the contract required. He's only supposed to get net profits. And he said that when he was a manager, there was no net profit. So really quick, if there's no profits when he was the manager for those 21 months, and he's not required to get any wages outside of that, and after the management period is over, he's only required to get 49% net profit distributions, and there are no net profit distributions, then there's no money to be he owns 49% of a negative number. And on top of that, he admitted that at least some of the money that is owed under the contract to Mr. Khan remains unpaid. He's at a negative number. Show me where the evidence was, other than just saying I want all my money back, where if you took that out of the analysis, there's money coming his way where he proved that, or he made a prima facie case that even goes above and beyond the indebtedness that he has to the defendants.
What about nominal damages? Well, doesn't that still keep his claim alive? There will be one.
Yeah, there's a recent Supreme Court case that just addressed this.
Sure is.
It's a trivial sum, I think, is basically what.
But it still keeps the claim alive.
As long as their charge on the compensable damages wouldn't be given to the jury, then it would only be
Right.
It only be nominal.
In other words, yeah, go ahead, Tim.
I think I said it all.
They're subbed in. So your position is even if he's obligated a nominal, his claim for actual damages, anything other than $1 or whatever it's going to be, should be struck.
The only number he's ever given is the rescission number.
All right, understood.
But Your Honor, we think that OCGA 13462 gives us the right to damages for rescission for non-performance. And that is in essence what has happened in this case.
Okay.
And even without that, I think the jury could certainly give us damages based on the testimony and evidence they've heard so far and the testimony we expect to get from Mr. Khan.
All right. Well, I'll take a look at that code section as rescission, again, as we talked about, I thought was going to be confined to a viable fraud claim. So I'll defer ruling on that, but generally speaking, I believe that that's not going to defeat a breach of contract claim altogether because it's still going to be there with nominal damages potentially in any effect. So at this point, where I would say what's left standing here after a result of this would be a verdict form with dueling breach of contract claims against Mr. Khan and Nahar Investments with accompanying 13,611 attorney's fees and vice versa. Anything further?
Yeah, just my own.
Sure.
Are you saying that you're looking into the notion of whether or not you will grant our request to limit the damages that they can seek under that breach of contract claim to nominal damages?
Unlikely. I just wanted to look at this statute because that is not one I'd laid eyes on before. Because I'm again, frankly, I would be inclined to limit argument during closing if rescission is not allowable at law, that you can't just say, give us our money back. If you want to say what the damages were under traditional expectation principles, as in our pattern charges and elsewhere, then, make those arguments. But if rescission is just not even a thing we can talk about, I don't think we should be talking about it at closing based on the rulings that I've
I
made.
think the statute gives us the right to it, so I certainly would encourage the court to
I will.
look at that. Certainly, we can, we have a couple of cases we can provide as well.
All right.
That code section again?
13,462,
One moment, Judge.
rescission for non-performance.
And there's a big caveat in that code section about, but only when both parties can be restored to the condition in which they were in before. And we don't have to argue it. I think that I'm going to take a look at the case law. We'll see if it's applicable at all. Any further motions?
Okay, I'm sorry, I'm glad. We believe that the verdict form needs to reflect the fact that he reaffirmed his interrogatory responses when he said that some money was still owed to the defendants. And as a result of that, we believe that the verdict form, we shouldn't have to prove liability on the breach of contract. We should only have to prove how much the liability was, the damages amount. I mean, he definitely,
You think he's admitted to a breach?
right, because we said you owed the 5,000 a month. We gave you credit for the 25,000. There would still be months owed, right? Yes. You admit in your interrogatory response, there was $129,000 worth of bills that we paid on your behalf. I mean,
Well, he also testified that he had an oral conversation with Mr. Khan suspending payment of those $5,000 payments, and the jury can decide whether that actually happened or not.
contract itself says it's got to be reduced to writing and there's no oral representations.
And I'll find the provision, but I believe that provision itself can be waived orally as well.
It can, but where was the evidence that he waived the waiver?
Testimony, if the jury chooses to believe it.
I agree,
But the
Judge.
objection is preserved.
You're correct, Judge. I think these are all jury questions.
That is it.
I don't believe you, but we'll charge forward nevertheless. All right, we've still got some time left that I'd like to utilize. And so let me start at the outset. Do you have any anticipation of how long your direct of your client will be?
Judge, can we have a bathroom break? before
Yes, I
we
need
go?
one too, but let me just make sure I can figure out where we're heading here.
And for the court reporter.
Judge, at this point, we only are going to provide evidence for fees and costs. That's it.
Well, I think as we talked about, I think as a matter of record, we've stipulated that. If
Okay.
y'all want to go ahead and lay out those numbers, the stipulation appears to be the reasonableness and the amount. And so just as a matter of law, if the jury checks the box saying you're entitled to them, that's going on the final judgment form.
All right, then we have nothing further.
All right, so then I'd call back in the jury and defense would rest. And plaintiff, just so we have all those amounts clear, why don't we go ahead and do the addition? And we'll come back in 5 minutes. You can put that onto the record. We'll get the jury back and excuse them for the day.
All right, thank you.
Thanks,
All right.
Judge.
Off the record.
You're not gonna love your job. You don't have to testify. You don't have to testify. Unless you're really, really.
The only thing
I
would be,
think, object is his cancel. And
wait,
take
you're
a
still on the
picture.
mic.
So basically,
Okay.
Pardon me? Led they any others? Any other cases? If you maybe send it, so you got a copy. Or did you already send that?
Yeah, I did.
Oh, that's the one I said I liked.
Yes.
So those are the only cases. Okay, so do you use Westlaw?
I do. They
I
were
don't-
the ones cited in the statute.
3.
No, there's some more,
Okay.
but there's for.
Like the Kroll case. It's not really quote worthy because they just quoted the statute, right? But you read the facts, those facts similar to yours. Now, obviously. Pardon me?
This is the background for.
Okay. That sounds pretty good to me. I think what I would say to the judge is that we want to brief this code section.
The judgment was first. Yeah.
I like it. Weird like that. Well, you put it in.
I'll show you yours if you show me mine.
What?
The numbers. that you
Oh,
want to change.
Matt.
Pardon me?
I don't know if he did the number, we didn't do the
numbers.
numbers.
The numbers.
Yeah, we're supposed to be
Updated
getting the
fee number.
updated numbers.
Oh, the fee number.
I was gonna
Okay.
just show you,
I did it.
so this is what we started at.
Uh-huh.
So 3 lawyers, or 10 hours a day, 350 an hour. I think that's your billable rate too.
Mm-hmm.
So it's 3,500 a day. Oh man, that's only for 2 lawyers.
Okay, let me get this. Since
Calculator. Oh, I got it. I'm sorry, I had it right. It was big, I should have. And lawyer 1 of me, lawyer 2, that's 7,000. Lawyer 3 is that. And got yesterday, cleared it out, people were 21,000. Starting point is 49,597.
You're
Thoughts,
gonna have-
questions, concerns? I'm not, I mean, I wasn't even gonna ask for tomorrow.
What now?
I'm not even gonna ask them for anything tomorrow.
Okay,
I'm just gonna do yesterday and today. Any issues? concerns?
so I guess the question I would have, Judge, is.
Does this need to be on the record?
Just a general question.
Okay.
I don't think it needs to be on the record. Just, in terms of the attorney's fees question, we were just discussing that. You want to give the jury just a number for each side? Do we want to give them invoices? What does the court generally like to do?
Well, look, the other, last time we had this where it was a similar thing, there's really nothing for the jury to decide except for
Check the box.
whether the elements are present justified.
Okay,
So unless you think there's some reason that they need to compare your numbers.
I don't think so.
No.
But otherwise, essentially, you're stipulating to reasonableness in the amount, so why burden them with that?
So we're gonna not even say dollar amounts, we're just gonna say, if you believe. Okay, that's fine with me. Okay.
Alright, then let's go back on the record. And the parties having previously indicated that they are stipulating to the reasonableness and the amount of either side's attorney's fees justified should an award of 13,611 be given by the jury. First, plaintiff, what is your amount of attorney's fees you're claiming in sum total as a result of this trial?
$49,597.50.
All right, that was the defense. And so, and on behalf of the plaintiffs, is that amount stipulated to?
Yes, Your Honor.
Can I get that one more time?
$49,597.50.
All right. And on behalf of the plaintiff,
$37,171.53.
and is that stipulated by the defendants?
Yes.
Okay. All right. So with that, then I believe we will, I'll call on the jury in just a moment. We'll have the plaintiffs rest on the record and then the evidence will be closed. At that point, I believe we'll just come back tomorrow morning for the charge conference. I'll have a packet ready. I might even send that to you tonight, so you can take a look, incorporating. There's some other non-pattern charges that neither party requested, but that we'd used before that you can, for your consideration. There's one in particular on bad faith, defining what bad faith is. There's one I've added as a result of the Walmart case for nominal damages. And point being is we'll let you take a look at that, hopefully to give you time to prepare for it by email. And then we would begin closing arguments tomorrow morning. And I would ask either side if you'd be willing to impose an hour time limit for each of your closings.
Yes.
Yes,
All right, both parties having agreed, we'll bring back the clocks.
we'll definitely be less than an hour, Judge.
Okay. And
Definitely swear to that. I won't have a choice to have a clock up there.
that's the idea. And at this, do we have some indication of who would open and rebut and that sort of thing?
We would normally waive opening and just do final argument.
Okay. And hearing no procedural issues to take up, then the plan would be to begin with the defense. We'll say 9:30 tomorrow morning. We'll do our charge conference at 9.
9 o'clock?
Yeah.
9 o'clock, understood.
All
Do
right.
you still want us to brief any of these?
If you'd like to, again, I'll take a look at it.
Okay.
And again, I just, if you want to show me some cases on point, it can be challenging in in the civil realm where you don't get something right in the same world, but it's right adjacent. And
Right.
so if you can find something that,
Gonna look, Judge. So I think
I
it's
hear
worth
you.
looking.
and if
Thank you.
not, we'll make law with this case. So here we are. All right. Is there anything else we need before we bring back in the jury and excuse them for the day?
No, sir.
Okay, Deputy Scott. Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, welcome back. Thank you for your patience. The plaintiff had rested before we broke, and now the defense has the opportunity to present evidence, further evidence if they so choose.
No, Judge, no further evidence.
All right, so the defense rests, and so where that leaves us now is for closing arguments. We're at an awkward time of the day where I don't think we can get those in today. So what I would ask is we'll come back at 9:30 tomorrow. We've got some things we got to work on before we can get closings ready to go. And closing arguments, I've been with the gracious assent of both parties, will last no longer than 2 hours. It could be shorter. But after that point, I charge you on the law, and then the case is yours. And so that would put us right at about 11:30 of the lunch hour. So we've arranged we're gonna bring some pizza in for if you'd like that. If you'd like to work through lunch, you can do that. It'll be there for you. If you want to break, that choice is yours as well. But we will, I think, have that here for you by 11:30. And I believe that will also come with with drinks as well. So with that, unless there are any other concerns that need to be raised, we'll see you back at 9:30. Please don't discuss the case with anyone, including amongst yourselves, and don't do any research about the case. Thank you. We'll see you tomorrow. Thank you, Deputy Scott. All right, unless there's anything else to take up, we'll be in recess until 9 o'clock tomorrow morning. We'll see you then.
Thank you, Judge.
Your Honor.